Good morning, Mr. Noakes.
Good morning. How are you this morning?
I am just fine. Have you spoke to your client?
I have not. I didn't have any contact information for him. So
Okay.
I'd love to be in a breakout room with him.
Well, he's not here. He's probably going to be in person.
Oh, okay.
Um, do you want me to chat you his phone number?
Yes, please, because I don't have it.
So how does that work? We put that all on the information when we send it to court appointed. I mean, if we're
Yeah.
wasting our time, why are we even putting anything on there?
Well, sometimes what happens is I got the information, but it was checked in by our office
Mm-hmm.
and they didn't put a phone number.
Okay.
So sometimes that occurs, very rarely, but sometimes it does happen. So if you could give me Mr. Watson's number.
I chatted it to you.
Okay, thank you.
Do you see it?
Yes, I do. I'll
Okay, so
give him a
if you
call.
can catch him, yeah, just have him sign on and have him sign on now if he's able to.
Okay, thank you very much.
You're welcome.
Testing 1, 2, 3. Can you hear me this time?
I can hear you.
So it had nothing to do with my volume. It was actually something was wrong with the microphone on my computer. We got it fixed though. So, Mr. Shear.
Sorry, Josh. I hear you. I'm just talking to the judge. I'm gonna
Oh, you're
make you
okay.
co I'm gonna make you co-host because it looks like you do have a lot going on today. So if you jump in and out with the prosecutor and grab your client, you're good to go, okay?
Thank you.
Thank you. Josh, just so you know, Douglas Shearer is already here, checked in, ready to go. Okay, I wasn't sure if you've seen him.
Mr. Shear, you should have a message to there you go.
Patricia,
Yep,
are you on both of Watson's files?
I am checking right now.
Thank you. So I know the pre-trial, I'm pretty sure you are, but I'm guessing that I'm not for sure about the felony.
Okay, it's a CSC3. It was charged by the same APA, so I'm guessing yes. But let me quadruple check. Heather, it looks like both the Watson cases are mine.
All right, thank you.
So he wants to be able to.
Michelle, I'm stepping away real quick. I'm going out to the hallway. Okay.
just zoom. Zoom it out. Zoom it out.
Mr. Noakes, did you speak to your client?
Yes, I did. And he cannot zoom in. So I'd ask permission to waive his appearance, and we're requesting a preliminary exam.
Did you want to speak to the prosecutor? And why can't he zoom in? So is he coming in person then?
No, he doesn't have the Zoom app.
Okay, he can do a dial in.
Okay, give me the dial-in number and I'll have him dial in.
Are you ready?
Yes.
Do you want me to chat it to you, or are you good for me to tell you?
No, you can just tell me.
646
Okay.
876 9923.
Okay, thank you.
And then he has to put in our ID number when it asks, the 491 number.
Okay, so just what's the ID number? 491?
1975.
Oh,
Six-
okay.
Yeah, the Zoom ID number, it'll ask him to prompt that. Because we need to get
491.
his information. We got to check him in and everything, make sure we have
Sure.
good information.
491-975-74.
6074.
All right, I'll call him and have him do that right now.
All right.
Thank you.
Hey, we are ready with the Wayne County Jail with Mr. Shup whenever the court is ready.
Thank you. And this one's going to be a weird one, but with Mr. Wasan, Crystal, he has a felony and a misdemeanor. And so Mr. Noakes is assigned to his felony. You are going to have to speak to him on his misdemeanor, and you guys are probably going to have to do something global together.
That's what I was
Same
gonna say.
victim, same everything.
We're probably just going to track the other case. So if it's set for exam, then we're just going to set the other one for a pretrial on that same day because we're going to want
Right.
to wait and see what happens on the felony.
Okay. All right. Let me let the judge know that you guys are ready.
But I guess I'll speak to him after he's spoken to his felony attorney, and I'll speak to his felony attorney. Maybe we could do like a group breakout room.
Very good. All right. Thanks.
Thank you.
Michelle, I'm going to make you host. If you can make me co-host, please. All right. Let me find you. Make host.
Good morning, Michelle.
Good morning. I can't find you now. Heather, where'd you go? Oh, there you go. There.
Oh, shoot.
Yes.
Is she coming in or zooming in?
She's on Zoom.
Oh, she's here too, you know.
Correct, yeah.
Yes. We had initially
Good morning,
tried
Ms.
to go,
Medina.
we had initially tried to go into the courtroom, Judge. We love the live action in there, but then we came back on Zoom.
Yeah, that's okay. Your appearance for Mr. Shoup?
Crystal Marie Medina, Your Honor, on behalf of Mr. Shup, I believe a number of his
And good
cases-
and
Oh,
good
sorry.
morning, Your Honor. Mohammed on behalf of the people, P86771.
Thank you. And Mr. Shoup, you can hear us all?
Yes.
Thank you. What do we got?
Your Honor, I think Mr. Shup has several cases scheduled for pretrial. Two of them are scheduled for an arraignment pretrial, Your Honor. We are prepared to waive formal reading and stand mute as to those cases, Your Honor. We would ask for an adjourned pretrial date so that we could receive and review discovery, and we would also ask to address bond, Your Honor.
Thank you. All right, so it looks like cases ending in 45 and 46 are the ones yet to be arraigned. I'll enter not guilty, please, for Mr. Shoup.
Yes.
And let's see, for pretrials, pretty much any Wednesday.
Okay, Your Honor, give me 1 second here.
So pick a Wednesday and we'll schedule all the files for the same day.
I'm trying to see, Your Honor, because I'm gonna be following this case, trying to see. Your Honor, if we could set it for the 14th, I don't want to put it too far out. If I can't be here physically, I'll have one of my colleagues cover, but I would not like to set it out past the 14th.
Yeah, February 14th, 10 o'clock.
That sounds good, Your Honor.
And that's going to be with Judge Green, so that's Zoom.
Oh, okay.
All right, let's talk bond.
Your Honor, I did have the opportunity to speak with APA Mohammed. He has spoken with, I believe, one of the complainants in these cases, I guess like a representative of the family, if you would agree. And he has a cash bond, a 10% bond on several cases. I believe his total is $3,000 at this time. He is unable to post a monetary bond. We would ask that the court consider a personal bond with a tether, Your Honor. My understanding is that there's to be no assaultive contact with the complainants. No assaultive contact with the complainants and not to return to the home address. Is that correct, APA Mohammed? If the court, of course, is in agreement, Your Honor, with what we have stipulated to.
So it would be, the people would request that this individual, if to be released, would be on a tether due to his history of failing to appear and his criminal history. We'd also request that no physical contact with any of the victims or even personal contact. The only contact the victim expressed to me is she wants to be able to communicate with her brother through the phone. So no assaultive contact and to remain on a tether if released.
Okay. The only problem with this is I'm the one that set his bond as I did because he told me he had no place to go except the address where his siblings were. And I can't give a GPS tether to a homeless guy.
And I understand that, Your Honor. I have spoken to my client today. He has indicated to me, that's why I wanted to set such a quick pretrial date, just in case he's not able to confirm an address. But in speaking with him today, he seems pretty certain that he's going to be able to reside with someone in Dearborn Heights. So he was going to make some calls. And so that's where we're at, Judge. We can revisit in 2 weeks if he's unable to provide a tether address by that time.
I'm not sure how it'll work. I suppose I could change the cash bond to a personal bond on those other files, require the GPS tether, and they're not going to let him out unless they've got an address that's been confirmed. I would assume.
That's exactly what would happen. And that's why, again, we would come back in 2 weeks. If he wasn't able to get an address, then we'll see where the cases are at that point and where the complainant's at and where everything's at.
All right. So what we'll do is I've got 1, 2, 3, 4, 5 files for Mr. Shup.
And I think
good morning, Corporal.
Good morning, Your Honor. I was just going to add that he is receiving mental health treatment here. And if he does get that personal bond with GPS tether and he has no verifiable address, he can also be put in an inpatient treatment facility for mental health.
Oh, I'd rather have that.
Yeah. As long as it's stipulated on the minimuses, Your Honor, they can work with him and put him in a treatment center.
Miss Medina, maybe you need a breakout room because I'd rather have him in treatment than out at some friends.
Well, Your Honor, my understanding is that my client would like to be, if possible, Your Honor, released from custody. But of course, that would be up to the court to decide. It would be great if that could be an alternative. So if he's not able to get an address and able to be tethered, that then he be placed in inpatient. As opposed to just sitting in the jail, but we would still ask the court to consider a personal bond with a tether, Your Honor.
And Judge, just for the record, after speaking to the victim, she did express to us that she largely wanted this individual to receive some kind of treatment. Right. So we would stipulate to anything in regards to this individual receiving treatment.
Thank you. Thank you. Mr. Shup, brother, I don't want you in jail.
Okay.
I think I made that clear to you last time I had you on video. I don't want you in jail, but I can't have you in the street.
Right.
And I want you in treatment. If the jail can put you right into treatment right now, are you willing?
Yes.
Listen to me. These problems with your siblings, you've been on a roller coaster, man.
I know, man. Since my mom died, I know.
We gotta get your head in the right spot.
All right. Your Honor.
All right, hear my heart. I think I'm doing this for you, buddy.
I think you are.
I think this is what you need.
Yes.
I mean, I could put you out in Garden City. Mr. Mohammed already gave me the okay, but I don't want that. I don't think that's what you need right now.
No, I don't.
All right. So, Corporal, let's be clear. If I put him on a personal bond on all files and require mental health treatment, that's what you need on the MIT.
That is correct, Your Honor.
All right. I'm not going to do the GPS tether. I'm going to order the no contact, but I don't want the tether to mess things up. I'm assuming, Corporal, if he's not in treatment, we're going to know it.
Yes, sir.
Okay. Are we all satisfied with that?
Yeah, I'm just confused. Deputy, does he require a tether to go into inpatient or no? It would be fine a personal with mental
Your Honor,
health.
whatever the court wants. It's just once they won't transport him to an inpatient treatment center because he's no longer on tether. He's not a tether. So he'll have to self-report. If he's on tether, we can transport and we can monitor.
Okay, so it's better to put him on the GPS tether.
Exactly.
I thought it was another impediment,
Yes,
and it's actually helping. Okay, so I'll order the GPS tether, I'll order the mental health treatment, and I'll order the no contact. So other than phone contact with your siblings, that's it, correct, Mr. Mohammed?
Yes, sir.
And remember, Mr. Shup, that all of your calls are recorded now that we're talking about phone calls, okay? All right, thank you.
Yes, I know.
Mr. Shup, good luck to you, brother. So on each one of these 5 files, I'm going to put you on a $1,000 personal bond. That's your promise that you're going to abide by those rules I just laid down.
Yes,
you're
I will.
in treatment, you're on the GPS tether, and nothing but phone contact with your siblings.
Right.
Raise your right hand. Do you swear or affirm and acknowledge the debts payable to the court in the amount of $1,000 times 5?
Yes.
Good luck to you. Corporal, thank you so much for your help.
Thank you, Your Honor. All the best to you and your staff.
Take care, Deputy.
All right, Councilman Medina. You guys have a blessed day.
Bye, you as well.
Yep. Guys to ask her to get on. Good morning. How are you? Good. How are you? Wonderful. Oh, okay.
Did we lose Mr. Noakes?
Say again?
I think we lost Mr. Noakes.
I have no idea. I haven't looked at that screen since I started scribbling.
Yeah, I think we did. I was going to talk to him, but.
Good morning. How are you? Much better than I deserve. Which file do you guys have?
Do we like or do we have?
Do you have?
Okay, we have Robert Reese, Judge.
Reese?
That is scheduled for 9:15, Your Honor. He is on his way
Okay. As in the courtroom, or he's into the court? He's not here yet.
in. He's walking, I believe, through security, Your Honor.
What are we gonna do with it?
I guess that's what we're,
You're not sure yet.
yes.
Well, I've got the file ready when you are.
All right, thank you. Sorry, I jumped the gun on that one.
No, you're all right. Father, Mr. Noakes is coming in again. Mr. Noakes is trying to, and then we've got our Galaxy phone unidentified. You got anything ready for me?
Mr. Noakes, I'm gonna put you in a breakout room with Crystal Medina because Mr. Wasan has a misdemeanor and a felony, both same
Okay.
victim.
Okay.
So she's gonna be his MIDC attorney. So I'm gonna put you guys in a breakout room. Just real quick, and then we'll get you a date. Or do you want to get the date first and then throw you in the room?
Yes, please.
All right, hold on. Patricia, did you need to speak to Mr. Noakes?
Yes.
Okay.
I can jump.
Mr. Noakes, Miss Manning
Yes.
needs to speak to you, the prosecutor, so I'm putting you guys in a breakout room before we go forward.
Okay, thank you.
I'll be right back.
Who's Crystal? I can give you a month. Okay. I felt bad. You order them. You don't go to the store. Oh, yes.
So, you know. Hi, I'm back, guys. Ms. Vandernack wanted to speak to Mr. Noakes first alone.
Crystal, did you speak to him? Were you in there with them?
Yes, so I spoke with Mr. Noakes. I think we have a game plan, but Ms. Vandernack kicked me into the main session because she wanted to speak to him alone.
Okay, all right.
All right.
Did you want to speak to Mr. Wasan?
I mean, first I'd want to confirm what they decided in their conversation that I think I would have been fine being a part of, but
You should
yeah.
have been in there with.
Yep, so
Okay.
I just wanted to say, you know, why I'm out here, and hopefully I'll find out a summary, and then we could go from there.
Okay. Josh, are you ready on Mr. Shearer?
We are. We're going to be setting up for final pretrial date though, and we're asking for a standby, so we may need Miss Mandernack. I don't know if she's been
All right.
joining for the.
Then we'll wait for the judge as well then.
They have the standby on there, issued on my thing for a one-time pickup of stuff too, on my court
We're
release.
just going to amend it to indicate that a third party can execute it. That way, we're just going to keep you
Okay.
clear from it. Mostly just doing it to not waste whoever your third party's time is when they go up to here on Township Police.
Yep. They said to call, meet them at the cemetery down the street.
What date are you looking for, Josh?
I got it.
It's every Wednesday. What date are you looking for?
It's going to be on a Wednesday, you said?
Yep.
Let's do. One week's probably not far enough out, is it? Because I'm already back here with you guys in a week.
Well, everything has to do with Miss Mandernach. She's the one.
I don't know, I can't talk right now.
Miss Mandernash,
Good morning. Did you have a
is
thing for
1 week sufficient to put out a final pretrial notice to the complainant on the Douglas Shear matter, or do you want to go further out?
I would prefer 2 weeks.
So can we do the 14th, Heather?
Yep. Do you still need the judge for the standby, or are we good on that?
We just need to make an amendment that says that a third party can execute the civil standby. We think it's in everyone's best interest just to keep the.
All right, then I'll wait for the judge to come out on that. So you want the 14th. On Wasan's file. What day what are we planning on doing?
I'm requesting an exam, and if we could do the 14th, and as I've told APA
No. That's not our day for an exam.
Oh, what date
So
is?
Either March 6th or April, I think it's April 17th.
Okay, I will be out of town on April 17th, and on March 6th, I will be beginning a homicide trial.
All right, then let me see what the next week is. April 24th.
I'm beginning another homicide trial.
Miss Mandernach, can we use you on a Tuesday since we used to have you on Tuesdays, or no?
So the issue isn't me, it's having a victim advocate present, and since this is a CSC3, I want to make sure that we have appropriate victim advocate coverage. I can check with Abby real quick.
Okay.
And I'm sorry, what was the date?
I have Tuesday, the 13th, February 13th.
Okay, that would work for me.
Well, let's see. If
Okay,
it works
let
for
me talk
everybody
to Abby
else.
real quick and I'll be right back.
All right.
And yeah, and I would just kind of need to know also the final pretrial.
Well, I understood.
All right.
No.
Hello.
Michelle, I'm in a bit of a jam. I've got another hearing I've got to do. Can we
Okay.
tentatively just set it for the 13th of February? And if anything changes, let me know.
Yep, we'll call you.
Right, here's
Okay.
Miss Vanderneck. Miss Vanderneck,
Heather,
did
I
you
just-
confirm that?
So, I cannot do Tuesday, the 13th because I don't have victim advocate coverage that day.
What was that?
Oh, I can't do, Tuesday, the 13th because I don't have victim advocate coverage that day.
Okay. February 26th.
I'm beginning another trial that day.
Okay, so you're totally unable to do March 6th? I'll call you.
Yeah, I understand. Well, I understood Judge Sabri was going to come on Zoom to do mine.
March 6th works for the people.
Right.
Okay, I'm on Zoom right now with another court. I'll be there as soon as I can.
Mr. Noak, so you're starting a trial on March 6th?
Yes.
Okay, so what week are you not in trial?
If we can do it the following week.
What's the following?
Well, I take that back because this trial is expected to go 2 weeks. Let's go the following week, like the 20th of
February
March.
26th?
Oh, February 26th doesn't work. I'm in trial.
So you need the week of February 20th?
I can do that.
I can't. So go to the next one. Oh, unless we can do February 20th in the afternoon.
I can do February 20th afternoon.
I've run into the same issue
Okay.
with, I don't have victim advocate coverage on Tuesdays because both the first step advocates and our Wayne County Prosecutor Office advocates are like scheduled to be in different courtrooms on those days.
All right. Well, we can't do a Wednesday. He's not available for our Wednesdays.
Okay. I can do whatever, or I'm sorry, which Tuesday were we looking at then?
Well, only the 20th in the afternoon, but we can look at another week if that doesn't work for you.
That works for me. I'm not in trial.
Okay, good. We'll set it for
at
1:30?
20th at 1 o'clock.
Okay, thank you so much. I've got to run. I've got another judge calling me.
And Heather, is there any way that we could set then the misdemeanor for final pretrial, though I didn't get to speak with APA Manderneck? Is that okay with you? APA Manderneck?
Yeah.
Oh, thank you. And then can I speak, I guess, with the client just briefly? So I can introduce myself? I'll put him in a breakout room.
Thank you.
Thank you.
Counsel, with the interpreter, is it Garbuzov? I don't, is this, I think your client's coming in now. Gonna try to check him in with the interpreter.
Okay.
I just don't read Russian. I think that's what it says on the screen.
Let me see.
Do you see him on the screen?
Bottom. Yeah,
Oh,
just
at least
as
I'm fine.
user of Zoom. Kind of a little bit of a broad category, but yes, it's him.
Okay, thank you. Let me see. He speaks no English, correct?
None. But Miss Abbott is here. Can I speak
Yes.
to him in a breakout room with Miss Abbott, and then
You
we'll be ready to
can.
go?
You can. Let me put you.
Mr. Washington?
That's okay.
Yes.
Earl Washington, yes, your client's here live in person because these are live dates today.
Oh, okay.
So we're gonna try to get him on Zoom.
Okay. All right then. Thank you.
You're welcome. Did you need to speak to the prosecutor while you're waiting?
Yes.
Is he with Mohammed?
Miss Mandernack? Grokowski is yours, right? Yes. Nope, just put him in Patricia's breakout room.
I gotcha.
When we're done with the court. Thank you.
I'm Robert Reese.
I'm sorry, I'm the complaining witness in your family or in a room. I'm just gonna bring them in here real quick. Okay.
That was freaking me out. I didn't realize it.
All right. Fourth District Court on session. You have Brian Nagle.
Have a seat. All right, ladies, your appearances on the People versus Robert Reese.
Good morning, Your Honor. Patricia Mandernack for the people, P84088.
Good morning, Your Honor. May it please the court, Patrice Disagreeing on behalf of Robert Reese, who's seated to my left. Mr.
Thank
Reese,
you.
please state your first and last name for the record.
Robert.
Morning. All right, what are we doing?
Your Honor, at this time, Your Honor, with defense counsel, I believe we may have a slight issue here. At this time, the people are moving to amend the complaint from one count of domestic violence, MCL 750.812, to one count of aggravated domestic violence pursuant to MCL 750.8182. And the people would request that this matter be set for a jury trial.
Your Honor, I would be objecting for setting it for jury trial at this time. I did receive 44 pages of medical records on January 10th of this year, and given the amendment, I just need additional time to investigate further. I am in a jury trial that is going mid-February, so I'm asking for something beyond the February date. I just need more time to be able to consult with my.
You want to set it for a final pretrial after you have a chance to consult?
Yes.
Look at the discovery?
Yes.
All right, let's do a pretrial. We won't need the complainant to be here that time. Agreed?
Okay.
Yes, Judge.
All right, so how far out you want to go? Any Wednesday works.
How far will you give me?
Any Wednesday works. I mean, I don't want to go into August, but
Yeah, one moment, Your Honor.
sure.
Your Honor, would the court entertain April? Or is that too far?
Any objections? Ms. Manerick?
Sorry, Judge, I'm just looking.
April dates.
Your Honor, I have no objection to April.
Any April, doesn't have to be me.
Which one?
Any Wednesday.
Which one to get the judge?
One moment, Your Honor.
That far out, it doesn't matter to us one way or the other.
And I'm sorry, Your Honor, you said Wednesday?
Any Wednesday. Wednesday in the morning.
How about April 10th?
So, all right, so that'll be Zoom with Judge Martin. What time do you want to do that? 9?
That's fine.
9 a.m.?
Yes, Your Honor.
All right, ladies, anything as to bond?
No, Your Honor. I just wanted to clarify for the record that the complaining witness is not required to be present.
Correct.
For 10 days.
Correct.
Thank you.
Your Honor, for purposes of the amendment, does he need to be rearranged in any shape or form?
Waive formal reading of the amended
I do
complaint?
waive formal reading.
Then we're fine. The bond's not going to change.
Thank you.
All right, so good luck. See you later.
Thank you, Your Honor.
Well, I won't see you.
Thank you, Judge.
Have a good day to you and your staff.
Amended complaint.
I will email that to you. And defense counsel.
And
I'm sure.
yeah, Jamie, if you're out there, tell Josh we're ready on Sure, please.
Here.
Mr. Sure, you can hear me okay? You're muted. Just give me a thumbs up.
Yeah, I can hear you. Yes, I can
There
hear
you
you.
go. All
Your Honor.
right, we're getting your attorney back in the courtroom. He was in and then ducked out again.
Thank you.
Thank you, Your Honor.
You're welcome.
Oh, Your Honor.
Mr. Hadley, your appearance for Mr. Shearer, please.
Good morning, Your Honor. Attorney Josh Hadley appearing on behalf of the defendant, Mr. Douglas Shear, who's appearing via Zoom. Your Honor, we're just setting this matter for a final pretrial for the complainant to appear. And we have one housekeeping matter we'd like to put on the record related to retrieval of personal property from the residence when the court's
Did you discuss how far out we were going to go for the final pretrial? Did you pick a date?
We did. We are going to be going out until February 14th, the people's request.
All right, how about 10 o'clock?
Excellent, Your Honor.
All right, so bond will continue, but you want to talk about a civil standby?
We do, Your Honor. Mr. Shear is currently equipped with a tether monitoring device, and he was given an authorization to use Huron Township Police Department for a civil standby. After kind of reading the police report and discussing this with Mr. Shear, I think it would be in everyone's best interest to have a agreed upon third party be the individual who goes to the residence, even with the police standby. I think it's just going to be better for everyone involved.
Okay.
So we would ask the court to basically amend the police standby to allow for a third party on behalf of the defendant to do the retrieval. Mr. Shear had two individuals that he had proposed that we believe would be mutually agreeable. Obviously, he can't call the complainant to verify she's okay with this third party.
Yeah, here's the way I think we've got to do that. I don't think Huron's going to care who calls and says, "Hey, I want to meet you at this address to make sure there's no problems." So I think to get the third party approved, that's something that you and Madam Prosecutor should just exchange some phone calls.
Okay, very good.
Obviously, she's got contact with her complainant.
Yes.
All right.
Very good. That's exactly what we'll do then. And I mean, you're on the final pre-trials in 2 weeks. Again, if it's something that's turned into more difficulty than it's worth, we'll address the matter later, but we appreciate the court's time for hearing it out.
Fair enough. Good luck, Mr. Shearer.
Thank you, Your Honor.
That's all we got so far. What about this? We need an interpreter on Maxim. Counsel, do we have an interpreter coming on Maxim?
Your Honor, she logged in, and I was having issues with her Zoom. She's going to log out and log back in momentarily. So just give her 2 minutes, please.
Okay. Are you ready when we get the interpreter?
Yes.
I'm assuming that funny writing down there is Mr. Maxim or Miss Maxim. I don't. Counsel, are we going to need the prosecutor in here for Maxim?
No, Your Honor.
Thank you. And how do you pronounce your name? Garbazov?
Garbuzov, Your Honor. Thank you.
Garbazov. Thank you. No, not unsure. The victim was here. Wasn't sure the one that Mandrich. Oh, yeah. I don't think we do either. I'm just not going to comment. Mr. Shearer, you should be good to go. Mr. Hamlin will reach out to you, I'm sure.
Okay, thank you. You have a wonderful day, Your Honor.
Yep. Have a good day.
You too, sir.
Thank you.
Ms. Mandernack, can you please talk to Mr. Washington in your breakout room? Maxim, are you ready on that case? Counsel?
We're waiting for the interpreter.
Oh, she's back.
She's
I just put her back in.
There.
We are ready to go then. Yes, absolutely.
All right, is that Al Abbott?
It is L.A. Abbott, yes.
All right, interpreter, you're muted. Okay. Mm-hmm. We got our interpreter on.
Interpreter is here.
All right. And the language is Russian, correct?
Correct.
All right. Would you inquire of Mr. Maxim if he can activate a camera?
Господин Максим, пожалуйста, включите камеру.
Что сейчас?
Thank you. Ms. Abbott, raise your right hand. Do you swear or affirm that you will accurately translate between English and Russian and English so that we can discuss this matter today with Mr. Maxim?
Yes, I swear.
Counsel, go ahead. Your appearance.
Yes.
Пожалуйста, господин адвокат, вам слово.
Good morning, Your Honor. Leo Garbuzov appearing on behalf of defendant Maxim Andreev, who's present via Zoom.
Добрый день, господин судья. Леонид Гарбузов представляет интересы Максима Андреева, который здесь по Zoom.
Your Honor, this is a date and time that was set for a pretrial in this matter.
На сегодняшний день назначено предварительное слушание по делу.
And Your Honor, even though it's not a complicated case, there are potential immigration consequences that I advise my client about and that he's well aware of.
И несмотря на то, что это дело не такое сложное, но тем не менее существуют иммиграционные последствия, с которыми мой подзащитный ознакомлен.
And for that reason, Your Honor, I submitted a deviation request to the Wayne County Prosecuting Attorney's Office.
И по этому поводу я подал ходатайство в отдел прокурора Wayne County.
And Your Honor, we're still waiting for a final answer from Mr. Bresnahan in this regard.
И мы ждем еще ответа от господина Брейна по этому поводу.
And I would respectfully ask that you adjourn this to a final pretrial in about 2 to 3 weeks, and I'm sure by that time we'll have a final answer and we'll know whether or not a resolution is possible.
И я хотела бы попросить, чтобы вы отложили рассмотрение данного дела еще на 2-3 недели, и до тех пор, пока мы не получим ответа и не будет вот этот вопрос, не будет видно, что этот вопрос, как этот вопрос будет разрешен.
February 21, 10 a.m. work?
На 21 числа в 10 утра.
Your Honor, I'm sorry. That date does not work. Is there another date that may be available?
Нет, к сожалению, день не подходит для меня, может быть, какой-то другой день.
28th?
28 число.
The 28th at what time, Your Honor?
Во
10 a.m.
сколько?
work?
10 утра.
That should work, Your Honor. Thank you.
Да, это подходит. Спасибо.
Mr. Maxim, February 28, 10 a.m. work for you?
Господин Максим, 28 февраля в 10 часов подходит это время для вас?
Подходит, спасибо.
Yes, it works.
All right. Any questions for your attorney before we terminate the meeting?
К адвокату или к суду?
Нет, вопросов нет.
No questions.
All right. Ms. Abbott, thank you. Counsel, good luck.
Thank you so
Your
much.
Honor, thank you as well. I just wanted to make sure that we're going to have an interpreter available for us on the 28th and to renew my request for an interpreter.
С 8 февраля был заказан переводчик.
Going in the system right now, counsel.
Thank you so much.
Да, будет помещен заказ в систему.
Thank you.
Спасибо.
Have a good day.
Thank you.
You as well.
Thank you.
Thank you, Ms. Abbott.
Miss Medina, you got something?
Yes, Your Honor, Ms. Kirk, we actually have a plea form, Your Honor, but at this time she'd like to consider the offer, so we are seeking an adjournment, I think.
How far you want to go?
If we could just do 2 weeks, Your Honor. I mean, well, sorry, AP and Mohammed wanted 1 week. If we could do 1 week, I apologize.
Next Wednesday? February 7th? How about 10:45?
That's great, Your Honor. Would that be in person or on Zoom?
Is that us again? Zoom with Judge Martin.
Okay, so it's gonna be in 1 week. Thank you so much, Your Honor.
You're welcome. Good luck.
You're gonna give your notice with the Zoom number and that's where.
Judge, that's Judge Green on the 7th.
Oh, that's TBG?
Yes.
All right. Crystal, that's Judge Green next week.
Okay, thank you so much.
Still Zoom.
And then just give me a call this week if you have any questions at all. Just so that we're ready to go for that date, okay? Folks, didn't want any longer. Sorry.
Gracie, we having fun?
Yes, absolutely. Thank you so much. Keep it here. Okay.
I don't know. She's here on high school kid, so I don't know. Yeah, she's related to Thornsbury now. Would you say it was your cousin married to Thornsbury?
My
Niece.
Old weird. This is playing first, yeah.
Ms. Kirk.
Mr. Washington, do we need your client out of the breakout room?
Yes, uh-huh.
Are you ready on it?
Yes, I'm ready. I'm ready I'm gonna ask for an exam date.
Judge, it's on Gachowski.
GACH.
Counsel, your appearance, please.
Good morning, Your Honor.
Good.
Patricia Mandernick for the people, P84088.
Good morning. This is Earl Washington, Neighborhood Defender Service, P31383, on behalf of Mr. Nicholas Gachowski.
And we don't have Mr. Gachowski. He must still be
I'm
stuck in the
trying,
breakout room.
I'm trying.
Gachowski.
He is in the building,
did-
Judge.
Are you available for an exam on March 6th?
I'm gonna check on that.
Sure.
6.
12
Yes,
or 12:30 works.
12 o'clock will be fine.
How do you pronounce the last name?
Gahoski.
Gahoski?
Yes, sir.
All right, Mr. Gahoski, we're setting an exam for you on March 6th at 12 noon. We've got your attorney online here.
Okay.
Anything else, counselors?
No, Your Honor.
No, Your Honor.
Bond will continue. We'll get a paper notice to Mr. Gachowski.
All right. Thank you, Your Honor. Have a good day.
Stay right where you're at until we get your
Thank you,
notice.
Judge.
Mr. Washington, you're all set unless you have another one.
All right. Thank you.
Thank you. Have a good day.
So last year, the state of Michigan adopted this new system where anytime you shoot here, you have to report the harvest, right? Online. It's supposed to be done with a theory, but I forgot. So it will not let me report the harvest because it won't accept the date of January 26th as a valid date for the harvest. Because statewide, the bow season ended December 31st. But at Wayne, Oakland, and Macomb, the season ended January 31st. But it won't take a date. And I'm assuming because they don't have it specified enough for those three counties that you can shoot one after the first game. So, all right, I guess you don't get my report then.
You have to report the harvest, mean like the dead, you just have to.
Yeah, when you take, you know, when you kill one.
Yeah.
Yeah, when you take one, you gotta report it.
My nephew shot like 8 fish up on that property that like up near somewhere up that way. And the property that he's hunting on, somebody that he works with, well, the guy, they butt up against the not Mormon, but who are those people that
Amish?
yeah.
I didn't know we had Amish in Wixom.
It's up a little farther, but yeah, so he butts land with him, and so my nephew would go and talk to him, let him know what he's doing and everything. And he just took, I think it was last year that he shot in the process, he took it out to that guy.
Yeah. They tend to be hunters too.
Yeah.
Yeah, I killed 5 this year. I killed 1. Gave 3 to 1. Oh.
A muzzle loader.
Whatever. All right. That's fun.
Is this thing?
Yeah, you know what? If you do some research on how deadly those things are, pretty impressive. I bet. It's pretty impressive.
What do you think about that movement? Swinging?
No. Yeah.
Judge, we have one. No. We got a silver one.
I can't read the writing, so I'm looking Holly. Mr. Holly? Mr. Holly, you have agreed to go forward today without a court-appointed attorney, is that correct?
Yes, ma'am.
All right, but you've talked to the prosecutor, and the prosecutor sent in a piece of paper.
Yes.
You were charged with drove while license suspended, revoked, or denied on March 7th. The prosecutor says if you plead to no operator's license on person, then he's asking me to dismiss that charge. Is that your agreement?
Yes.
You understand the possible penalty for that charge?
Yes.
And did you read your rights form, and do you understand your rights and the options they present to you?
Yes.
Understanding all of that, are you pleading guilty freely and voluntarily to the added charge?
Yes.
Sir, on the date of March 7, 2022, were you at or near Detroit Metro Airport?
Yes.
And at that time, were you operating a vehicle without a valid license?
Yes.
I will accept your plea to the added charge. I will dismiss the original charge. What's the status of your license now?
I can get it now that I got this like taken care of. I couldn't get it because I had other stuff going on.
All right. All right, you got another court date coming up on tomorrow.
Look, that's the thing with that court date. He told me that they don't handle, they handle felonies today. That's a felony court date, which is posted.
Not tomorrow. We don't have felonies on Thursday.
That's what I'm saying, but that case is a felony though.
Not defrauding an innkeeper.
That's not a felony?
No.
Oh, I thought that was a felony.
No, that's a misdemeanor.
Oh, I didn't know that.
Yeah.
I thought that was a felony.
Yeah, so you can handle that tomorrow?
It says it's on Zoom tomorrow. That's what it say.
Right. Yeah.
Yeah.
Oh, that's why it's okay. I thought it was a felony. That's my I thought it was always felony.
Nope, misdemeanor.
All right, thanks.
So you can be here in person or on Zoom?
I'm gonna be on Zoom tomorrow because they already said it for me. Already.
Okay. All right. So what do you got to do to get your license back?
When I'm done with here, I think I got one more ticket. Yeah, I just got it because I had just bonded out from here by going to jail.
Okay.
So, but when I went to jail, they gave me a ticket too, which I didn't know.
Okay.
So I got to get my pay Shelby Township, then I get my license.
Are you working?
Yeah.
Where do you
I work at Salon Posh. That's my baby mother owned like a big hair salon.
Okay.
I just do janitor work there.
Okay.
I just recently started. I started working there like when I had to though.
Right.
For, I wasn't
Okay.
working there first though.
So how soon do you think you can get your license straight?
What as soon as possible. I can pay for whatever I gotta pay for. I just need to, if I can get them, I should be able to get them though. I need them bad though. I want them tomorrow if I could. I got court for Shelby Township coming up too. So that's one of my last
This
court
one's
dates.
not stopping anymore because we're not suspended, right? Right.
Yeah, but no, this one's not happening.
Yeah, all right.
It won't.
Okay, all right, anything else before I sentence you on this one?
No,
All right, so on this one, fines and costs are $600. You need a payment plan or can you pay it today?
I want to pay them.
Go downstairs, make whatever payment you can, if any, and
All
then
right.
set up a payment plan.
All right.
Any questions?
No.
All right, good luck.
So I'm gonna have a different payment plan for the next case?
Tomorrow's case?
Yeah.
We'll roll it into one if we have to.
All right, okay.
Yeah. Good luck.
All right.
Hi, Your Honor, I am just waiting right now. I have a client here who is not scheduled till 10 and Mohammed is waiting on the payment so we can figure out hide options.
Who is that?
That is Mr. Victor Stokes.
Stokes with an S?
Yes, Stokes with an S. Is there anyone online that we would need? Nobody? Thank you so much for putting me in that breakout room that I was booted on. I really appreciate it. I have no answer to for my client to any of his questions. I will handle that.
What do you got, Mr. Mohammed?
It's a recount ticket.
What's your name, Joe? Oh, you got files. Come on up, sir. Yeah, Mr. Ferentz?
Yes, sir.
All right, you're going forward today without an attorney, correct?
Correct.
All right, let's see what we got. We got a speeding ticket. We've got a registration or plate violation, and we've got a misdemeanor false insurance charge. All right, so the speeding ticket, we're going to reduce to 6 to 10. The misdemeanor, we're going to reduce to a civil infraction, failed to display insurance, and the registration plate we're going to dismiss. Is that your agreement?
Yes.
Okay. Josh, would you do me a favor?
Yes, sir.
Educate Mohammed. He's been doing this. He sends in I got 3 separate files and he sends them in with count 1, 2, 3. I don't know which is 1, 2, 3.
So he's not distinguishing on there which one's which?
Case numbers.
Okay.
Right. So on let's case, you could use A, B, C because they're all the same incident, right?
Yep.
The count 1, 2, 3 works when it's one file with 3 charges.
But you have 3 cases and the count 1, 2,
3 separate files.
Okay.
Right. I mean, I can figure it out usually by what he's describing, but it just makes it a little easier.
It's not your joke.
Just a little easier.
I'll let him know.
We got to educate him because they didn't do any educating at the prosecutor's office. They sent him out here with 0 training.
Don't talk to him over really quick. It's okay.
Yeah.
I like this judge right now.
All right, so we've got 2 civil infractions. We're going to dismiss 2 original files. All right, is that what you want to do to take care of this, Mr. Ferentz?
Yes.
Okay. All right, so let's get rid of the one we're going to dismiss. I'm dismissing C. And on the speeding ticket, we're going to reduce the 16 to 25 to a 6 to 10. Fines and costs on that one, sir, 180.
Okay.
Can you pay that today or do you need time?
Anytime.
All right, so when I'm done with you, go downstairs and set up a payment plan on whatever you got to do.
Okay.
All right, on the insurance civil infraction. Fines and costs on that one, 220. So the total is
total
400.
Yeah, 120 or 180 and 220 is 400. Yeah.
Right, my math is right?
Yep.
Right.
How much is that one?
220 on the insurance. Questions?
No, sir.
You're all set. Go downstairs and they'll set you up with a payment plan. Weekly, bi-weekly, monthly, whatever works.
Okay, thank you.
You're welcome, sir. Enjoy your day.
You do.
Thank you. Joe?
Yeah.
What do dentists call the x-rays they take in their office? You can figure it out, really. You could logically, you could figure this one out.
So wait,
Toothpicks.
failed to display insurance, so just no insurance.
I guess. No POI?
That is pretty good.
She sent me one last night. I'll get to it in a minute. I'll show you. It was just bad. Let's see. I was shocked when I found out my toaster was not waterproof. That's just bad. I mean, you know.
That you would announce.
No, that was, I wouldn't even announce it. That was just. That was just big. Look at this.
This is one that he would have announced on radio.
This is a 1,000-piece puzzle that she just did.
Did you find it?
Yeah. 2 pieces of 20 by 27 inch poster board. That gives you an idea how big that puzzle is. Isn't that cool? Not a straight edge on it.
Wow.
That would be tough. I wouldn't even do that one. I wouldn't even try that one.
Messengers.
Thank you, Josh. You know what? Josh is a logical thinker. So what do dentists call the x-rays that they take in their office?
She thought our witness the other day for the jury trial was pretty weak. Wanda did. The Miss Green was a pretty weak week. Yeah, pretty weak witness.
I don't know, my brain's going right to puns and like dad jokes. Is that what it is?
Toothpicks.
Okay, so I wasn't far off. I was trying to do the pun.
No.
Somewhere right there.
I like that one. I like that one a lot.
The jury trial you're talking about, was that the stalking case? At least done, right?
Yeah. Well, yeah, we'll lie. They found him not guilty. It was a weak case, but I didn't think they'd like him. I thought they would convict him. Just, I don't care. I would say this in the newspaper.
In the jury room, but you're at the end of the day, everybody's confused.
Yeah. Oh yeah. Yeah. But and you know what? Kuja did a great job, and he had a chart. And Sona said they've been using a lot of circuit court. He says he's seen them use it in murder trials. She says there's some judges who won't let him use it. So he's got this chart. It's like this big, and at the top in red, there's red boxes, or it says guilty, and then under that is like 10 or 12 different. Starts at the bottom like no way he did it.
Right.
To maybe he did it. To I think he did it. He probably did it, and it works. It's all the way up, and under guilty was, I don't remember now what it was, but basically it's like getting closer and closer and closer to he did it. And I thought it was a great. Did you see it?
I didn't see
it. I thought it was a great chart, and she didn't like it at all.
Oh, no.
And she says it just makes it look like it's almost impossible. I said, well, when you get right down to it, it is a high burden. They both did a great job on closing
The
them.
last one on that board should have been, like have been the first. If you're reading from guilty, then the first one underneath it was like
Yeah, I'm pretty sure.
Pretty
yeah.
This is kind of like what it looked like, but it was all white and just a red.
I love it. I've never seen it before.
That kind of split.
This was all white, and then this was red. See how like this is only guilty, and all of this is next.
So what's the first name?
Guilty, highly likely.
Yeah.
Guilty, likely, probably guilty, possibly guilty, suspected, perhaps, maybe not, possibly unlikely.
I would change the color code to be what he said.
Yeah, it was all white.
It was all one color.
Yeah, this was all like this was red, and then that.
I thought it was good.
Because I got that like 5 defendant.
Oh, there it is. We're gonna prove. This is
That's it.
exactly what you said.
Exactly.
Right here.
Because I was gonna say, I got a 5 co-defendants and
You could take that on
That's exactly
thumb
what
drive,
you
take it, and tell them you want that on a chart.
blow it up for
had.
you.
Yeah,
I love
yeah. It was
And
on a
actually,
hardboard.
The jury saved me up because he tried to fight Kuja after the people arrested. I'm like, no, I'm not letting you fight. But I have no authority. So. He was in the middle of jury trial.
You see how.
Oh, yeah. I don't care. That's never possible. But, well, he goes to JCC and I got to go to that dog. Well, when I did it, I was wrong. I'll give him another trial before I stop this one or turn this one into a dog. What'd you forget?
What's that?
I don't think anybody's been in here since you though.
No one has.
You want us to call it?
You guys are. I got two. All right.
Well, that's why you call one of the other ones.
It looks like there's one.
I've learned how to ask him I'm about to
he's on call 24/7 at work.
For me, it's I've realized how useful texting is for my mind. I don't want to send me I'm not there because like if you're below the age of 30 and I text you come to court.
You gotta talk to a real detective first. I'm not so sure there's not an app you can put on that phone. There's a separate number that just tests.
There is. I had it. It was a Vonage app, and I just did not care for it. It was a little clunky.
Okay.
And also, it's like what did it look like?
Oh, yeah, what it showed up.
Yeah, you know what I'm saying? I didn't look professional.
You know what's crazy? If I call my wife from home on my cell phone, it comes up public service president. I can call my wife right now.
But if you call her from down the street, it's gonna be your normal.
Okay.
That's what strangers do.
It's really bizarre.
Yeah. I don't know. Yeah, I'm glad you guys got it. Either way.
Oh, me too.
That's right.
Well, I told her, well, I'm smart on this. Because on one hand, if I'm not guilty, it solves a lot of problems here. Yeah. But on the other hand, I wanted to find it guilty. I was in Florida with this health care. That guy, he's kind of, that guy has some issues.
So I don't know, man. This is I'm from Michigan. Michigan is a professional. I'm not disclosing any communications. Let me say this. During one of my communications with a former client, it broke down. I said, let's take a breather and talk tomorrow. And we said, we just continue to try to talk tomorrow. I hung up on him. Royce and I received, no exaggeration, count them up, because I had no trace of it, 27 calls
that day
in a row. Right. We leave a voicemail, we'll call, right. Let her ring the voicemail.
Good, not wait until tomorrow. Yeah, and that's what we talked about, because some of it, did you know what I thought? It's like, this guy's probably got this case one right now. He does not do that. The three of us agree. The prosecutor agreed. If he does not get on the stand, he's probably got it right now. And I said, this gives me a perfect opportunity to use my favorite round white call. He has a constitutional right, but he doesn't have the ability to apply. And Kuja tried. I mean, Kuja did a pretty good job of keeping him on task because every answer he wanted to answer and then preach. Yeah, you know what I mean? Moving into conspiracy. And I kept saying yes or no. Someone kept saying yes or no. So much. See, I think she would have got more. I think she would have. Ken brought that up yesterday, and I said, I think that was my fault. I think I pulled the rug out from under her so many times during that trial because we were headed into, and she was getting frustrated. Bless her heart, she's getting frustrated because, as she said, it's also intertwined. I don't know how I can talk about. I don't know how I can get to what I can talk about without getting to what you told me I can't talk about. So I think that's part of why she didn't go after as hard as she was, because she was afraid he was going to say something that I already said this is all. I just think I had her on the roll, not intentionally, but I thought she did a great job of what she did. But with the jury room, a lot of times, when did it take half hour? To deliver it? Yeah. It was like, yeah, she got her all out. The first battle waiting for that. Well, it was 7 o'clock. So I don't know if it was like, you know what? We're not sure what happened. Let's get the hell out of here. And you know what I realized at home, what I realized Tuesday morning? You bring up, hey, you guys discuss if you want to have a lunch break, when you want to have a lunch break. If you say no now and you change your mind later, that's okay. And then at the same time, I'd say, and you also decide how they work it. I never did that. So when one juror, when I got back to the last question about process or anything, one juror fine, nobody wants to say, one juror said, why did it work so late? And I didn't catch it then. I said, well, because in my experience, jurors would always rather work a little late. Try to find another day where all 7 of us can get together again.
What do you got? I just need Josh. Is he ready? Is Mohammed ready on my app? Now you have another one here. Really? He's done for now.
And if the kid turns 18 in October, maybe that'll do it.
You want that back there about the bill of particulars? Yeah. Then go get with your victim rights people and send her to family court with PPOs. That one to me, it was gonna be a much better path forward than this because of it. But it's still there. Wash it.
You think you're supposed to be the gatekeeper
Well, I
for
have
Zoom.
a note next to most of my people that can.
He's got a whole buttload of civil infraction.
Yes, he is right.
Okay.
We can talk about a civil infraction.
Well, I don't have a phone
I
file.
mean, yeah, you have. the
Oh, yeah, I
bottom.
do. It wasn't together. Is it appointed?
Yes, he had Mr. Humphrey for his appointment for selling.
Oh, I think all these are just payments.
They are. And that's why I printed off
Yeah.
the front sheet to give you the exact
Yeah.
pricing
Oh, is it? Where's that?
on top of the felony.
Oh, okay, thanks. Mr. Dewson, can you unmute yourself?
Yes, sir.
All right, we're waiting for Mr. Humphreys to appear to talk about your felony file, but we got a whole bunch of other files here that you owe money on. Are you okay talking to me about those without him?
Yes, I recently requested a payment hearing or a payment plan. I'm sorry. I haven't got the packet in the mail yet, but I just recently started a job too, so I haven't gotten paid yet.
Okay.
But as I get paid, I plan on sending the $50 to clear the warrants at least.
Did you do all that online through our email?
Yes.
Okay, all right. When's the last time you sent us something electronically about your payment plan?
Probably years ago, sir.
No, not the last time you sent us money. When did you last communicate with us about your payment plan?
Let's see. I can look into my email real quick.
Sure, thank you. Then we should process that by.
Oh, you're too swinging doors. You come up with me. He can stand over here. Mr. Fred Tripp.
It was
Go ahead.
I said it was January 17th, the last time I talked to him.
Okay. All right, well, just let me make sure I got a good email address for you. Go ahead and give it to me.
It's beachjacob02@gmail.
Did you get any of that?
Judge, I already confirmed it in his contacts.
You got it? Okay,
Yeah.
we've already got it in the system. All right, so now just hang tight until Mr. Humphrey shows up.
Yes, sir.
Good morning, Mr. Oakley.
Good morning. Triplet?
Yes, yes, sir.
Good morning, Your Honor. Attorney Josh Hadley, appearing on behalf of this fine gentleman, Mr. Fred Triplett, who's standing to my left, who just, we'll go ahead and state your name for the record. Brady Triplett. Thank you.
Good morning, fellas.
Your Honor, good morning. Today's the date and time set for a final pretrial conference. This matter for the complainant to appear. I believe the APA is.
Yes, good morning, Your Honor. Mohammed on behalf of the people, P86771. I did speak with the victim along with Tanisha Oliver, the victim advocate, and the victim indicated to me that she's not going to appear. She knew about the final pretrial date today, and she doesn't want to move forward with this case.
Obviously, in response, we'll be moving for, I shouldn't say obviously, we will be moving for a motion to dismiss without prejudice at this time.
It was obvious to me. All right, I'm assuming that's okay with you.
Yes, sir.
Case is dismissed.
Thank you, Your Honor. I guess obviously and honestly are things I should just not use as qualifiers as an attorney.
Have a good day.
Thank you, sir.
Happy holiday.
You as well, sir.
No,
Oh, we do it to it.
Which file?
Big pen, Judge.
Are they saying Digman?
Big pen.
Big pen.
And Judge, in regards to those citations, it's not gonna happen.
No problem. You don't know if you don't know.
Yeah.
Are you ready, counsel?
Yes, we just need to sign the waiver form, but I'm ready to go on the record.
All right, appearances for Lazarus Thigpen.
Good morning, Your Honor. Mohammed on behalf of the people, P86771.
Judge, good morning, Lyle Harris, Commissioner Thigpen.
Good morning, Mr. Harris.
Lazarus Thigpen here.
Thank you, sir. All right, does the waiver?
Yes, Judge, discussed the matter with my client. He understands his right to an exam and he is likely to.
Thank you. That's true, sir. You understand the purpose for an exam?
Yes, sir.
You understand your rights and options after going over those with counsel?
I do, Your Honor.
Sir, you understand if I enter a waiver, we send the file for the next court date to be downtown?
Yes, sir.
That's what you want to do today?
Yes, sir.
You're doing so freely and voluntarily?
I do, Your Honor.
Gentlemen, are you satisfied with the waiver as taken?
Yes.
Yes, Judge.
All right. So what's the 31st? So that'll be 2 weeks out on Valentine's Day. All right. Anything as to bond, fellas, or should we just continue?
I'm gonna ask you to continue.
Mr. Mohammed, okay?
Yeah, no objection.
Thank you. All right, Mr. Harris, let me do my scribbles and I'll hand it out to you for signatures. All right, and I'm done with it, Joe. All right, thank you. Good luck downtown, sir.
Thank you, sir. Thank you, Your Honor.
Mr. Jones, how you been?
Your Honor, I am incredibly lucky, as you know, and Forrest Gump continues to work. The DV prosecutor has my file.
What's the name?
That would be Mr. Rose.
Rose, like the flower?
That's exactly how we like to think of it.
Do we need her to do what we're doing?
Yeah.
Okay.
She was seemingly doing other things. She made me feel like I was the only case, but it seems she did have others.
Okay, well, I'm ready when she comes in.
Okay. Call for the other side. Oh, look who's here.
Nice time.
Thank you. I just got it. I just put some together.
How's things, you busy?
Julie was over Monday night. They watched the Bachelor together. I hide upstairs. It's really unbelievable.
I have not seen her in years.
Yeah. She
Or the
literally,
chosen
she
one.
looks, I didn't know her in college, but I presume she looks identical.
Some people age, some people don't.
She runs in snowstorms. It's crazy.
I reconnected with a guy, Dennis. He finally sent me a response to what was going on. He on November 2nd, he had open heart. He was 77 at the time.
Oh, yeah.
The doctor said, I've never had a patient heal this quickly. He called 2 other MDs in to check out his wound because it was healing so well. Already, he's back to shooting his bow every Thursday night at leagues, shoots a recurve. And he is on his bicycle every day. And he says, I think it's because I rode bikes for 50 years. Because he was always, you know, I was telling her, single guy, never married, no kids, and just real eccentric. And he always took long bike rides. That was his thing. Archery and bike rides.
I think equally as important is you believe that. It gives you the strength. Right.
Yeah, I thought you were gonna say because he had no kids or wife.
No. He,
less stressing.
No, at the end of the day, after I ask myself how this happened, I'm like, well, it gives me more to try and help. 34 years on Friday, so it's my Rockville District Court anniversary.
Yeah.
And let me go see if my friend wrote up.
Mr. Humphries is coming in.
Mr. Humphreys, are you connected? I don't think he is.
Yes, yeah, yes.
There he is. All right, counsel, I've got Mr. Duzen. Do you need to talk to Mr. Duzen in a breakout or the prosecutor or both?
None of the above, Your Honor. Mr. Duzen and I have already had a chance to talk. He's requesting an exam.
All right. Counsel, look at your calendar. Are you available on the 6th of March? 12 or
1 second,
12:30?
John.
Sure, take your time. Gotcha.
Okay. Should be in a second.
So 1 p.m., 12 p.m., or 12:30 p.m. on the 6th, they're all available.
Unfortunately, Your Honor, I have a jury trial that starts on the 5th in circuit court.
How about April 17th at 11:30, 12, or 12:30?
Whatever the first time was, that's good.
Okay, 11:30.
Thank you very much, John.
Mr. Duzen, you got that? April 17th, 11:30. That's a Wednesday.
Okay. Yes, Your Honor.
All right. Bond is continued, counsel.
Thank you, Your Honor.
Thank you, Your Honor.
You're welcome. Have a good day, gentlemen. We gotta let Muhammad know that date. All right, appearances on Rose.
Good morning, Your Honor. Patricia Mandernack for the people, P84088.
Good morning to you, your unparalleled staff, especially Heather, and my sister counsel. I'm Jonathan Jones. I represent Mr. Rose.
What are we doing?
Your Honor, at this time, the complaining witness was present. I was able to speak to her. She indicated that she does not want to participate in prosecution. I'm unable to proceed without her.
Shockingly, I have no objection.
Okay. I'm assuming it's okay with your client if I dismiss without prejudice?
Let me check with him. Is it okay with you? He says,
all right. Glad you could convince him. All right. Enjoy your day.
I can't tell Steve you say hello.
Oh, absolutely. Yeah. And as always, pleasure to see you.
Thank you. Yeah, thank you.
All right, I'm gonna go make a phone call. Hey, Joe, when it's convenient, let's look at those shows.
Okay.
Actually, this one's better for you. A purple line next, like, yep. I have a couple more, but these are later. I didn't know these people show up.
Oh, here goes one.
Huh? And then 10:15 is my next page. So. Never talk to me today because they never confirm. Oh. I'm gonna tell what's coming up. Hey, you know that Ronald Roll case?
Yeah, I'm gonna say yes. I mean, I know I have it, I just can't remember what it is.
Felony and the felony she just listed, the prosecution on the transcript, we adjourned it to the transcript. I put the transcript to the prosecutor's office, no replying, no nothing, no payment, so I'm gonna talk to Judge Martin, it may not happen in February. Because it was a dismissed, aggravated domestic. We can talk to her right now.
Yeah,
They don't pay me.
I thought I was heading to buy a new laptop this morning. When you were like, turn up your volume, I was, something turned off in the actual hardware. Is that microphone screwing up your, my voice is too loud with that microphone.
Is it?
Let's
Oh,
listen to this.
no, yeah, we can pick up later. Yeah. Hello? Do we have anything ready, Josh?
I'm waiting on Mohammed. Yeah, I've got a dismissal.
He's got a dismissal. Who is yours? Okay.
About their Luis. Mine's.
Is yours just, yeah, perfect. Just impeding, how long do you want? 14 days
Yeah.
Today
14
or
days.
14 days? All right, and you're all set. I will put it in the system right now and
Sounds good.
thank you. Have a great day.
Yep, we didn't even write up a dismissal form. We need one.
No.
I wasn't sure.
Which file?
Who is it, Josh?
Julie Novotnik. I don't know where Mohammed's at. You said he was right behind me. Sorry, Your Honor.
That's all right.
Pull you out early.
There we go.
And to be clear, it's the DV case because there is a separate OWI with Romney's. We're hoping to make quick work of this as well.
Yeah, I don't
You
have
don't
that.
have that one.
Yeah, I wouldn't have that file today. Looks like she's scheduled for a 2:15 pretrial.
Yeah.
Mr. Hadley?
Yes, sir.
February 15th pretrial for the drinking and driving.
Okay, thank you.
No shows in pink.
No shows in pink.
Yep.
Either somebody, I'm getting ready to move to most of the. One of you guys. Okay. So you want to grab her, so first one I had. Fourier?
Well, they didn't.
Show cause, there was a show cause, that's
Yeah,
not.
the show cause.
Our show cause is on mine.
I don't have it, I don't have it.
Yeah, it's usually on the.
Yes, this is double. Yeah, but.
Alphabetical is at the very top of the second page. Pure.
Right there. Right there.
Oh, okay, all right.
They thought they were ready.
All right.
Yeah, they're discussing it.
She didn't show, right, Heather? Her.
Look who's here. He must miss us.
Unless there's got.
Good morning, Mr. Kuja. Who's he here for?
Good morning, Your Honor.
How we doing today?
Good, how are you? I just have a PCC for Mohammed Al-Khatib.
Yeah.
Right.
Notice it said live in person.
This is supposed to be live, so I don't know if your client's here or not.
Oh, I didn't. We could be there in like 10 minutes. We could be there in 10, 15 minutes if you want us there in person, Judge. No problem.
Do you need to speak to him?
No, I spoke to him on the phone.
Okay, so are you ready if I can get him in the courtroom?
Yeah, we were just looking to set an exam date. But I think he's on
Okay.
Zoom. He asked me for the Zoom code just now. But I know he doesn't live far from the court.
So we're looking about. NCTEEBT. Yep. He's
Not here. Okay. No, he's not in person, so we're waiting for him to show up.
Okay.
He asked, Mr. Puja for the Zoom ID, so we're just waiting for him.
Yeah. Are we ready to call Novotny?
Yes, Judge.
Appearances.
Good morning, Your Honor.
Your Honor, Patricia Internet, People, P84088.
Good morning, Your Honor. Attorney Josh Hadley, on behalf of Julie Novotny, who stands to my left, please state your name for the court.
Julie Novotny.
Your Honor, this is the date and time set for a final pretrial for the two complainants to appear. We've spoken with victim rights advocate indicating that there have been some waffling back and forth, but as of today, we don't believe that they intend to move forward. If the people don't have any objection, we're going to be motioning to dismiss without prejudice.
That is correct, Your Honor. It's my understanding the complaining witnesses are unwilling to proceed. I cannot go forward without them.
Dismissed without prejudice.
Excellent, Your Honor. And there was a no contact that was in place.
All goes away.
All go away. Very good. So
Okay, thank you.
You bet.
You're welcome,
Appreciate
ma'am.
the family law attorney.
Thank you.
Yeah.
Hey, next time Josh is up here, shoot, ask him to explain it.
So I was forced, but
Yeah, you got anything out there?
I'm done.
All right.
Do you guys need anything else?
Yeah, come on up here. Heather asked me the other day, what's the difference between the prosecutor and the process? Dismissal. And I told her, the only thing I can do is now the process, prosecutor do it. And dismissal usually at the request of the party in the course do it.
So we have to come up with that big case of going to trial and that's all.
Okay.
So the prosecutor got all the signs before they were the proper evidence. They didn't refile. So I think prosecution may put a burden on themselves by doing. I don't know if they have to refile. I think we may have a hurdle. Why now?
Okay.
Dismissal without prejudice. We should
It's like a
discretionary. It's like,
Yeah.
we'll see what happens.
Well, the way they use it is, what way they use it now, process. We're not ready, so we'll come back later.
I'm actually curious enough to ask you that because I'm curious enough. I got to research that issue and break it out. So
Well,
it's a
good.
much better answer.
I would appreciate that. I would, seriously, I would appreciate that. Yeah.
I wouldn't take a 10 o'clock.
Yeah, that's fine. Yeah, we don't want to go beyond it.
As much as I correct about those appellate cases, they actually do get you back to reviewing.
Absolutely. Absolutely. Well, I had a conversation with a guy the other day that actually went to prison for 5 years for defrauding his client. And now he's basically all he's doing now is he's in the legal writing program while he's in prison. Now he's doing. You know what I find? Most of the time when I'm doing this something. He says, I spent 14 hours on a brief. He said, what practicing attorney has 14 hours to spend on it?
It's not wrong. Because I just, it's easy to have.
Yep.
Game is all days. Just
Yep.
take what you get.
Yep. Okay. Do we have anything ready?
Judge, I believe that we are ready on Willingham. DeMarco Willingham.
All right. Is Mr. Willingham here?
Yes, Your Honor.
Oh, come on up, counsel. Ladies, your appearances.
Good morning, Your Honor. Patricia Mandernack for the people, P84088. Good morning, Your Honor. Kashama Kirkland on behalf of Mr. Willingham, P84015.
Thank you. What do we got today?
Your Honor, at this time, the people have extended a plea offer in this case. The current plea offer is defendant pleads guilty to count 1 domestic violence pursuant to MCL 769.4A. Defendant would be sentenced to 1 year probation. Defendant must complete batter's intervention. Defendant must complete psychological evaluation and treatment. Defendant must complete parenting classes, and defendant is to have no contact with complaining witness except pursuant to a custody and parenting time order.
And yes, Your Honor, I have spoken with Mr. Willingham. We did receive the offer today. We asked for an adjourned final pretrial date. We're still waiting for some discovery. I have been in contact with sister counsel, and she's working with the OIC to tender that. So we just asked for maybe a 2-week adjournment.
I could care less. Just pick a Wednesday.
Thank you. And just that offer remains open until the next.
2 weeks is okay?
Yes, Your Honor.
February 14th?
Thank you.
You can wear red.
Oh, and I'm sorry, that's for another final pretrial, Your Honor.
Pre-trial, because final gets confusing because everybody thinks the complainant has to be here.
Okay.
Yes.
So I'm assuming we're not requiring the complainant to be here for this next one.
No, and Your Honor, I would just like to put on the record that the complaining witness is present.
Okay. So I said the 24th, didn't I? 14th. I don't know, 10:30?
10:30 works. And Judge, is that in person or via Zoom?
That one is going to be Zoom with Judge Green.
Green, okay, thank you.
All right, good luck.
Thank you. Have a good one.
You as well.
Do you take the final?
No. Complainant doesn't have to be here. Are we ready on Sandoval?
Yes, Your Honor.
Counsel, your appearance?
Is the prosecutor here? Is it just me, Judge?
Yes.
Yep. Mr. Mohammed is here.
Good morning, Your Honor. Mohammed on behalf of the people, P86771.
Good morning, Your Honor. May it please the court, Brian Daly, appearing on behalf of the defendant, Mr. Sandoval.
Mr. Sandoval, you're muted, and activate your camera if you have one. Thank you, sir. Mr. Sandoval, can you hear us all?
Yes.
And what are we doing today, counsel?
Your Honor, we're planning on waiving the preliminary examination so that we can move down to Frank Murphy.
Thank you. I lost Mr. Sandoval. We had him for a second, Mr. Daly.
I'm sure you get him back, Judge. Judge, while we're waiting for that, can I ask you officially, what is your policy on Zoom hearings?
Hate them. You want any more specifics?
Love to, yes.
What do you want to know?
So what hearings can we assume that if we request by Zoom, the court will grant, and what can we not?
I'm not doing exams on Zoom.
I understand. Pre-trials?
Yeah, obviously I'll do PCCs on Zoom.
PCCs, pre-trials, arraignments?
We tend to schedule our arraignment pre-trials together.
Okay.
And if there's a good reason, like your client's 300 miles away or got a new job and can't get the time off, something like that, then I'll allow a pre-trial to be done on Zoom.
So the only reason I asked, Judge, is because if we can avoid driving down there, which I don't mind driving down there, and I love your fair community, it saves our clients a tremendous amount of money, and I just wanted to find out what the court's view on that is.
Sure. Well, I think I gave it to you.
Okay, thank you very much. I appreciate it.
Yep, and I've got Mr. Sandoval back on. So, Mr. Sandoval, I understand you are going to waive the your right to a preliminary exam today. Is that correct, sir?
I don't know what I'm doing because I wanted to speak to him yesterday and I don't understand what's going on right now. I never heard from him
Counsel,
yesterday.
you want us to throw you in a breakout?
Yeah, why don't you do that, Judge?
Yep. Michelle, can you put these gentlemen in a breakout room, please?
Yep.
And Mr. Kuja, are you ready? We've got your client. I think we've got him. Yeah, we got him muted.
Yes,
Mr. Al-Khatib?
Yes,
There
I'm
you go.
Yes,
All
we're ready,
Mr. Kuja, your appearance?
Good morning. Jamil Kuja appearing on behalf of Mohammed Al-Khatib.
All right, what are we going to do today?
Your Honor, I was asking if we could set the matter for preliminary examination. I think the court only does it on Wednesdays. I'm just not available next Wednesday. If we could have February 14th, please.
Are you available on March 6th? That's my next date.
Oh, okay.
Exams we tend to keep. We don't pass on to the benchmates.
I see. Yes. March
12
6th.
noon?
That'll work,
I
Judge.
knew we said already. Yeah, I don't know. We already said. All right, 12 noon on March 6th. Mr. El Khatib, that work?
Yes, Your Honor.
All right, bond is continued. Gentlemen, enjoy your day.
Thank you, Judge. Have a good day.
Mr. Mohammed, you got anything ready?
Yes, so Madam Counselor would like to go on the record for Wickham and set a motion hearing.
Wickham?
Vermin.
Vermin with a V?
Bruman.
Bruman with a B. B like boy.
B as in victim.
V. I'd love to go on the record with that one, except I don't have a file.
That's only a pre-hearing, that's only a ticket.
Oh, that's a civil matter? Civil infraction?
Civil infraction, yes. Mr. Mohammed, do you have that ticket with you or that piece of paper?
I can go check.
Yeah. What are we trying to do with it?
Your Honor, we've asked for discovery in this. I know it's a civil infraction that's not typically provided.
Right.
But, APA Mohammed has agreed to provide it. There's some video that the trooper has here on a computer with
Right.
him. He doesn't have a copy to give us on hand.
Right.
But his sergeant said he would get us one.
Sure.
The intention is to review it. There may be a forthcoming motion to suppress.
Okay.
So the idea I thought was we could set a motion hearing / formal hearing.
Sure.
Even though I don't have a motion filed yet, and then if I don't file.
No
it,
problem.
resolve.
No problem. Easy
Okay.
peasy. Easy peasy, yeah. You got a date, Heather?
Any of those days.
Yeah, basically any Wednesday.
Okay.
And just one request, does the officer trooper have to appear on that day?
I don't know. I don't know your case. If he was the trooper that issued the ticket, probably.
For the motion hearing?
Yeah, because if
It's a
the,
motion to suppress reasonable suspicion being an issue, so I would say.
yeah, I would say probably.
Oh.
Because depending on what happens with the motion, we're gonna have a formal hearing that day too. Right? That's your intention. Yeah, yeah. Obviously, if it resolves ahead of time, you can let the trooper know and we save some drive time.
Yeah.
Which I'm assuming is possible depending on discovery.
100%. If we
Yeah.
don't file a motion, I'll be talking to you about a resolution.
Yeah.
February 28th. Is it in the morning, I assume?
What do we use? We're gonna do that at 11 o'clock?
That would be on Zoom, so whatever. Or,
How are we doing that on the other judge's dockets?
well, this time, so is this coming back to us?
Well, not if you tell me any Wednesday.
Well.
You told me any Wednesday, which made me think we were.
Final motion.
Yeah, let's keep it then.
Then, yes, let's go to March.
How about March 6th? Are you available March 6th?
I could be in the afternoon.
Probably,
For the following week and then, or late in the morning. I mean, it's up to, I mean, we can't, we're
What-
here in the afternoon.
March 6th. What we're doing March 13th? That's the one we got all the exams.
March 13th is when we have all the.
Yeah, we don't want to do anything more.
I mean, but if she's available in the morning.
Then he's not available in the morning. He's doing all his pre-trials in the morning.
You can add it to the stack.
10:45.
Try to 10:45 and hope you can get wrapped up by then
Yeah.
on the 13th.
March 13 at 10:45?
Correct. So I got no paperwork up here. So you're putting in the system. They got their calendars. We're good.
Yeah.
Okay.
Give them a notice.
All right. And counsel, I'm assuming if you're gonna file a motion, you'll get it to council within a couple of weeks
Certainly.
prior.
Or let him know that I won't be filing one.
That'll work too. Well, you're gonna let him know that because then you're gonna try to resolve it. Got it. Okay, anything else?
No.
All right, thanks, Troop. Be safe.
Thank you.
You're welcome, counsel. What's your name, by the way?
Lacey Riley,
How come we don't see you?
because I'm in Lambertville, Michigan.
Oh, that's why.
I live in Toledo.
Yeah.
So, but we represent this carrier all over.
Sure,
So you
sure.
may see me again.
Good client. Yep. All
Hold
right.
on 1 second.
We're gonna get you written notice. I just found out one of our local prosecutors is living in Toledo.
I'm sorry.
I just found out one of our local prosecutors is living in Toledo and drives up here all the
Oh,
time.
It really isn't
Belleville.
that drive.
No, actually, it's a nice drive.
Yeah.
I mean, if you gotta go for an hour, it's a nice drive for an hour.
Hey, put it for a
a motion hearing just in case you do file that motion? Great. If not, it'll just be for whatever hearing you guys are meant for. Understood.
Thanks, counsel. Have a great day.
Thank you, you too.
Sir, what are you here for?
I'm trying to get his notice.
You're getting a notice.
Or you smoke? Yes, I don't smoke. All right.
Yes, sir, that will be here. Thank you.
Anybody wants a shotgun? Shotgun? He's got two of them. He's got a Mossberg 835 with 2 barrels and a Cabela's brand scope. He wants $375. That ain't a bad price. Then he's got a Mossberg 930, which is a semi-auto slug gun with a Cabela scope. He wants $500 on it for it. And then he's got a Marlin 35 Remington with a Leopold scope. He wants $900 for.
What's 35? That's odd. That's odd. Wow.
It's not really. It's pretty much a lever action round. It's 35 caliber. It's like a 30-30 on steroids. You know, it's 35 instead of a 30.
It's what you call it, double.
Bottleneck, yeah.
Yeah.
Yeah, as a matter of fact, the new 360 hammer they got out, they developed, which is a straight wall cartridge. That's pretty much ballistically, it's pretty close to 35 from what I read. Yeah. Yeah, it's an old lever action caliber. Yeah, the price is right though. How much? With 2 barrels? That's a pretty good deal.
Yeah, that joke right
Yeah, I got excited when my nephew said, Mike at work has 3 guns if you're interested. And I opened the bundle, I'm like, ah, shit, Mike knows what they're worth. And he's basically, I got retail prices on. I don't buy them unless it's something I want. I don't buy it unless I'm my wholesale price. You know.
I know the Remington.
Mm-hmm. Yeah. That's what it sounded like. Mm-hmm. Okay, take it.
I was, he asked me a question, and that's the way I am. It started driving me nuts. So I started researching it real quick. Your Honor, you can recharge. That what I had stated isn't accurate.
Either way, I think that
you absolutely can. For some reason, I was adding a component that states that the prosecution had to show there was a basis for refiling.
Right.
What actually happens is per the statute. This is kind of interesting, at least to me.
Let me get this one taken care of. Counsel, are we ready on Sandoval?
Yes, Judge, but there's a bit of a wrinkle. I've had a chance to speak with my client. It's my belief that he needs to have a forensic examination.
Okay.
So I think that we need to get him ordered into a forensic examination for now.
For competency?
Both. Judge, do you have the orders on that, or do we submit that to you?
Well, if you, yeah, they've tightened things up. Competency is not an issue. I can order competency. If you want criminal responsibility evaluation, then you need to put us on notice that you plan on asserting the defense of insanity.
We are putting you on notice. We'll do that in
All right.
writing.
That would be helpful. Thank you.
Yes, sir. I'm always trying to curry favor with the judges.
It's always a good idea.
My dad used to tell me, you got to know three things. You got to know the judge's legal assistant, and where the coffee is.
I always tell new attorneys, make friends with this court staff, and even if the judge doesn't like you, can still get some stuff done.
That's exactly right. My dad also
Yeah.
told me to make sure I knew where the restroom was, because that was an important thing.
That is important to know where the restroom is, regardless of where you're at.
Yep.
All right. So we'll continue bond. I made a note in the file that competency and responsibility evaluations are ordered. And anything else we can accomplish today?
Not that I'm aware of. Judge, is there a reason to have my client on a tether right now? It might help him if he could get out and get some work.
I can't have that discussion without bringing the prosecutor in, so just hang out and we'll get the prosecutor back in here.
Yes, sir. Ryan, you are on tether, aren't you?
Yes.
Do you have a job to go to if you can get off the tether?
I could find one, yeah.
Okay.
Hey, Ken, can you get Mr. Mohammed to step in here? Mr. Mohammed. Thanks. Mr. Sandoval, can you confirm your address and phone number with me? I've got an address on Colbert Avenue in Ramos. Is that correct?
Yes.
And a phone number ending with 7558. Is that also correct?
Yeah.
Thank you. Mr. Mohammed, your appearance on the People versus Sandoval, please.
Good morning, Your Honor. Mohammed on behalf of the people, P86771.
All right, so bond is currently set at 50,000, 10% with a GPS tether and no mood altering substances. Counsel just asked me to schedule Mr. Sandoval for evaluations for both competency and responsibility and asked me to terminate the tether requirement. I wanted to give the people a chance to weigh in.
The reason why I'm asking for that, Your Honor, and also Mr. Mohammed, is my client would benefit from being able to get out and get a job, but it's hard to do that with a tether.
Yeah, and so I'm objecting. I do need to go grab my stuff and just review it.
Go grab your
very,
file.
very briefly.
That's all right, grab your file. We got a minute. Pardon me? Judge Martin. She doesn't have any clarification. You okay?
Yeah.
Need a cough drop?
No, it's not.
Mr. Martin, are you ready?
Good morning, Judge Oakley. Yeah, we're ready to set Mr. Lazaire for an exam. That's
As
all.
soon as this one's done, I'll get you up here. Counsel, we're looking at March 6th or April 17th if you want to start looking at your calendar. Mr. Martin, if you want to look at your calendar, March 6th or April 17th.
Can we take the April date?
Sure.
That was April
17th.
April 17th.
11:30, 12 or 12:30.
April 17th, 11:30.
All right. Was there? All right, Mr. Lazaire, you got that? April 17th, 11:30 in the morning. We'll get your written notice in just a few minutes.
Sounds
Bond is continued?
Yeah. Thank you.
You're welcome. Oh, hold on. Looks like we've got a pretrial coming up on another file tomorrow, assault and battery charge. Out of,
Yeah.
you know about that one?
Yeah. Yes, sir.
When you're ready, Mr. Muhammad.
Hey, Judge. Thank you. Yeah, Judge, the people will object to any amendment as to bond. Not only does this individual, Mr. Sandoval, have a criminal history of robbery along the lines of other things. In this case alone, he was resisting police officers, and officers asked him to stop, and he just took off running in the yard, fleeing from police officers. So not only do I believe he poses a danger to the community.
How did you
based off of his
tell him we have a camera?
Hold on, Mr. Sandoval.
based off of his history of committing crimes, but also in this instance, for this case, he was attempting to flee from officers. So the people are objecting to any amendment to bond, and that's the thing.
Thank you. Mr. Daly.
Yes, sir.
When was Mr. Sandoval last employed, if you know?
Mr. Sandoval?
Oh, 2 years ago at my dad's work.
Where was that at, sir?
It's Chrysler, Dodge, Jeep, Ram on Telegraph in Taylor, Michigan.
Thank you. And who is speaking, please?
I'm his girlfriend.
Name?
Caressa Drillard.
Thank you, Mr. Yard.
You're welcome.
Mr. Daly, anything else?
No, Your Honor.
All right. I know it's hard to get a job with a tether, but if he hasn't worked in 2 years, job's not on the top of his priority list, so I'll leave bond as is.
Very good, Judge. If he is able to achieve a job, can we bring this back to your attention?
Always willing to hear a bond argument.
Thanks, Judge.
All right.
Are we?
Have a good day, gentlemen.
You too. Take care.
He had to talk about something. Okay, I'm ready to hear you. Yeah.
So I think we're just using terms interchangeably.
No, competency.
Oh, yeah. Thank you.
The attorney thought he had it worked out, and then the breakout room this morning convinced him his guy needs some help. Go ahead.
I definitely had that sound. I think we're just people are using the terms interchangeably. So
That's kind of what I've always thought.
there is a slight difference, but it doesn't have to do with refiling.
To me, I always hear nollie pros as this is the prosecutor doing it, and dismiss is like it's the court doing it.
It's correct, and here's why. It's because of this requirement of this specific statute. And I just don't think anyone makes anyone do this probably. So MCL 767.29, which deals with the discontinuance or abandonment of an indictment. It says the prosecuting attorney shall not enter a nollie upon an indictment without stating on the record
why
the reasons for the discontinuance or abandonment, without the leave of the court having jurisdiction try the offense charge hearing minutes.
Mm-hmm.
Here's why. Dirty pool of prosecutors. They've had juvenile waiver cases where they've attempted to move a case to like the juvenile courts, like remove it to circuit court. There's been monkeying by prosecutors' offices where they don't like what's going on in a juvenile case because there's a separate statute that goes with it that says.
So then now they so they can charge when you guys over.
It's like you can't, and basically you can't use a no. That's a great question. Like I know it came up on something I had before.
Her question.
So really, if we're going to hold prosecutors to their task, they should do a motion to dismiss without prejudice if they don't want to get into the why.
Right.
But for like what we did today.
But of course, she makes a motion to dismiss. She's got to tell me why. It's a motion, so explain why.
Because you can deny.
We're not ready to proceed. We don't have a complaint.
So it does sort of seem to be interchangeably, but
although I've always looked at it this way: how am I going to deny your motion to dismiss?
It's the problem. What's interesting. The only place I've heard actually do that in circuit court judges, and they usually gets
dismissed eventually.
It gets overturned once they refuse it. So it'll be an interlocutory appeal to file.
Right.
Let's say it's prosecutor discretion.
Right.
End of the day, if they say there's no case.
Because trust me, I wanted to dismiss it when I've had those cases where the prosecutor keeps refiling because the complainant keeps not showing up, and the prosecutor's office doesn't have the balls to say no.
Yeah.
We gave you 3 chances.
That's
no.
it.
Yeah.
Interesting.
Yeah.
I've been off the clock since you said it. I was just more curious.
Well, I appreciate
You
it.
know my brain works.
I know.
It's one of those
I
where
know.
you can't let it go.
I appreciate it. I appreciate it.
I'll see you guys tomorrow morning.
All righty.
Josh.
Which file, Ms. Mainrick?
We are ready on Hallowell. I think we're.
She's saying Hallowell?
Oh, it's a pleasure.
Don't move that way.
But you need to tell my.
Oh,
Don't
Samantha. Appearances on Samantha Hallowell.
Good morning, Your Honor. Patricia Mandernack for the people, P84088.
Good morning, Your Honor. May it please the court, James W. Murray. I represent defendant Hollabaugh.
Samantha Hollabaugh. Aye.
Thank you.
Your
You
Honor.
can sit down, ma'am.
Okay.
The attorneys are trained to stand up.
Okay.
Go ahead.
Oh, I'm sorry, I can't help.
It's okay. It's okay. I'm okay if you're seated.
Okay. Oh, it feels weird. Your Honor, today is the date and time set for the final pretrial in this matter. The complaining witness is present. However, we have a discovery issue in this case. In this case, the incident was originally reported, I believe, with a 911 it was reported by both parties with a 911 call to, I believe, Browntown Township PD. They were rerouted to Taylor. The parties appeared at Taylor PD, and then they were resent to Romulus. The issue in this case is that I have reached out to my OIC multiple times. I have been unable to obtain any of the information and the 911 call from Brownstown Township, the 911 call to Taylor, or any of the body cam or surveillance video from Taylor.
Right.
So at this time, I've been unable to turn over discovery to defense counsel as required, so I'm requesting that the case be dismissed.
I'm assuming there's no objection.
No objection to the dismissal. Your Honor, there are some other things on the discovery, but I'm not going to get into that.
Okay.
Because I don't think it'll be relevant if there's a dismissal.
Okay. And I don't have a cash bond to deal with, so we're good to go.
Thank you very much, Your Honor. Nice seeing you.
Nice to see
Thank
you.
you, Judge.
Had a nice long conversation with Tom White last week.
He told me that, I think yesterday.
Yeah.
That's awesome.
Yeah. Yep.
That's great.
Yeah, it seems like his head's in a real good spot.
Correct.
Yeah.
Correct.
Yeah.
He appreciated that, Your Honor, a lot.
Oh, I didn't feel like I was putting myself out.
No,
Yeah.
I don't think so either, but just the fact that you gave him some time.
Yeah. When he first approached me, he's like, I don't know if you're comfortable with that. I'm like,
Right.
Tom, you didn't escape. You know, you did everything the right way. You're done.
Yeah.
So
Right.
yeah.
Yeah.
No, I'm a big one on redemption and second chances.
100%, Your Honor.
Yeah.
Thank you so much.
Thank you, Your Honor.
You're welcome, ma'am.
Thank you. Pleasure. Till the next one, no problem. Thank you.
Well, probably because the feds are all located downtown, it's easier for the West Coast to come out and do it.
I thought you were telling me he's lucky he's alive. I was gonna agree with you because the little bit I read of the report, I mean, that was a pretty heated situation. Violence cops didn't fire off any rounds. When they arrived on scene, they could hear gunshots. I mean, it was a hot scene when they got there. Wow. Yeah. It's history. Well, he's got enough to be a felon. So.
That's a real felony. That's not, you know.
Yeah, that's not third offense drunk driving.
Yeah.
All right. Moving slow today.
I'll go check our temp.
Thank you.
Folks, now we're gonna do exams.
You have a whole ton of no-shows now. Yeah, I think we're down. I gotta get some on my truck.
If you want to take down that letter to mail, it's in that basket on my desk. check in when we're ready or no? Yeah, if you're ready. Okay, yeah, we're ready on, Jamie McKee. And I'm also standing in for Vanessa Hamilton. Michael Smith, and I'm very unhappy in custody. And what are you doing with it? With Michael Smith, I'm actually gonna ask for an adjournment to see and Jamie McKee for waiting. Okay, so with Smith, we can work on a day. Okay. And then, but with McKee, we will have the judge come out to the waiver. I think he just ran downstairs. So, and is there a form for me to just, McKee? Yep. You guys can sign. And then whenever the judge is ready, he'll do his signing. Here's on McKee. And then. Or we can have Mr. McKee come in. Okay, yeah. I was just gonna remember if I did this before. For Smith. Now, he's obviously in custody of other things. Yes, he's not in custody. I've never seen him. Is Oakley gonna be in? No, it's Judge Green, so they would be by Zoom. Okay. And it would be probably available by Zoom. Okay, and it'll be at 8:30 because he's in custody. Okay. And I'll have
Services. I can't believe nobody showed me that. Did we do it on Zoom or something?
He hasn't appeared yet. He actually has 2 cases. So maybe he's coming in on. Yeah, he has a case at 11:30, so he's probably gonna handle it then.
Okay.
Because isn't it just
The commercial ticket.
right, but is it just
Registration, yeah.
It's just oh, but it's no, it's just. Where's her note?
Oh, this is that.
Yeah. Oh, but this one's for Vanessa. Are you guys Vanessa before?
She's out there.
No, no. So just email it to her? Yeah. Okay, yeah. Sorry, email. No, that's fine. Well, that's good. What kids you on? Adrian? Am I pronouncing that right?
This is a form.
How do you pronounce your last name? I was holding.
So
Well,
what it says is that
the
you
discovery
understand
issue,
you
the
have
judgment
an
and order,
attorney,
so we'll see.
which you have, and the right to request a court appointed attorney, which you have, you're financially unable. So it must be shown. So the government has that burden. Now, you're voluntarily waiving that right to obtain. You understand your how much it is in very concerned about that. And then you put in that. Notice of the 2 charges and any sentencing.
So just to charge to do some amount of probation.
But you're not.
You're not leaving, are you? I'm just gonna go back there.
Oh,
You want us here?
You can stay there because he's gonna call you up.
Okay.
Should I have Mohammed write it up, because we're just doing an adjournment on.
Yeah, just do an adjournment. Yeah.
Thank you. Report orders on which we.
All right. 34th District Court back in session.
Have a seat.
There's basket work and there's a note from Carol that I think with your knowledge downstairs, you might be able to Carol make sense for me. Are we ready on McKeith?
Yes.
Appearance.
Good morning, Judge Hannah Barron from the Neighborhood Defender Service, P85265, representing Mr. McKeith. Mr. McKeith, can you please say your name for the record?
Good morning. What are we doing?
Judge, I believe Mr. McKeith is waiving his preliminary examination.
Let's find out. Mr. McKeith, you've discussed your rights and options?
Yep.
You understand those rights and options?
Yes, Your Honor.
You understand the purpose for a preliminary exam?
Yes, Your Honor.
You understand that if you waive the preliminary exam, I'm going to send the file downtown, so your next court date's at the circuit court level, not at the district court where you're at right now.
Yes, Your Honor.
Understanding all of that, are you waiving that freely and voluntarily?
Yes, Your Honor.
And Judge, I just would like to clarify one more thing for the record, that Mr. McKeith is waiving his preliminary examination on the representation that he'll receive HIDA at the circuit court.
Fair enough. True. All right. Anything else? All right. I've signed the paperwork. You've signed the paperwork. I wish you luck downtown.
Appreciate it.
Thank you.
You're welcome. Are we ready on Teagueman?
I'm ready. I don't know.
Do we need a prosecutor?
We
Maybe.
need to address a discovery violation, Your Honor.
Okay.
We do need a prosecutor.
All right. Is that Mr. Mohammed?
It is.
All right,
He's
well-
in the hallway installing because his officers aren't here.
All right, we'll get him in. Well, this is the one where you're going to convince me you need digital, right?
Well, you signed an order for the audit log for the supposedly missing body worn camera, and
I have yet to receive said audit log,
Okay.
which is a simple printout.
So this is the one that I said I did a lot of exams before we had digital discovery?
No, it's a
Different one.
separate older
Okay.
one.
All right.
This is,
He's almost here. He's got a little bit of a squirrel problem. Have you noticed that?
whatever shiny.
Squirrel. Sister counsel stopped him in the hallway with a question, I think. All right, appearances on Teagueman.
Good morning, Your Honor. Mohammed on behalf of people PA 6771.
Good morning, Your Honor. Sophia Nelson of Neighborhood Defender Service. On behalf of Mr. Teagueman, P 77960. Mr. Teagueman is present with me in court today. Can you please state your name for the record?
Eric Teagueman.
Your Honor, on the 5th of January, this court signed a discovery order for the audit log for the body worn camera of Officer Williams, who responded to the scene and took the statement from the complaining witness.
Why did I have you on a Friday? Should have been January 3rd, right?
I'm going by what's in the ROA.
Yeah, and I'm looking at my notes and they're stamped January 4th.
I think I submitted
Had
it
to be
on the
the-
Wednesday, and I don't know when it actually got signed, but
Okay.
the register of actions says that it was filed on the 5th.
Either way.
And I have not received the body worn camera audit log for Officer Williams. So Axion, the body worn camera system used by the Romulus Police Department, has the ability to print off what's called an audit log.
Right.
For every body worn camera, and it shows for the shift that an individual is working whenever the body worn camera was activated and deactivated, whether it was in working order for that day. And it automatically stores that information when after the shift, the body worn camera is docked.
Let me stop you. I want to make sure. So the audit log is going to tell you when an individual camera goes on or off.
For that officer.
Thank you.
And at the time, and Officer Williams is the responding officer to the scene that took the statement from the complaining witness in this case. Obviously, Romulus Police Department's policies require that officers activate their body worn camera whenever they come in contact with civilians, which is the whole point of a body worn camera. The representations from the OIC in this case is that there is no body worn camera for Officer Williams, which I said, fine, I want to see the audit log. Your Honor ordered it. It's not been produced.
Shame on you, Mr. Muhammad. Explain yourself.
Judge, so in regards to the audit, I did email, well, Officer Rice was emailed on January 8th in regards to this audit, and he said his response was, we do not have anyone who audits our body cameras. So there's nothing to hand over because it doesn't appear that it exists.
And if I understand Ms. Nelson's correctly, you're saying it's part of the Axiom system. It's like an internal
Correct.
audit.
And I've received it in many cases. It does exist. I've gotten it before. It's
Who does tech for the Romulus PD? And you probably don't even know.
I wouldn't know. Detective Rice did just step out. I can get that.
Yeah, let's find out. Hello. Wonderful. All right, so who does tech for Romulus PD?
So Judge, I don't know who actually does it. I don't know if our IT does it or if our records bureau, because I remember this, that I have no clue what an audit is myself.
Yeah.
So
I'm taking counsel at her word.
Yeah, that's
because she says Axiom, it's like an internal part of the system, and she's seen it in other jurisdictions.
not just in other jurisdictions in this one.
Other departments or in Romulus?
Other
If you know.
departments, but any department that use Axion has the ability to print out an audit log for an
Okay.
individual body worn camera.
Okay, all right.
So I just checked this morning, there is not, like, that day in question, it either didn't work, or, you know, I don't know if it wasn't on, I wasn't there, you know, sometimes the officers just do not turn them on,
Right.
certain days. I don't know, I don't want to speak for
Right.
someone. But
Yeah.
I don't know who does that audit, I can try and call and find out, and see real quick,
Well, it doesn't sound like anybody does the audit. It sounds like it's just part of the Axiom system. Somebody's got to know how to access to provide it.
correct. So I assume our IT would, but I don't want to make an assumption if I don't know that.
All right, well, I'll tell you what. Ms. Nelson, I'm gonna give him time to make a phone call or two, because at this point, I've got an order that was not followed, and I don't make myself a liar, so I'm gonna dismiss this case if we don't have something. So give us time so Detective Rice can make some phone calls.
Can I get 1 minute to step outside real quick?
I don't need you on this, because he's the one that's gonna try to figure out what happened or what can happen, right? Okay, yeah, take your time. Take your time.
You're on.
Yep. You got something ready?
No, Your Honor.
We're just waiting, we got 3 minutes scheduled.
With Mr. Mohammed?
Yes, sir.
Okay, I guess we'll have to wait for him then. What's the file name?
I have another, file, it's, a transportation misdemeanor. I already spoke with Mr. Mohammed about it, I think we got it resolved. But since I just rolled in, it's for, Sandman Trucking. It was scheduled earlier, Your Honor, but we talked about it yesterday, and he said it's coming when I went to my prelim.
Do we got a file on that one, Heather?
We should, because it's.
Oh, you know what?
It's probably in your notes.
Yeah, it's in the no-shows.
So I gotta wait to get the write up out of Sandman, so I'm ready to go for the prelim whenever.
Okay. And Mohammed's doing some paperwork on Sandman?
Yes, sir.
Frank, how do you say your last name?
No.
No? What's your client's name, Mr. Mullins?
Back.
Back is with a B.
I've been known to sloppily speak.
I've been known to sloppily hear, so. All right, back has got it. All right. So I've got both your files when we're ready.
Thank you, Mayor.
So having fun?
Are you observing?
She wants to be a judge, so she's been bouncing around between the prosecutor's offices, the MIDC, just kind of being heavily exposed today. Yeah, it's pretty fun. Gentle Joe. Mr. Mohammed, are you ready on either Bacchus or Sandman?
Yeah, I'm ready on back.
Okay. Oh, you lost Mr. Mullins now.
Yeah.
I have the FIP charge in my office. Can I grab it? The certified records.
We're making you just do all kinds of stuff.
No, it's okay.
You're getting your steps in. I don't know what an FIP is, though. Back row, what's your name? Stokes? Who's your attorney?
It was Crystal Medina.
Have you talked to an attorney today?
Yeah, they said I'm waiting on paper. Yeah.
Oh, they're waiting, you're waiting for an adjournment, correct? No. Yeah.
Yeah, we don't talk to anybody on that one. So I don't know what the next one is.
I think she was waiting for him to, the prosecutor to write the notice, but she left.
Well, let's see if Mohammed knows what the agreed date was. It's not moving. It's not flowing. It's not flowing. You got sidetracked again.
Medina
so-
left.
Huh?
Medina left.
Right.
Yeah.
So.
Muhammad's getting it from everywhere.
He's being pulled all over the place.
And back, this is here all.
Mr. Muhammad is getting pulled in at least 3 different directions, and I'm ready to pull him in the 4th right now.
So Sergeant Otter is trying to find out. Handles that.
Okay.
Judge, we're gonna have a resolution on it.
All right. I know you're getting pulled all over. On Stokes, Miss Medina's client, I think there was an agreed adjournment.
Yeah.
Do we know what it was?
Yeah, we got it.
Okay. All right, Mr. Stokes, we're gonna get you out of here, brother. Ryan, bring it up. Thank you. Got it. Okay. We're gonna get your written notice, Mr. Stokes. Now that we're doing this Valentine's Day. I don't care. 10:30? 10:30 on February 14th work for you, sir? Wear red, it's Valentine's Day. That's all right. I'll at least have a red tie on. If I don't forget. Not a problem. Grace, you getting your questions answered?
Yes. That answered everything. Excellent.
No problem. We'll have you back here any day you can come.
Thank you so much. I really.
As you can see, Wednesdays tend to be a little bit
The best day.
exciting. And just so you know, if you want to, especially on Wednesdays, because Wednesdays we can guarantee there's going to be something to watch. Okay. You don't have to set it up ahead of time. Just roll in, tell the guys at security, I'm just here to watch. Yeah. No problem. Oh, I'm still willing to sit down with you as soon as we get a break.
Well, I think she's gonna be an attorney or a prosecutor. She doesn't, she's got all that side and she obviously seems pretty excited on that side.
Oh, one thing you'll find about people in this profession is most of us really like to talk about it.
There's lots of officers here too.
You don't want to be a cop. And I don't think you'll find a single one here that would try to talk you into it. Yeah. Oh, whenever you gotta go. Yeah. You got any questions for me? I was in private practice. I hung up a shingle after law school. So I was in private practice and I had gotten tired of the business end of it. people that came in crying, you fix the problem, then you send them a bill for $300 and they complain. You know, just that kind of stuff. And I was trying to figure out how I was going to change my practice so I wasn't having so much of that, or find something else I could do with my law degree. And at about the same time I was going through that kind of soul searching process, Judge Green was elected. And when she was elected, she was 31, I think. Do you remember? The joke was she wasn't as old as the courtroom, which was 34. And it really changed the way I thought about judges, because back then, pretty much judges were attorneys that had been in private practice for a long time, most of them old white men, in our area at least. And as a semi-retirement gig, they got on the bench somewhere because there was a benefit package, whereas most private law firms back in the day, you didn't get a retirement package, you know, you probably didn't get any kind of health care, right? Especially if you were a sole practitioner, you know, unless you paid for it yourself. So it's kind of like a semi-retirement gig. Well, when she did that, I got to thinking, well, wait, maybe I don't have to wait until I'm, you know, 60 years old to think about that. So, and I was always involved in community stuff. So I thought, all right, I got a law degree, you know, that I worked real hard to get myself through 7 years of school. I like to be involved in my community. Hey, in 1998, lost by 1.131% of the overall vote. And it was really funny. And we always had a great relationship, Judge Linus and I. And then when I ended up working with him after I got elected 2 years later, we always had a good relationship. But the day after the election, and we got along fine during the election, we'd meet somewhere and I'd give his wife a kiss, he'd give my wife a kiss, we'd shake hands. It was all very cordial, the way politics can be and should be. So the day after the election, Susie and I are headed up north. We're getting away because it's been grueling. So I called his house to congratulate him, and his wife said he was still sleeping. I said, don't wake him. I said, just tell him I called to congratulate him. She says, Brian, you won. I said, no, Ann, we didn't win. I said, what time did you guys go to bed? She said, oh, it was about midnight. I said, well, Huron's last votes didn't come in until after 1. I said, I lost. She said, are you sure? I said, absolutely. That's why I called to congratulate you. She said, I'm going to wake him up to tell him that. That's how close it was. Yeah. So anyhow, long answer to a short question. I love the practice of law. I didn't like the business end of it. And I was trying to figure out what to do with it. Yeah.
Did you get elected or appointed, Judge?
Elected.
Okay.
Yeah. And looking back on it now, there's no doubt in my mind that it was completely meant to be. I think I was called to the bench. I think there's a lot of things in my life that God just made fall into place the right way. So yeah, until COVID, it was a great gig. Yeah. Yeah. COVID changed too many things to suit me. Are we ready on Teigman?
Yes, we have a resolution, Your Honor.
Tell me all about it.
Yes, so the representations from the OIC and the prosecutor's office, because the complainant is here, is that if Your Honor was to dismiss this case, they would refile. I have discussed that with my client. We've come to a resolution to a plea to the high court misdemeanor of joyriding. I'm going to give you the MCL code, but my internet.
Yeah, give me the NCL when you find it.
Sorry,
That's all right.
You leave your computer too long and it.
Hey, Joe.
So he's going to plead to motor vehicle use without authority, but without intent to steal, MCL 750.414. That's a 2-year misdemeanor. We've come to an agreement, Your Honor, to a 6-month term of probation with drug treatment. and restitution in the amount of $350. I would ask that this court consider waiving not discretionary costs and fines in this matter, because restitution is going to be quite the challenge for Mr. Keaton. He's currently homeless, and as is reflected by the fact that he needs drug treatment, struggling with addiction, which is the underlying cause for, and the prosecutor can agree, the sealing of this, or the temporary taking of this vehicle. He does want to make the complainant in this case whole for the cash that he took out of the car.
Okay.
So that would be his priority.
Sure.
And I would probation, hopefully he's expressed interest in treatment. I'm hoping probation can refer him to treatment services to be completed.
Yeah. All right. So Mr. Teigman, we're using a Caseville Road address in Westland. Is that a good mailing address?
Yes.
Okay. All right. Physically, where are you laying your head every night? You bouncing from couch to couch? What are you doing?
Yeah, what the Westland address and another friend's house. So
Okay.
I'm, not in the streets.
Okay. All right.
He also, I mean, at the time of this was at an extended stay motel. So he's
Yeah.
bouncing around.
Yeah. So there's where all his money was going. So I don't like to order treatment
Okay.
without any kind of evaluation. So what I'm going to order is a substance abuse evaluation. And then based on that evaluation, whatever level they think you need, that's what I'm going to order. Understood?
Yeah.
Okay. All right. So you understand the possible penalty for this new charge?
Yes.
And you understand your rights and options?
Yes, sir.
All right. Understanding all of that, are you pleading guilty freely and voluntarily to the added charge?
Yes, sir. Yes.
All right. Would you like to voir dire to give me the facts?
Yes. And obviously the felony is going to be dismissed.
Correct. Correct.
Mr. Teigman, on or about November 23rd, 2023, on Marion in the city of Romulus, County of Wayne, were you present at a gas station? And at that gas station, did you take a vehicle and drive it away from the scene that you did not have permission to use?
Yes.
All right, no further. And was that vehicle a Lincoln MKZ?
Yes, it was.
Okay, no further questions.
Are you satisfied?
Yes.
Mr. Mohammed, you satisfied? So am I. One other thing, I'm not going to put you on for 6 months. I'm going to put you on for 12 months with the understanding that if everything goes the way it's supposed to, you can always ask me to terminate it at 6 months. But depending on what the treatment plan is, they might want you in for a long time. I don't know.
That's fine.
Okay?
Yeah.
All right. So I think what the agreement was, substance abuse evaluation, restitution of $300, right?
$350.
$350? All right. Okay.
Yep.
All right. All right. So here's what I'm going to do. I'm going to sentence you to 0 fines and costs.
Thank you.
Merry Christmas. $350 restitution. You can set up a payment plan through the probation department. Substance abuse evaluation, which you're going to get information from the probation department. And when you meet with the probation office, tell them you need to speak to Mr. Taylor, who's in that department, because Mr. Taylor's got real good contacts right next door with Wayne Metro, and they've got some programs for homeless folks. I don't know if they can do anything quick for you. Maybe not, probably not. But let's get you tapped into whatever resources are available for you. All right?
Yes.
You got all that?
Got it.
Questions?
No.
No,
Counsel?
Your Honor, thank you.
All right. Good luck, Mr. Tigman.
Use the 750-414.
Nope, it's 750.414.
Right, that comes up still as unlawful use felony.
So I'm reading 750.414, a person who takes and uses without authority any other motor vehicle without intent to steal, or who is a party to such unauthorized use taking, is guilty of a misdemeanor punishable by imprisonment of not more than 2 years. So it's a high court misdemeanor, which for sentencing guidelines purposes is a felony, but is it?
Show up as a felony for the 414.
I suppose, but it is a misdemeanor. It's a 2-year misdemeanor.
In our system, it's somebody as a felony.
I think we could take it. So we'll work it out somehow.
I mean, I can show you right here on the MCL code that it's a high court misdemeanor.
She just, the system's telling her one thing.
Yeah,
So,
yeah. Okay.
okay.
All right, understood.
Thank you. Good luck.
Thank you.
are we ready on Bacchus when they're ready on Bacchus?
He reports to probation downstairs.
Yes.
Okay.
And Judge, in regards to restitution, how do I, explain to the victim how to get that?
Is the victim here today?
Yes.
Beautiful. Ask her to go down to probation counter. Let them know she's here on the Tigman matter, and they'll get all her contact information. So when Mr. Tigman is able to start making payments, we can get the money to her.
Okay.
All right. Actually, you know what? You mind doing that? I want to keep him up here working. All right.
No problem.
Thank you. Be safe.
You're welcome. We'll be back in there for another one.
All right. Bacchus. If they're ready. I don't know if he's trying to talk his guy into something or. Are we ready, Mr. Mullins? We ready?
I'm ready. I just don't know if the victim is here. He's here. Oh, he is here. Okay.
Ryan, did you have some paperwork on Sandman Services?
No one appeared for that. I don't. Yeah.
I thought that was Mr.
Oh,
Mullins.
the registration one. Oh, we didn't have a ticket for that. We didn't have a copy of the ticket.
No, what are we doing on it?
So as long as it reflects that it was a registration issue, I'm gonna dismiss it based off of his.
Just a straight out dismissal?
Yes.
Okay, what does he need it for?
Oh, I thought he said that that's what he needed.
No.
Yes, so for Sandman, it's gonna be dismissed due to, it's just a registration, right?
Yeah, it's registration or plate violation, commercial vehicle. And I've got the actual ticket if you need to compare it. Are we ready on Bacchus though?
I'm ready with it, yes.
Okay. Yeah.
There's no counter people anymore.
Oh, that's right. Even if she just gets his contact info, that's all right. We shouldn't have to sitting down and talking to them.
Right, but somebody had talked, I didn't want to.
Right.
Judge, is it okay if we discuss this after the exam?
Yeah.
Thank you.
Yeah, I'm just trying to do quick stuff.
Yeah.
Yeah.
Thank you.
Yeah, well, sometimes it's not quick.
Absolutely.
I don't have the answers.
Absolutely. So we're ready on Bacchus? All right. Appearances, gentlemen?
Good morning, Your Honor. Mohammed on behalf of the people, P86771.
Good morning, Your Honor. Robert Mullen on behalf of the defendant, Mr. Dylan Bacchus, who's moving up to the table.
Bacchus or Bacchus?
Bacchus, Your Honor.
Bacchus.
Okay, go ahead. Have a
Good
seat.
morning, Your Honor. Miles Drew, also on behalf of Mr. Dylan Bacchus, P number 84554.
Good to see you.
Mr. Bacchus, could you please state your name for the judge?
Dylan Bacchus, Dylan Kevin Bacchus.
Thank you. Nice tie.
No, thank you.
Your Honor,
Yeah,
is
he's
it
been
possible
here.
an extra chair?
Yeah, we'll steal one of theirs because Ryan's already on the pew. We'll put the OIC on the bench when he gets back.
Let me just grab mine. I'm ready to go around this.
We're ready. You ready to call a witness, Mr. Mullen?
Yes, Judge. This is a quick preliminary matter, just for the record.
Yeah.
We request a mutual order of sequestration.
Okay. And given the fact that we've got nobody in the buildings or courtroom except Gracie, we know she's not a witness. We're ready to go.
We've kept everyone that's potentially a witness, either preliminary exam or if a trial occurs out of court. But
Thank
there
you.
is some family support that might be able to do that part of the case.
I'm okay with family support as long as they're not prospective witnesses. Who's the first witness?
So, Judge, it was just brought to my attention that the victim indicated to my colleague that he's afraid of some of the family members that are outside because they advise him like not to move forward with the case or something happens.
I'll let you guys go out there and talk to your victim and make sure we won't let those people in the courtroom if it's intimidating to the victim.
So, thank you.
Yep. I do like that kid. I'll tell you what, being likable will cover up a lot of mistakes.
don't think so. Mr. Drew, you didn't work at the prosecutor's office, did you?
No, I did intern there.
Yeah,
briefly.
intern,
Did
okay.
you come here at all doing it?
No, I was mostly in 36 district.
But you've
court.
been here before as an attorney.
Yes, yeah.
Yeah.
I represented a gentleman on a gun case here maybe about a year ago.
Okay,
Yeah, and I held an exam.
I don't think that was the same tie though.
No. I usually have ties that are in this vein though. Figured it's the
I
one thing in a
like-
suit you can kind of.
I like bright ties.
Thank you, yeah.
Yeah, life is too short for boring ties.
Could not agree more, Judge.
No offense, Mr. Mullins.
That's all right, Judge. As you get older, you get, hey, Judge, remember, nice to have that hair, you know, sometimes you got to throw it around, you know?
If you didn't really want, vending machines and stuff downstairs, or I have real
So Judge,
Yeah.
I think it's in the best, I think the best case is to have this empty, the room empty with no family members or friends. Based off my discussion with the victim.
All right, so my understanding is the victim has felt intimidated by certain family members of Mr. Bagus.
He doesn't want anyone.
Well,
If your victims had no contact with these folks, it's an open courtroom, I'm gonna leave them here. It's not, your victim's not a kid, right?
We're not, yeah, that's what I was gonna say.
No,
I mean,
I'm not gonna close the courtroom if it's not a child victim. If your victims had contact with these people directly and felt intimidated, then that's one thing.
have you had contact with them over 3 years? Not over 3 years, not anything to do with this particular case at all.
Then let's bring your victim in and put him on the stand. Blame me.
Your Honor, the people called Mr. Joseph Backus.
Sure, Martin, you got something else on?
Yes, you have, Crenshaw, so I hope you didn't go Crenshaw.
I don't think so. That would be Joe's fault if I did. I did. Oh, okay.
He was gonna get a hold of him and ask him.
All right, then it's legitimately on Joe's list. Okay. Oh, that's right. That's when you told me yesterday, you're gonna have us late people or early people show up late.
Judge, been brought to my attention.
You know what his options are.
Can I please just have 30 seconds?
Sure.
So you don't lose. Okay, thank you.
She'll be able to courtroom.
I'm sure everyone will hear me. I'm pretty loud.
She asked me to. I answered to you.
No worries at all, sir. Oh, so I push the, so that everything I say isn't being, do I hold?
Yeah. Okay.
All right, thank you, because I'm always talking and saying stupid things, and we do not want to have that recorded. One time I was in federal court doing a trial. You know,
I'm like,
Folks, give me your names loud so you're on the record.
Danielle Watson.
Brendan Watson.
Thank you.
It's not about beating it. Yeah.
sure, no problem. Do you want to do that? I appreciate it.
Yeah, go ahead.
My area.
You heard this officer. This officer.
Yeah. Wow.
All of it?
He's out there.
Mhm.
Yeah.
Nope, have we?
Yeah.
I don't recognize the name, and that's one you should recognize. Yeah, I figured that.
Judge, I'm sorry, do the back and forth. The
Sorry.
witness is coming.
That's fine. Mr. Backus, all the way up here. Watch my step, my incline ramp here. Don't trip up. Raise your right hand for me, sir. Do you swear or affirm the truth, whole truth, and nothing but truth today? Have a seat right here. Settle in that chair and then state your name loudly for the record.
Joseph Backus.
Thank
Your
you.
Honor, I have permission to move so I can see the witness.
Sure, move around.
Thank you. Go ahead, you go back to where you were. I'll just.
Yeah, as long as Heather picks up everybody that's talking, I don't care where everybody's at. Go ahead, Mr. Mahoney.
Good afternoon, Mr. Backus. Can you please restate your name for the record?
Joseph Backus.
Mr. Backus, I'm going to take you back to the day of November 4th, 2023. Were you at the location of 20259 Middle Belt Road in the city of Romulus, County of Wayne?
I was.
And what's at that location?
My father's house, the house I grew up in.
And what took you to that location?
I have a 2-year-old daughter that's never met her grandfather, and I myself never met my grandfathers in my life, and I tried to make a better life for her and give her grandfather a chance to be a part of her life and meet her, because she's a beautiful young girl. She deserves to have all her family in her life. I wanted life to be different for her than it was for me.
upon going there and trying to see my
Okay,
father.
okay, let's
Yeah.
stick to questions and answers.
Okay, so that's what brought me to the house that day, is
I
to
understand.
give my father a chance to be a part of his granddaughter's life.
Okay, thank you. And did something occur?
Sorry.
Did something occur at that location that brings you into court today?
Yep, I knocked on the door. I was not greeted by my father. My brother Dylan answered the door.
Your brother Dylan, do you see that individual in the courtroom?
Yeah, he's sitting over there.
Can you please point to that individual and point out an article of clothing that individual is wearing?
That's the gentleman in the gray shirt.
Your Honor,
Noted.
Thank you. And what happened, if anything, upon interacting with your brother?
He opened the door. He asked me what I was doing here. I said, I'm trying to see dad. I'd like to let him see my daughter. Pointed at my car, so he was aware my daughter was in the car. Upon my response, he reached into his pocket and pulled out a pistol and proceeded to put it in my face and told me I better get to stepping while I have a chance. I proceeded to walk backwards, not breaking eye contact, to be aware of my surroundings until I got in my vehicle, left, got down the street to get my daughter in a safe location and called Huron Township Police.
Okay, and you described a weapon was aimed at you, correct?
Yes, a pistol.
And can you
handgun.
describe this weapon?
Yes, it was the lower part of it was a lighter gray. The upper part was a darker gray or a black. Handgun looked maybe a 9mm.
Okay. And when this weapon was pointed at you, where was it pointed?
That was about 6 inches away from my face, with the barrel facing my face.
And where was your daughter when this weapon was pointed?
Approximately 15 feet behind me in my car, in her car seat.
And when this weapon was pointed at your face, how did it make you feel?
Made me feel like I needed to get somewhere safe for my daughter. You know, needed to leave that location and get out of there because I have a 2-year-old daughter with me and now there's a gun involved in this incident.
Was there any other feelings that you felt when this weapon was pointed at you?
And not really, a panic came over me. I just knew I needed to leave and get somewhere safe.
A what came over you?
A panic, like you know, I
panic?
feel something bad could happen and my daughter's life could be at threat if something happens. So I need.
Did
to
you
leave
fear
this
for your
location.
life?
Yes. I mean, there was a gun in my face.
I understand. Nothing further for this witness.
Mr. Mullins, your witness?
Absolutely.
Now, sir, you wrote a statement in this case when you contacted the police. Is that correct?
Yep.
And you put everything, you were truthful when you made that statement.
Yep.
And is that a yes?
Yes.
And in fact, the only reason you made a statement was to tell the truth as to what happened.
Yes.
And you were not under any restraints in time. No one told you you had only had so much time to fill out that statement.
No, the police met me after I called them and they gave me the statement. So here, can you just fill
They
this
said
out
we
and
have
sign
all
it?
and they said, oh, you didn't have any time constraints in filling out that statement, right?
Objection. Ask
I
and
just
answer.
want to make sure I got that out there.
Yeah, it wasn't clear. Nobody said fill this out in the next 3 seconds and hand it back.
No, they just
They
had
gave you
this paper
time.
and said, here's this, you had all, I actually walked away and sat at my car for a moment, you know, had time to
Got it.
replay the incident in my head. I had all the time in the world to do it. I mean,
Okay.
we did
Okay,
this.
okay, move on, Mr. Mullins.
The individual that you pointed out as the defendant in this case, that's your little brother.
Yes.
He's 5 years younger than you.
Objection, relevance.
I'm just establishing the relationship.
I think it's fair.
You guys have not had the best relationship over the years. Isn't that true?
That's how you like to put it.
Well, I asked you a question. You can say no. That's a yes or no question.
I haven't talked to him in 2 years, so it's kind of hard to say we have a relationship at all.
Okay, and you say you haven't talked to him in 2 years. You haven't talked to anyone that lived in that residence for over 2 years.
Objection, relevance.
What's relevant?
The relevance is the relationship that was going on, whether or not he should have been at that. There's all kinds of questions that's related to the relationship, and it goes to my client's state of mind in dealing with his brother, because there's issues of whether or not it would be reasonable for his behavior under case law as an affirmative defense that even in a preliminary exam you can consider, as well as credibility of the witness. All these questions are relative because these are not normal relationships, Your Honor, of strangers. These are relationships that have been born over years and they can affect people.
I'll allow it.
2 years ago, you were removed from that house that you went to on that day. Police had to is your testimony the police didn't show up and escort you off that property
They
that
did
day?
not escort me off that property. They were there allowing me to get my belongings and leave. They didn't,
Right.
it was never escorted.
You were no longer welcome on that property at that time. Isn't that true?
I don't recall any type of court paperwork or anything stating
I'm
I'm
not-
not allowed to be
I'm
there.
gonna object to the relevance.
I think it's relevant. I think he's right. It goes to the state of mind of the defendant.
You were not welcome on that property by any of the residents that lived on that property.
Objection, speculation. He's speculating to the state of mind. of
It's a statement too, and I don't like that. So
All right.
start asking questions.
Sir, your father did not want you on his property
Objection.
when you
What's your
left
objection?
2
Hold
years.
on. What's your objection?
Speculation. Speculating. to
I think he's trying to ask a question. He's just having trouble asking it in the form of a question.
Understand.
Isn't it true? Your father did not want you on that residence. He wanted you off that property 2 years ago when you left.
I'm gonna object, Judge. Speculation.
I don't think it is. Did your father want you on the property? Well, a better question would be, did your father make it known to you that you were not wanted there?
No.
Have you talked to your father in the over 2 years from when you left the property to when you arrived on the day in question?
No,
On
that's why I was there, to give him a chance to be a part of his daughter's life. It could have been handled better than
All
a
right,
gun in
sir.
my face.
Sir, this is the third time I've asked you to answer the questions.
I'm
Now,
answering them.
you can argue with me, it's not gonna end well for you. If there's a question that's been asked of you and you can answer it with a yes or no, do so. If the prosecutor thinks there's more information that has to come out, he can ask you more questions.
Okay.
But you're not up there to narrate and get your story out. You're there to answer questions. Understood? Try again, Mr. Mullins.
Isn't it true, sir? You did not speak to your father for over 2 years after you left the family home that you lived in.
Yes.
And in fact, you hadn't spoken to your brother in over 2 years during that time period.
Yes.
And you hadn't spoken to your sister in over 2 years during that time.
Yes.
And those are 3 people that lived at that residence on November 4th when you showed up. To your knowledge, if you know.
Objection.
No, my sister didn't live there.
You don't have to answer.
Okay, that's fair enough. And you had reached out to your father during that 2-year period through text messages.
Is that true?
Is it true?
True.
And you never got a response from your father. Is that true?
True.
And in fact, you had asked him about coming over 2 days before you showed up. You had sent him multiple text messages about coming over to visit and did not receive a message.
Not true.
You have never, in those 2 years, isn't it true? In those 2 years, you have never been invited over to that house.
True.
And in fact, when you've had a relationship with your brother for most of his life, right? As his older brother, isn't that true?
True.
And there's been times where that relationship has been physical between you two. Isn't that true?
True. What brothers don't get in fights?
Sure. And you're the older brother, isn't that correct?
True.
And 5 years older. Is that true?
Objection, relevance.
Relevance is to show the age.
Relationship. I'll allow it.
I'm not 5 years older than him.
Are you 4 years older than him?
True.
All right. And isn't it true that when he was 13 years old, you duct taped him to a chair and pushed him down the stairs?
Objection.
Not true.
That's not true?
No.
Are you saying you've never been, isn't it true that you've been physical and beat up your brother in the past?
I think you gotta narrow that down. I mean, if, you know,
well, Judge,
it was 10 and 6 and they had a fist fight, I don't really care.
In the last 10 years, you've beaten your brother up. Isn't that true?
Not true.
Not true? When's the last time you beat your brother up?
Couldn't tell you. The last fight we got into, I actually got 11 staples in my head. So.
When was that?
Couldn't tell you.
Now, during that 2 years that you weren't living there, wouldn't it be fair to say that you had a hostile relationship with both your brother and your father?
I'm gonna object, Judge. The attorney mentioned that he had no contact with him for the last 2 years. So now he's saying it was a hostile relationship for the last 2 years. It's one or the other. Either there was a relationship or there wasn't.
Well, in an earlier question, Mr. Backus said he considered it to be no relationship. So I don't know how it could be a hostile relationship. It was a non-relationship according to this witness.
Just give me just a little latitude here, Judge, and I'll fill that in. isn't it true that you had sent a text message within the last?
Objection, hearsay.
Let him get it out. Don't answer it.
Isn't it true that you sent a text message to your sister indicating, referencing Dylan as the scumbag brother?
Objection, hearsay.
It's not hearsay, it's his statement. If I was.
He's not the defendant, respectfully.
No, it's the witness's statement I'm asking him of. It's not hearsay. He can testify to whether or not he made that statement.
He's not an out of court declarant. He's right here. I'll allow it.
Didn't you refer to your brother as the scumbag brother in a text message you sent to your sister in July of 2001?
What year?
2001, July.
I was 6 years old. I didn't have a phone.
In July,
2001?
I'm sorry,
Yeah, I was 6 years old. I
2021.
didn't have a phone.
You are correct, sir. My math is not as good as it used to be. In July of 2021, didn't you reference your brother as the scumbag brother?
And I'm gonna object for the record, Judge.
Well, would that be something you would say about him?
No.
So your testimony is that that's untrue? Is that your testimony?
Yeah.
And is it also true that in that same text message that you sent, that you called your father a loser
And
father?
I'm gonna object again, Judge, for the record, that's hearsay.
Again, Your Honor, it's a statement.
I don't think it is. I don't
Isn't
think
it
it's
true?
hearsay.
No. Your testimony again today is that you never referenced your father as a loser.
And I'm gonna object for the record, it's relevant.
Now,
Not relevant.
when you walked up to that house with your daughter.
Didn't have my daughter. She was in the car.
She's in the car. And when you came up with your daughter in the car, you didn't know if your dad was there or not. Isn't that true?
Yeah, I can't see some walls, so no, I didn't know who was in there.
So you had texted your dad and told him you were coming, didn't you? So it's your testimony today that you never reached out to your father in a text message that you wanted him to meet your daughter prior to you showing up.
I said, meet my daughter. I never said come by the house.
Okay.
I said I was gonna come by, I said, meet your granddaughter. Yes, that was stated in the text. Would you
And-
like to meet your granddaughter?
And you never got a response. Isn't that true?
True.
And in fact, any text that you sent to any,
Objection.
That's asked and answered. All right, let's move on. I've given you a lot of leeway. Let's get to current events.
so on the date of the event, you said that your brother pulled out a gun. Did your brother isn't it true your brother told you to leave before he even showed you a gun?
No.
He told you to leave 5 times that day.
Did not.
And when he had his gun, he never pointed it at you. Isn't that true?
It's not true.
In your statement, you had indicated he pulled it out of his pocket with the barrel almost inside the pocket. You remember saying that in your statement?
The whole gun
And I'm
was in
gonna
his pocket.
object, Judge, to hearsay. for the
It's
record.
his statement.
He's quizzing you about his own statement he made to the police. It's allowed.
Don't you recall saying that in your written statement?
Yeah, that's,
Okay. And in fact, is it also true that when you interviewed with the police, you identified your brother's gun, right? And is that a yes?
yes.
And is it also true that you identified your brother's gun as a black gun with a silver handle? Isn't that what you told the police? And they interviewed you on 11/4 after this incident.
The hand, where you hold the gun was gray. The slide, the top part of the gun, the slide was a darker gray or a black, is what my
Well,
statement was.
Is that what you're claiming you told the police? Is that what your statement is in court that you told the police?
I wrote it down, you can read it.
No, I'm asking you what you told the police when they asked you to describe the gun.
I said what was written on the paper.
Well, let me slow down and ask the question, and you just tell me if this is what you told the police. I'm not asking you what you wrote down. Before you wrote down your statement, you interviewed with the police at the gas station. Isn't that true?
Yes.
Then they gave you a piece of paper and you went and wrote down whatever it is that you were gonna say. Isn't that true?
Yeah.
And when you were standing there and being interviewed by the police, you were asked about the gun and you described the gun.
Yep.
Is that true?
Yes.
And in your description to the police, when they were speaking to you, you told them it was a black gun with either a silver or black slide. Isn't that true?
No, I said dark gray or black.
Okay.
3 times.
And you actually even described that gun as a Ruger 9mm, didn't you?
I said it could have been a Ruger. The barrel was pointing down my eyes, looked to be about a 9mm.
So you didn't see it when he pulled it out of his pocket?
Yeah, I seen it when he pulled it out of his Carhartt pocket and proceeded to bring it up to my face.
Right? We have the ability to play his statement back on the body cam through there if we hook up our HDM.
I don't know if you do or not. I'm not a tech guy, so
We've got.
I know if it's done correctly, it'll do it.
Well, when I'm done with questioning, then maybe I can go back and do some impeachment of the statement. Now, isn't it true that when you spoke to the police officer, you stated probably 5 times that your brother brandished a firearm in front of you? That was your statement to him when they were talking to you at the gas station.
Yeah, that'd be the legal term of pulling a gun on somebody's brandishing a firearm.
Okay, but you weren't necessarily saying he pointed it to you. You were saying he brandished it at you.
He brandished it and proceeded to put it in my face.
So was it all in one action, or did he have it out and kind of show you for a
He
while?
pulled his hand like this out of his pocket, gun was in it, pulled it out and put it in my face like that. That's
All in
exactly
one-
what happened, all in one motion.
Okay, all right. Now, is your testimony that your brother never told you to leave the restaurant, never told you to leave the residence?
On
After
November
the
4th.
firearm was pulled, he did.
11/4.
Not until after he pulled the firearm.
Okay.
And Judge, I'm gonna ask and answer.
Probably was. Move on.
As soon as you came to the door and spoke to your brother, you inquired if Dad was there, correct?
No, I didn't ask. He asked me what I was doing there. I stated, I'm here to see Dad. That's when he pulled the firearm and said, well, you better get to stepping while you can.
Did you ever receive information as to whether or not your dad was there?
No, because he pulled the firearm, maybe I left. I had a 2-year-old kid in my car.
Your daughter wasn't outside of the car, right?
She was about 10 feet behind me in the car.
Good.
Bullets go through things.
How long is that with you? Your Honor, we're gonna ask Plea body cam of his statements to the police.
And Judge, I'd object. There's no foundation that's been laid.
Well, all right, fair enough. We
That's
can
fair
do it to the
question.
police officer. We'll just call him and he can identify it as his body cam and all of that.
Okay.
Just a second to make sure I'm either done or not done with this witness. Before you went there, you spoke to your uncle.
Objection, where's their judge?
Wait, before you showed up with your daughter at your dad's house, you had a conversation with your uncle, correct?
True.
And
He's already answered it.
when you had that conversation, did you feel encouraged to go to your dad's house based on that conversation?
Yes.
And why so?
My uncle never indicated that he thought it would be a bad idea.
Objection, relevance, not just relevance, hearsay. He's testifying to what his uncle said.
I asked him
No,
specifically.
he's asking how he felt after the conversation. So that's not hearsay. What's the relevance?
Well, the relevance is what his state of mind would have been going there.
Okay, I think we've already established that he had no concrete reason to feel he would be welcome when he went there.
That's fair enough.
Which doesn't mean he can't still show up and try to
sure.
mend things. So move on.
Sir, you wanted a relationship with your granddaughter, with your grandfather, your daughter with your grandfather. Isn't that true?
Can you repeat that?
You wanted
It
your
didn't make
daughter.
sense, so I need to hear it.
It was important for you, for your daughter to have a relationship with her grandfather.
Yeah,
Isn't that
that's
true?
important in any kid's life.
Well, and you stated today it was important because you didn't have a relationship with your grandfather. Isn't that true?
True.
And you went over there and attempted to facilitate or put together a relationship with your dad and your daughter, correct?
No, I just let it be known, wanted to let it be known if you wanted to be a part of his granddaughter's life, definitely could be an option, something that could happen.
Well, didn't you text him that previous to you showing up, that if he wanted to meet his granddaughter and be a part of his life? Isn't that what you testified to previously?
Yeah. True.
So when you showed up there, you didn't need to show up there in order to get that message across, correct?
True, but he also didn't, I didn't get a response. I didn't know which way, you know,
Next
one way or
question.
the other.
Next question.
I asked you this question. I just want to make sure that I covered it. Your testimony is you were never told to get in the car and leave.
No.
And you were free to leave. You didn't feel like you were a hostage there, were you?
No.
He never made a statement to you he was going to kill you, did he?
Indirectly. He said you better get to stepping while you have a chance. I mean, I guess it's up to your own interpretation on how to take that, depending on who you are.
Isn't it true, sir? You were upset with your brother for rejecting you when you showed up there with your daughter to meet his father.
Not true.
You weren't upset.
No.
It didn't affect you that you wanted to have a relationship with your daughter with the grandfather, and you were turned away at the door.
And I'm gonna object, Judge, to relevance.
Relevance is state of mind. And
State of mind's relevant. But he's answered the question.
Is it also true, sir?
No, but I didn't pull a gun on anybody.
Is it also true, sir, that you wanted your brother, when you spoke to the officer in this case, you specifically told them you were making that report because you wanted your brother to get a reality check, right? Isn't that what you told them?
True. We don't live in the wild, wild west. You can't pull guns on people like that anymore.
I don't have any further questions.
Mr. Muhammad, any redirect?
Mr. Backus, when you approached this location and you were greeted by your brother aiming a firearm to your face, did you have on you any weapons at that moment?
No. Also,
No, there is no also. Last time I'm going to tell you, you ask, the question is asked, you answer it, and you stop. Next time you do that, I'll just throw you out of my courtroom and hold you in contempt, put you in jail. Clear?
Clear.
Mr. Backus, please just answer my questions. Now, did you knock at this door or did you enter the room?
I knocked on the door.
Okay. And did you ever enter this location?
Never.
And you mentioned earlier that, you know, the testimony came out that you texted your father wanting to go over. You never got a response.
No, I never said I was going to go over their house or anything. I just said, hey, you have a granddaughter. She would probably enjoy having her grandfather and her wife.
And so my question is, did he ever respond until you know?
No.
Okay. Nothing further.
Any recross?
I can't look at, I'd be expanding the record, Judge. I know better.
Okay.
And you've been generous with me, so.
Thank you. Mr. Backus, you're free to leave. Watch your steps, sir.
I could like leave or,
Yeah.
okay. I just wanna make sure.
Any reason for me to stick around?
No.
Okay, yes, you can leave.
Have a good day, Howard.
You as well. Any other witnesses from the people?
Nothing from the people, Judge.
Defense witnesses?
We're calling a witness right now. We're seeing if he's gonna come and testify. Uncle Kevin.
Sir, all the way up front, please. Watch your step on the incline ramp, all the way up here. Watch your step on this ramp. Raise your right hand for me, sir. Do you swear or affirm to tell the truth, the whole truth, nothing but the truth? I do. Have a seat right there in that chair. Settle in that chair and state your full name.
Kevin Lee Backus.
Thank you, sir. Mr. Mullen.
Mr. Backus, do you know Dylan Backus?
Yes.
How do you know him?
He's my nephew.
And do you know Joseph Backus?
Yes.
How do you know him?
He's my nephew.
So would it be fair to say you've known them all of your life?
Yes.
All their life, rather, I'm sorry.
Yes.
Did you have contact with Joseph Backus on the day that he came over? Let me give you the date, November 4th, 2023, which would be the day that he had an incident. First off, are you aware of an incident between Joseph Backus and Dylan?
I'm
Backus?
objecting, Judge, to leading.
I'm asking if he's aware.
I think it's fair. I think it's fair.
Yes.
And how are you aware of that?
Because I ran into Joey prior to him going out there.
Okay, and when prior to him going out there, you had a conversation with him?
Yes, I did.
And during that conversation, did you encourage him to go out there?
Objection, leading.
That's a yes or no. I allow.
I'm sorry, can you repeat the
I
question?
said, during that conversation, did you encourage him to go over to his father's house?
No.
Was there anything about his manner that you noticed when you spoke to him that day?
Yeah, he came up to me, give me a hug. I could smell liquor on him. I would say my guess is whiskey, smelled like whiskey.
Objection, speculation.
It was.
But
I just didn't want no confrontation. I gave him a hug back.
And Judge, I'm also gonna object to relevance. I don't know how, whether he was or he wasn't intoxicated, hypothetically, how is that relevant to the case we have before us?
It's a credibility issue. I'm more concerned with the timing. When was this meeting?
What time did you meet with him?
It was approximately, well, I don't remember the time of.
Was it on November
exactly.
4th?
It was on November 4th.
That's all I needed to know.
And, okay.
That's enough. I just wanted to make sure it wasn't 3 weeks before.
Gotcha.
Was it before he went to his father's house?
Yes.
Okay. And
Objection, speculation. How's he gonna know that?
He's already answered it. Gotta be quicker.
have you ever seen your nephew, Joey, be physically aggressive prior to November 4th? And if you have, could you give us a time frame?
What timer?
No, a time frame.
Well, over the years, me and my brother are 11 months apart. Okay, we grew up, with your fist fights and such. I've seen them boys go back and forth, and Joey usually is more the aggressor than Dylan ever was. Dylan's always been the guy that's, tried to, defend himself against the older brother, in my opinion. I've known him, I've known these kids. Me and my brother were in business together. I used to spend every day after work out there. I think them kids are like my kids. They're very tight.
And just so, and Judge, I know you'll give me the asked and answered if I asked it. Did you encourage Joe to go to his dad's house that day?
No,
Objection, asked and answered.
It was.
All right, I couldn't remember, Judge, and I think that was an important question I had. I don't have any further questions to this witness.
Any questions for this Mr. Backus?
Just a Mr. Backus, you saw Joseph on that day, correct?
Yes.
On November 4th. You see Joseph in the courtroom today?
No.
On that day of November 4th, did Joseph have a gun on him or any sort of firearm?
He actually asked me to come see his daughter in the car.
Please just answer my question. It's a yes or no. Did he have a firearm on him on that day? Joseph?
Yes, in the car.
How do you know that? Did you see that weapon?
Yes, he took me back to his car, opened his trunk and showed it to me.
And did
And he also had a bow and arrow in the trunk. Hunting gun and a bow and arrow in the trunk of his car.
Nothing further.
Just one question. Tell Joey anything about going over there that day?
Did I tell him to go over there?
No, did you tell him anything about going over there that day?
No, that was his idea.
Okay. But did you have?
I knew you couldn't do just one question. Go ahead.
Did you give him any advice from you about him going over there?
Yes, I told him it was a bad idea.
I don't have any further questions.
Any recross?
Yes, Judge. Mr. Backus, did you ever approach Joseph and tell him to back off from prosecution or try and intimidate him in any way?
No.
Did you ever threaten Mr. Backus with a weapon?
No.
What was Mr. Joseph Backus wearing on that day?
I honestly don't remember.
You said he showed you a bow and arrow. Can you describe that bow and arrow?
Here's a compound bow.
It was a what?
Compound bow for hunting.
Okay, what color was it?
Camouflage, I believe.
Was there any arrows attached to it?
It was in a case with arrows.
What color were those arrows?
I don't remember.
And you said there was a firearm as well, right?
Yes.
What color was that firearm?
I believe it was black stock.
It was what?
Black stock.
What do you mean by stock?
The stock, I believe, was black and the barrel was black. I don't remember the size of the caliber he said it was.
Okay, was
It
there
a hunting gun?
Was there an ammo attached to that gun?
I don't know if there was ammo in it. I didn't ask him if it was loaded.
Are you how do you know that it's a firearm and not a BB gun?
Because he told me it was his new hunting gun and he wanted to show me his bow.
Okay, you said it's his hunting gear?
He said, yeah, this is my hunting gun.
Okay.
He says this, yeah.
Okay, nothing further.
Okay, so you can step down. Watch your step on the right.
Thank you.
Thank you for your time. Any other defense witnesses, Mr. Mullins?
We would like to call the officer in the case. We just want to get his name correct. Is it Officer?
I'm gonna suggest it's either Zeismer or Lujovic. I'm not sure if I'm saying it right.
Officer, come on up. Raise your right hand. Swear or affirm to tell the truth, the whole truth, nothing but the truth today?
I do, Your Honor.
Come on up here, walk my ramp, don't trip up. Settle in the witness chair. After you've settled in, state your full name.
Officer Travis Ziesmer, Your Honor.
Say it again.
Officer Travis Ziesmer.
Ziesmer, thank you.
Yes, Your
Is it C-Sport, right?
Honor. Ziesmer, sir.
Officer Z-Sport, did you respond to a call on the 4th of November, 2023?
Yes.
And you had contact with did you have contact with the complainant in that matter, Mr. Joseph Bacchus?
I did.
And do you recall whether or not you interviewed him at a BP gas station in reference to this case?
I did, sir.
And at the time that you interviewed him, did you have a body cam that you were wearing?
I did, sir.
Do you know if that body cam was operating correctly on that day?
To the best of my recollection, yes, sir.
Sure. And if I were to show you a video, would you be able to tell me if that would accurately represent the circumstances of you interviewing Mr. Bacchus at that gas station?
Yes, sir.
And would your body cam have recorded your question and answer? Look, back that question up. You wear a body cam, and when you turn it on, the purpose is to record interactions between witnesses or civilians when you're doing an investigation. Would that be a purpose that you would use it for?
Yes, sir.
And you were using it were you using it for that purpose today? I mean, on the 4th of November?
Yes, sir.
Okay.
I haven't plugged into the HDMI thing that's on the table here. Thank you, Madam Clerk.
Sir, Your Honor, can I ask him another question before we start this?
Sure.
When you interviewed him, did you ask him about describing the firearm that he told you was part of this incident between he and his brother?
I believe so, sir.
Okay.
That's my background. I don't know why my screen isn't showing.
It's a lovely background too.
Oh, thank you. It's up in the Keweenaw Peninsula.
Beautiful.
Give me just a moment to check my settings here. I apologize. Your
Try,
Honor.
I was told to hit your desktop and hit display settings and it automatically will start going on. Just that's slow.
Oh, okay. So let's see.
How do you pronounce your partner's name?
My partner's name?
Walovich?
Yes. If that's the one.
It's pretty easy.
Yeah, if that's the one.
It's a lot easier to spell.
Yes. Okay, so yeah.
Judge, is it okay if I take 1 minute to bathroom? While they set up-
Yeah, while we're doing the tech stuff, sure.
Okay, there we go.
Do it quick. Spell it. Ziesmer. See, I would pronounce yours Zeiss.
Ziesmer.
Yeah, I would have said Zeiss with the IE.
I get it all kind of used.
Oh, I bet you did it butchered really well. Not as bad as your partner.
Oh, no.
Yeah, those J's completely throw you off with his name.
I play just a moment just to make sure the sound's coming through too. Okay.
Knock yourself out.
Oh, it's coming through my laptop, so there is an issue with it.
No.
Mr. Jerome, if I understand correctly, really all we're after is the audio on this.
Yes.
Push comes to shove, we could probably just play your laptop next to the microphone.
Okay, thank you, Your Honor. I think it's something with my settings where I think I just have to click this button and I think this is gonna fix it. Yep, okay, there we go. My apologies, Mayor. Thank
No
you.
problem. I love me some technology.
It's great until it isn't, you
And
know?
that was all pure sarcasm, just in case you missed it.
Didn't miss it.
All right, we're back on the record, fellas. Ready to start the video?
Yes.
Just play.
Yep.
So you said it was black and silver, some black slide. Okay, looked like a roofer. Straight.
Was that the complaint in this matter describing the firearm?
It was, sir.
And officer, at any time did you recover a firearm that was alleged to be used in this incident?
Yes, sir.
If I were to show you a picture, would you be able to tell me if that was a firearm that was recovered?
Yes, sir.
Is that the firearm that was covered?
Yes, sir, it is.
Recovered?
Yes, sir.
You got that picture, right?
Anything else at this point?
No further questions.
Officer, this weapon that was recovered, who did you recover it from?
Who did I recover it from?
Yeah,
We got it from Dylan.
and is Dylan in the courtroom today?
Yes, sir.
Can you please point to that individual, turn out an article that individual for it, please?
In the gray shirt on the far
Your
right.
Honor, let the record reflect.
Noted.
Witnesses that the police officer has identified the defendant. Where on his body did you recover this firearm?
He actually didn't have it on his body at the time.
Okay, where was it recovered?
It was actually in his room as
In
he,
his room?
yes, sir.
Was this weapon loaded?
That I don't know.
What did you do with this weapon?
The weapon was entered into evidence.
Okay, did you make the weapon safe prior?
I didn't enter it into.
All right, nothing further from this witness.
Any redirect with the officer?
None, Your Honor.
All right, thank you, officer.
Thanks.
Watch your step. Can we send him back to wherever he'd rather be?
He can go back.
Yeah, you don't need him to stick around?
My only question is this, Judge, it's different because we're doing evidence. I would like to admit both the video and the picture.
We don't need him for that discussion.
No, but I mean, but we did it by video, you know what I'm saying? I
Right.
don't have something tangible.
Right.
Do you have an objection to that?
So I would just request that what's been shown is okay to be admitted, but I don't know what else.
Okay, all right, that's perfect.
That time.
That's fine. I'm not asking something you didn't see. I appreciate it.
Admitted. So is Officer,
The OIC is free to leave.
how about Officer Olovich?
Any
The
officer.
other officer
I'm
was
gonna
there.
go with-
You guys have a nice day.
Thank you.
Stay safe.
For clarity of the record, you should-
All right, any other witnesses from the defense, Mr. Mullins?
No more witnesses, Your Honor.
All right, any rebuttal?
Nothing, Judge.
All right, so I'm ready for argument, guys.
Judge, the people moved to find over on all counts. The testimony today by Mr. Joseph Backus is he went to go see his dad. He texted him, sure. His dad never told him he's not welcome.
Let me stop you. I heard the testimony. I don't need you to recap it. If we have a 3-day exam, that'll be helpful, but after this short one, I don't need it. Any argument, I'll let him respond to the argument.
Yeah, I'm gonna talk case law. Case law as far as a preliminary exam, what this court can consider in determining a bind over. Now, often, Your Honor, the court doesn't look at affirmative defenses and other things, because there could be questions of fact. What could lead the court to say, hey, that's for a trier of fact, and not necessarily for this court. But there are exceptions. And under the People versus Robert Redden, 290 Mishap 65-8485, and they were quoting People versus Woltening, which is 272 Mishap 678 690. The court noted that in situations in which a defense is complete and there's no conflicting facts regarding the defense, it can be argued that there's no probable cause to believe that a crime was committed. Now, I'm asking the court to do a lot. Now I'm going to backtrack and tell the court or explain why I think that's relevant here. People versus Johnson in 2020 gave an opinion. Oh, I'm so sorry, Your Honor. I'm reading you the wrong case law. I got a specific case law. As I'm looking at use of force and what's allowed for an individual in a situation on their property. And I'm going to explain the facts and give the case. In this particular case, an individual pointed a gun at someone's face. And the trial court ruled that pointing a gun in someone's face was considered deadly force. Now, when you have deadly force that you use, you have a different requirement to show as the defendant in order to get the affirmative defense. And in fact, when you have deadly force that you use in an instance, that would be considered, you have to have a situation where deadly force is necessary and you're saving, your life is at risk. It's a risk of your life in order to do that. But the court in People versus Oakley, which is a 2022 case, 341, Mishap 28 says, pointing a gun at someone without more is not deadly force. It would be different if you pointed the gun and fired it and said, shoot. I was shocked when I read this, Judge, because I've been doing this a long time, and I would think clearly if you point a gun at somebody, that's going to be deadly force. The court specifically indicated that putting a gun and pointing at them in of itself, that's not deadly force. So in this particular case, if we are following the case law, Mr. Bacchus did not use deadly force when he encountered his brother, even if you agree with his brother's story that he pointed the gun at him. And I've got questions with that. And the reason being is, you saw the evidence. He described a totally different weapon that was used. That weapon that the police recovered, and the weapon that was alleged to have been used in this, had a desert storm color, totally different than the gun he described. We also heard the witness fight with the lawyer, kind of be flippant about different questions. We know he did not have a good relationship. We know he wasn't in contact. We know he reached out to his dad for his own testimony, and nobody gave him permission. He wasn't welcome. He left over 2 years ago with a dispute with the family. We heard testimony of his uncle that talked about the relationship between the two brothers and how the older brother was a little more of a hothead and the older brother would get the better of his younger brother, which is not unusual in a family. But this goes to the state of mind of my client when now, over 2 years later, his brother who's been removed from the place shows up and is there on his porch. And now his brother wants to see dad. Well, based on the relationship, it's the individual who is not engaged in using deadly force. It's a different standard. If this person reasonably believes that the use of some force is necessary to defend himself against that individual, they would be justified in it. I think the facts in this case kind of line up that way. You got an individual, all the things I told you about him. And furthermore, I don't think he misidentified the gun. He said it was right there. What do you say, 6 inches from him, a couple feet from him? I think the witness was not a credible witness. And in a preliminary exam, you're sitting as trier of fact and trier of the law, and you can make a credibility consideration. My client is at his home. He has no duty to retreat. And when he's faced with a threat of his brother, and I think the evidence is pretty much square on, and I'm asking for a lot, but this is one of the rare cases where I think the stars line up and the facts line up, where he doesn't have to show he was facing deadly force. Even if he's wrong in his belief, but it's reasonable for him to believe that his brother's a threat, then I think that's enough for him to use not deadly force to remove what could be considered a trespasser at that point. And so I ask you to question.
Thank you.
And so, the charges in this case are felonious assault and weapons felony firearm. I mean, that was a great speech on the use of intent to use deadly force, but that's not a requirement for the elements.
It was a great speech. It was a great speech.
It was, without question. if it was regarding the intent of using deadly force. But unfortunately, for brother counsel, that's not the elements for the crime. So the elements in this crime are make an assault with a dangerous weapon, but without intending to commit the crime of murder or inflict great bodily harm less than the crime of murder. So the weapon that was used in this scenario was a firearm. It was recovered by one of the officers. The testimony by the OIC today was that this firearm was recovered from the defendant's bedroom. The testimony today reflects that this weapon was used and aimed at the face of the victim. And the victim stated that he felt in fear. He panicked. He had to leave the situation. And that's what he did. Nothing on the record indicates a self-defense kind of claim where the victim approached the defendant with a weapon. He stated he wasn't armed. He had no knife, nothing. So I believe without question, probable cause, the standard of probable cause has been met in regards to these two elements, and we're gonna move to bind over on these two charges.
Thank you, Judge.
And
Go ahead, I'll give you a shot.
super brief. I think the important thing to bring out is this goes to an affirmative defense that my client has. It's not necessarily we're going through the elements of it. We're talking about an affirmative defense. In the case law that I cited, People versus Robert Redden from 2010, published case of the Court of Appeals, allows you to raise a affirmative defense at preliminary exam. Typically, affirmative defense is going to be raised at trial. I know that. But that case specifically says you can do so. And in doing so, you can consider the credibility of the witness and whether or not it's reasonable for my client to feel threatened by this individual. You heard the facts, and I'm not going to repeat all the facts of the relationship. As I relate to the gun, that's the gun that's alleged to be used. That's not the gun that was identified by the witness. Again, going to his credibility of whether or not this crime really was committed. And what they say is this: if the affirmative defense has the issue, if the elements of the affirmative defense are met, this court can find that probable cause that a crime occurred did not happen. Because that's one of the things, whether he committed a crime and by probable cause, the elements of the crime have been present. So for those are the reasons why I think it's appropriate for you to quash bind over in this particular case.
I'll be very, very brief, I promise. I don't know what the affirmative defense is for. This victim went to the home of his father to show his father his newborn child. He didn't go there with a gun. He knocked on the door, he left. They didn't want him, he left. That's all that happened here. It's a sad case that a brother is pulling out a gun and aiming it at his brother for wanting to, his older brother show the family his newborn child. I think this is a very, very sad case. And it's sad to see that it happened. And we're still moving to bind over because the elements of the crimes have been met. Thank you.
Thank you both. The trier of fact. The testimony was that there was more than pointing a gun. There was get to stepping while you still can. That's a threat. And I'm a huge stand your ground, all that, but you don't open your door and point a gun at somebody. There's got to be something to precipitate it. If you ask them to leave and they refuse, if they make threatening gestures, whole different ballgame. The testimony today was there was no conversation. He was not asked to leave. The gun came out and get to stepping. This is a trier of fact issue. So I'm going to send it downtown. Your next court date's going to be February 14th at 9 a.m.
February 14th?
14th. Yep. 9 a.m. Bond will be continued once I hear something quick. Bond will be continued. Wish you luck downtown, sir.
You want just one last thing? Those two exhibits, will they go with it?
I don't know how we're going to do that because, yeah, we don't.
The record marks those two exhibits, the video that dealt with that short interview with the brother regarding the description of the guns, as well as the,
yeah.
No, thank you, I appreciate it.
Yeah, we can do that. Right, picture of the gun, just put in the notes that images were shown and admitted. Which one are you going to do next, Mr. Mohammed?
I think Michelle Japanga, can I just go check?
Yeah, we've got her on Zoom. She's been here for quite a while. Gentlemen, you don't have to go far, but you gotta get out of here. Good luck down.
I'm sorry.
Good luck down.
I still have one more, Your Honor. Hopefully, he's not gonna pull my deal now. No, I'm joking. I'm teasing.
I was informed that the exhibits are for this exam only, so when you go from downtown, the parking lot will be shut.
Oh, look, no problem. Just, I'll file a motion to quash fine over. I want to use that. She can only use the lower record.
Shannon.
As long as they're not part of this record, that's all that.
I can't, I don't have video, I can't. I do is I
Hold on,
transcribe
turn
it.
yourself in. No, that's all I need. I'll make the rest of the argument.
Money and he hadn't done anything that was supposed to be corporation wants.
So you just came in today?
Yes, yes.
Okay.
And Al saw him this morning.
Okay.
So I'm training, sent it to me.
Good.
And once he was done, you know, with all the information, we put him search over to make sure they had shelter for him.
Really?
Yes. Sent him.
Yes.
So my thing was
Is
checking
shelter
with you.
now?
Yeah.
Yeah.
Mine was check with you.
Do it.
To see if we can, I can drop him off, take.
Sure. I don't think you should go alone though.
Huh? Yeah, I'll take this thing.
Yeah, yeah.
Okay.
Yeah, take him. Great.
Good.
Perfect.
Just wanted to clear it out. Check.
Yeah,
I'll
no,
let
we
Ryan
did-
know as well.
We just build goodwill with him. Now maybe we can close our files out with the community service.
Yeah.
Yeah,
Just wanted to
yeah,
make sure
yeah. Be
everything
careful.
was good.
Yeah, thank you. Yeah. Yeah. Wise guy. It's the black shirt. Yeah. All right, gentlemen, appearances for the people versus Michelle Japanga.
Good afternoon, Your Honor. Mohammed on behalf of the people, PA 6771.
Good afternoon, Judge Oakley. Good afternoon to your staff, Neighborhood Defender Service, Carrie Martin, P 84592. I appear on behalf of Miss Michelle Japanga, who appears by Zoom. Ms. Japanga, state your full name.
Michelle Renee Yepton.
Thank you, ma'am. She's still in treatment, I assume?
Your Honor, I had Ms. Japanga Zoom in today because right before I got a call from her around 11:30 and from her boyfriend, actually first from her boyfriend, that she had a seizure. So she's an epileptic and you had previously granted her permission to appear by Zoom because of her epilepsy. She cannot drive. She had another seizure just today. Heard it from her as well. I didn't want to jeopardize her health in any way. And I had also heard from Detective Rice that an officer who I believe to be a necessary witness in this exam, that would be former Officer Kilgore of formerly of Romulus PD, is not present. So I am, for those and other reasons, if you'd like me to put them on the record, asking for a dismissal.
Is that a no? She's not in treatment?
She's not in treatment.
Okay, all right. Yeah, you're gonna have to give me more than she's had a seizure and they've got one missing witness. What other reasons do I have for dismissal?
Well, Your Honor, the missing witness is the officer who, and this incident, which was November 2021, who first approached Ms. Japanga, found her overdosing. That's a critical issue for exam because that would, under the statute, show you, that would make it that she had not committed this offense. Now, the only officer that we have is an officer who arrived later after this had occurred. In addition, we don't have body cam. And I had Judge Martin sign a discovery order requiring that they produce body cam depicting the interactions with Ms. Japanga. I was provided some other forms of digital discovery, but was informed, Mr. Mohammed showed me communication from the OIC. I'm not sure whether it was Detective Rice or the previous OIC on this case, that body cam no longer existed.
All right, so the initial contact between her and, was it Kilgore?
Kilgore.
That we don't have that video.
We don't have that video and we don't have Kilgore.
Okay, okay. All right, response?
Judge, we did after that discovery order, from what I recall, my computer's down at the moment, but I do recall us sending some digital discovery that we got. And as Mr. Martin disclosed, some stuff just didn't last over time. I think this is a couple years back. We are ready to move forward today. We do have Officer Dorsey. I understand Ms. Japanga suffered seizure in regards to that, but we are prepared to move forward today. We are missing one officer that does play an important role, and so we would request a helping part in regards to that officer.
Okay.
And
Is there, hold on a minute. Am I safe to assume that you don't have any civilian witnesses, just law enforcement?
No, police officers.
All right. So number one, she just had a seizure. Number two, you want Kilgore. I'm assuming you don't know if you can get him or not.
Yeah.
Do we know?
He works down in Auburn Hills. We're able to get a hold of him. This subpoena came in late, so he is available. We weren't able at the time to get him for this day.
All right.
And just for the record.
So hold on. I don't want to start it and finish it later. That's selfishly, it's just rougher on me. I also think it's not probably the most compassionate way to handle it for Mr. Japanga. I'm inclined to adjourn.
Your Honor, I would respectfully renew a request for dismissal, not just because of the missing witness, but because of what I'm saying is a discovery violation that will prejudice Ms. Japanga if this case were to go forward.
But if I understand correctly, you've got everything they've got. They just don't have what you want.
Well, what we have is a concession from the people that this body cam footage previously existed, and they allowed it to be erased, destroyed. That is a Youngblood violation. That's a due process violation. That is, they once had access, control of possibly exculpatory evidence, and they failed to preserve that evidence.
Yeah, but I also, and I'll give you a chance to argue it, but I also think there's got to be a bad faith before the result is a dismissal.
Youngblood does require bad faith. Bad faith can arise from blanketly, maintaining a system that erases discovery, including on pending cases. I mean, this isn't just, our old closed cases. We can say, it was just a technology failure. But at the end of the day, if you have a police department that is knowingly or that knows that footage from pending cases is getting erased and destroyed, I would argue that's enough for bad faith for Youngblood. And even if you don't need Youngblood, I would argue it's a Brady violation, which doesn't require bad faith, where you had possibly exculpatory or at least impeachment evidence that was in the possession of the people that has not been provided.
All right, so let me ask you this. What do you think the video is going to show that helps her?
I think the video would show that the police officers who responded were responding to what appeared to be a drug overdose and what I actually believe was a drug overdose.
Right. That
under the statute, I mean, I've got it right here. Basically all the sections of the Controlled Substance Act, including the one she's charged under, which is 333-7403, contain a subsection 3, which states that an individual who requires medical assistance and is presented for assistance by another individual, if he or she is incapacitated because of a drug overdose or other perceived medical emergency arising from the use of controlled substance, and possessed an amount sufficient only for personal use, and this evidence of the violation is obtained as a result of the individual seeking or being presented for medical assistance, that individual is not in violation of the section.
Okay.
Now, I would say that—
Hold on, I'm with you. So is it the people's position that she was not suffering effects of an overdose at the time of the interaction?
I think that is the people's position, is that there was a response for a 911 call. The officers responded, they made contact with the defendant, and in plain view, they did observe drugs, which were the suspected cocaine.
But she was conscious, she was interacting.
She was conscious, and it was her own words that it was cocaine.
If I could.
And
respond.
that's-
Yeah. I just want to make sure I know what their
The
position is.
nature of the 911 call was an unconscious female.
Okay.
When, according to the report, when Officer Kilgore responded, Ms. Japenga was unconscious. He performed a sternum rub on her. And though that did arise her, she was later, nodding off again.
Right.
And Judge, just for the record, I'm pretty sure the person who did that 911 call was her friend. And I don't know if that helps.
I don't think that matters under the statute.
I know, I just want to make sure I'm
Right.
disclosing.
I think the determinative factor in the statute is her condition at the time of the initial interaction. Would we all agree on that?
Yeah.
Okay.
I'm with you.
Okay. I'm not going to dismiss it at this point. Here's why. If Kilgore's testimony is all of what you just told me, I think then that's the argument.
Yes.
She was in the midst of an overdose at the initial interaction.
Yes.
Which then I think triggers subsection 3.
Yes.
I don't need a body cam. If he says, no, I got there, she was talking, it was fine, blah, 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 then you can renew your motion because, yeah, I think at that point, the body cam could impeach that testimony.
Well, for purposes of today's argument, given that the people did not subpoena Officer Kilgore, would you entertain looking at the reports in which Officer Kilgore does state that he found Ms. Japenga unconscious?
And I'm going to object to that misrepresentation Mr. Carey is making to the court and for the record. Subpoenas were sent weeks in advance.
Oh, no, don't even go there because I'm not think he's trying to. I don't think he's trying to paint you in a bad light. He's saying we don't have the cop, but we've got his record. Can we just go forward with his report? Any objection to that? I mean, I'm okay with an adjournment if you want to get Kilgore here, but if you want to save the time and just go on his reports, from what Mr. Carey just told me, the reports make the argument. I mean, I haven't seen the reports, obviously.
Yes, and I would need to grab my computer and pull them up, but do it in about 30 seconds.
I feel strongly both ways, so.
So, Officer Kilgore, it does state that he performed a sternum rub to wake Miss Michelle Japenga. Japenga woke up and when asked what she had taken, and that's when she made the statement that it was possibly cocaine. And that's a representation I want to make to the court.
Okay.
And I'll, live by your decision.
Well, I think we can all agree if he's doing the sternum rub, it must be because she was non-responsive when he first approached her.
Agreed.
I'm dismissing it.
Thank you, Judge.
And you guys can build the record. You can take the dismissal because the discovery violation, because of section 3. I think we could have a full-blown exam. I'm going to be the same place.
Yeah, I think section 3 doesn't apply.
All right.
Thank you.
Okay. Ms. Japenga, you're all set. Case dismissed. I'm going to write it up as dismissed after exam. Just because I don't think it matters too much, but that's why I'm going to write it up.
Works for me, Judge. Thank you very much.
Good luck, ma'am.
Your Honor, thank you very much.
Thanks, guys. We still got a couple files, don't we? What else?
The next one is Michelle. And then we have, well, Michelle was the first.
Hey, Joe. Yeah. On the way out there, find out if we're ready on Michelle.
Michelle?
Yep. Go ahead.
I appreciate it. Yeah. I think that's the right choice.
What's next?
Your Honor, have a good day.
You as well. Stay safe.
Okay.
Mohammed, are you doing Michelle too?
Yeah. Judge, that last one, that drug one with, it's a codependent one. I'm gonna need a minute to talk to officers. It's kind of a big case.
What's the name?
Um,
Michelle, you mean? Or
no, it's Stacy Jackson
Okay.
and Dwight Jackson.
can we,
I'm sorry.
You want to talk before you get to Michelle?
Yeah,
Go ahead.
I'm just sorry because I didn't anticipate that FA to be.
no, that's all right.
Okay, remind me. And then.
We're rating pretty good. You have a lot of files up there?
Yeah, I've got Michelle, I've got Crenshaw, and then I've got some of those are probably no shows.
So that Sarah Pornier, no show. What?
What's that? Oh, you did? Yeah. Yeah, for an off the cuff argument? Yeah, you did a great job. Both of them. Yeah, tell him that. I agree.
I absolutely will.
No, that's a do-gooder thing. I think in certain circumstances, absolutely. Yeah.
I'll go to the job.
Says he had another file, but I don't know which kind it is.
Well, Crenshaw never did show. Yeah.
Put it on that file there. Oh, I got a file.
Oh, we scratched, didn't know.
I know, because somebody told me it was here.
I'll double check.
Oh, no. Crenshaw was scheduled early this morning, but Kerry Martin told him to come in late today because he had some other stuff late. So you might check with Martin whether or not he's here.
Okay, all right.
Did Gracie leave?
What's that?
Did Gracie leave?
I think so.
Okay, that's all. Perfect.
I don't know.
For drivers?
Yeah, for the commercial.
No, but the thing is, it's to a company, so it's not gonna affect anybody. It's not gonna be me. Why is it gonna affect the city? We don't have the driver's license number, we have actually nothing on. It's for the company. And it's a registration.
I was a truck cop from.
You want me to help you?
Yeah. I get him. It's gonna give me a civil. And he's gonna yeah, well, the ticket was originally a failure to have registration. He corrected it.
Yeah, it's in the company name.
So it's not carrier.
Oh, wait.
I'm so happy that we. Yeah, okay, I'm just double one.
We usually want 180 or 200.
Okay, perfect. No, there's a driver listed.
Right.
You have that ticket,
Yes, it's over here.
would
So
you do a double parking? I mean, you want a civil infraction, right?
yeah, but I don't know if double parking will fit. I would normally dismiss it, but the only thing is it's a CDL holder and our office has like a big policy.
It's the company.
It's the company, it's not even the driver.
So it's nothing for the driver, it's the company.
Okay.
Well, no, I'm just saying,
Yeah,
it's in the company's name.
It's not a commercial drive.
Okay, then yeah, dismiss it. 9 out of 10 times I would dismiss it, only when it's CDL, I'm hesitant because our office has like some weird
Yeah.
policy.
Yeah.
It's company's name, so it's not even the driver, it has, you know. it's not really
So you're moving to dismiss?
Yes.
Yeah. And just so you know, the CDL thing, where I think we're all sensitive about it, is safety issues.
Yeah, you're right.
This isn't really a safety issue, because we don't want a guy with a class A CDL that's an unsafe driver
Overweight,
hauling our petro down the road. Yeah.
Okay. I appreciate it.
Would you agree with that?
I wanted to.
Would you agree with that? The reason the prosecutor's office is tough on CDLs is because it's a safety issue, not a registration problem.
Well done. Well, I get something, can I get a copy of that to give the client or?
Yeah.
Or am I asking?
And he's got paperwork says it's right.
Your Honor, he's a good young prosecutor. This one
Huh?
here, he's a good young prosecutor.
I'll tell you what, they sent this kid out here. He didn't even know, he didn't have a clue how to do a plea agreement when he got here.
Well, you know what? You can tell he's got natural skills, a natural drive to do the job. I said that to him. I like him.
You know, the other thing I really like about him, he's humble. He'll ask questions. He'll take direction.
And he's got the right temperament. You know how hard it is in this job.
Yeah.
You know, and defense attorneys are jerks.
Yeah.
We say things, you know, cases.
Yeah.
He did a great job.
He did a great job with your argument that he got blindsided with. And then Kerry Martin just hit him with another blindsided argument that I thought he handled real good. I think I really, first of all, I told her earlier, I like him. And you know what? If you're likable, that covers up all kinds of sins.
It does. It does.
Yep. Yeah, yeah. But you know what? when he was first here, I think he's still doing it, but when he first showed up here, he'd pull a defense attorney aside and say, look, I gotta make an offer on this case. What would be a good offer on this case? Because he wasn't getting any help from downtown. No.
I mean, I hate to say that.
Well, you know, Trish, I don't disagree with you. Trish Gerard was out here. You know, her domestic violence. And I can't even tell you the last time I saw her, but she used to be assigned to our court as a domestic violence prosecutor. Now she's the head of that division. I mentioned him to her about the fact that it's, you know, it's sad how little training. She says, Judge, I'm here. I'm not supposed to be in court. She says, we don't have time to train these kids. Yeah.
He did a great job.
No, I thought so too.
And you know, it's tough. I did want to tell you that.
Well, those are pretty new cases you were getting too, 21, 22. Right. On the case where they said it wasn't deadly force, I'm assuming there were no words. It's like gun in face, nothing else.
I don't think there was a words. It was really interesting. And it was a little better that the neighbor had punched him one time or something, which gave it was reasonable for him to use up
To pull the gun, right?
You know, I've got witnesses.
Yeah.
You know, it's out of your court.
Yeah,
right?
yeah.
I've got witnesses that are going to testify how. Yeah. You know, he's.
I hate these family things though, because there's no repairing this. And you know what? The 2-year-old is going to suffer.
I do too. You know, and I even asked.
Yeah.
And you know, like, I'm afraid so. Yeah. But it's tough. You know, those are tough.
You know, I've been looking into this whole restorative justice thing, because between you and me, this job is not nearly as much fun as it was 3 years ago. And I got to get at least to the end of my next term, right? I got another term I could run for. And at this point, I'm just trying to find some way to stay engaged for the next 4 years. So I was thinking of the restorative justice, you know, with the juveniles, and, you know, I'm getting real involved with the Rhino schools right now. This is a perfect example where, you know, the restorative, well, for the model, this case doesn't fit,
right?
You know, with the weapon and everything, but family situations, man, get them all in a room and say, what do we got to do to move forward so this 2-year-old can know her grandpa and her uncle?
And you know, grandpa wants to know the kid.
Oh, I'm sure.
But he's got an ad, you know, it's all, you heard the divorce.
No.
Divorce.
The kids picked,
Yeah.
this one picked the wrong side.
Yes, that's
right.
So
I got a buddy that's going through that right now.
It's horrible.
Got 5 kids, and he has not had a conversation with his only son since the divorce.
I don't know. I don't know what to do with it. And there's so much emotion involved. This is like some stranger.
No,
showed up today.
those are easy compared to
Yeah,
these,
right.
yeah. Because this goes back to who got what for Christmas in 1978. It's like doing divorce work, right?
Oh.
It ain't about the toaster. That's just what they're fighting about.
I hate it. I do hate it.
Yeah. Now, good luck, guys. Oh, you're done now.
Yeah. Thank you.
All right, so you confirm that with Mark.
Out there at the front desk.
Your turn. Just check with the attorney. I'll get some water.
We did that. We did that.
That was on Zoom.
Yeah. We're
Yeah, the backstory.
Yeah. All right, so the ones that are marked are no shows. We didn't have a lot.
All the people in the motion.
Yep, except that one, we're still,
Everline's here.
it's crazy. Yeah, he's in custody.
Is that insane?
Everline in custody.
Okay.
At 2 o'clock.
All right, and we got him here.
Yeah.
Hold on.
Jacksons are outside waiting to come in. Martell's their attorney. He's here.
Oh, we got 2 Jacksons.
Yep.
That's right, Mr. and Mr.
No, and then
First and top. Perkin Heights and Thompson.
Yes.
9:15 pre-trial, so they must not show up. Is it highlighted? Yep. And then last file is Siegfried.
Siegfried is on its way.
Yeah, we have real good. Here. Hey, Jamie.
Yeah, yeah.
She's got all his information.
Avery just brought me, when Avery walked in there, he just got him in the back hooked up. I was like, today, and I gave Avery the okay to drive the guy to take it to the house. Well, it's also on that guy. I mean, how bad do you want out? Something.
Acting and stuff, he's not, so.
Yeah.
And Shannon tried to.
Yeah, I usually like what she does. Hey, Ken?
Yes, sir.
Whether or not it happens now or not, these go down to Mackenzie. That's all, you're gonna eat right in front of us.
Hey, nobody else is eating.
Here, I have.
I don't mind you eating, just don't do it in front of Heather or I.
I offered her,
I can't, I gotta get my hands all yucky and I'm trying to work.
Then she'd have to wear gloves.
I'm working.
What are you a monkey? You just eat fruit today?
that's what I did, that's my breakfast every day, or my lunch.
Really, just nothing but fruit?
And that peanut butter jelly.
Oh, okay.
He already sucked that down.
No, I haven't eaten it yet.
Well, that's good for you. That's healthy, a lot of fruit.
That's what I do.
What was that?
That's why I try to eat a lot of fruit.
Oh.
Usually my lunch is probably 3 out of 4 lunches I eat are smoothies with 2 or 3 bananas and then strawberries, frozen blueberries, walnuts, heavy cream, and make the smoothie.
Green?
I never eat them.
Almond milk and heavy cream.
Unless I'm on vacation now.
All right, tell somebody to get in here and work.
All right.
He's been keeping you going for quite a
No,
while.
he's been doing all right.
You're going back and
Well, he's
forth.
chewing, he's all right.
No, I'm
Thank you for having my
not.
back.
Muhammad,
I'm talking
Muhammad.
Mohammed.
Heather, I actually feel like I have a airline in this courtroom now.
Don't get used to it.
No, I saw that.
He's so excited. He's been wild since he was a kid. Finally came. It wasn't there. He said, "Say no more."
That's funny.
Yeah, it's like the holy grail of pistols for most gun collectors. It's a Colt Python. They were like back from the 70s and 80s. They came out again with Pythons like a year or two ago. They started reproducing them. So if you find an old one, that's like,
Yeah.
but he bought a brand new one. But he's really excited. So he's not even going to shoot it. He's just going to like put it away in the safe, take it out and look at it. That's all.
Well, if nothing else, it gave me a good excuse not to go to Dearborn.
Oh, yeah. Right, right. I can't, this is okay, hang on. Invalid disposition for court. It's a messing, it's a high court misdemeanor. Seven five oh 4. Oh, Pat Corral. Yeah. Pat Corral 1510. No, that's not. 750 that's 414. Um, 06. Please, just so that I can display this file.
Oh my God. There's this guy that I get one of my emails. They send the stories. His doctor's name is Will Dabbs. He's an MD, and I see his writing on one of the sites. It's really. So he started out by saying one of the guys, he used to drive to his office, and he was down in rural south. He used to drive every day. He'd see this old man, just a typical Southern grandpa, skinny, shirt buttoned up to the neck, buttoned at the cuffs, bib overalls on. The old man would wave. He said, "I'd wave," and never think anything of it. Then he came in to see me for some reason. Pain in his arm, rolled up his sleeve, and he saw it was just a mass of scars. Find out the guy, he got the scars on. Grenade. So he goes through a bunch of stuff. So he told me every time you come see me, you're gonna be a war story. Come here and listen to
Working
this.
on some negotiations, but I think it's getting. real
Come here and
close.
listen to this. This, I don't know if you ever heard of Dr. Will Dabbs. He writes in a lot of gun mags and stuff like that. Writes real well. Anyhow, he's a country doctor in rural South. And
meets this old man who's supposed to be. So he told me, every time he comes to me, he's going to wash. It's one of the stories. The war was, I'll skip the part that the worst part of the war for him was coming home in a troop ship that caught his phone, and that was scary. Shit. Once he finally got home, his mother threw him a party. Friends and family from all over to celebrate the fact that he made it home safely and intact. All stayed up late. He cast all gradually went home. His mother took him to his old bed. It was exactly as it was when he left 3 years ago. He took him into bed, went to her room, changed the overnight clothes. In his own words, I sat in the dark staring at the ceiling. I couldn't do it. I got up, took it outside of the woods and touched the house. I went in the backyard. My mom heard the noise and came out to investigate and she found me cold over the side. I realized for the first time when I've been through, it all changed me.
Did we switch last time? I feel like in that courtroom, I've made a mistake too.
I couldn't sit outside the box. Together, we never shit like that. All right, which one are we ready on, fellas?
Michelle, that's the.
Where is Mr. Michaud? Is he in custody?
He's here.
He's coming?
Yeah, he was just in the courtroom.
Hey, you gotta get on that site. That's that field ethos I told you about. I showed you the magazine. Field ethos. Remember I showed you the magazine? You gotta get their emails. That story came in that. And I get just about one email a day. And they got stories like that. I mean, some of them were hunter fishing stories, but the writing is. I told you, one of Hemingway's grandfather or grandson's writes in it. Still good read. And those guys came back and they just went back to their lives and sucked it up. It's World War II. They just sucked it up. No, I know. No. Yeah. It really was the greatest generation. All right, appearances for the people versus Frank Michaud Jr.
Good afternoon, Your Honor. Mohammed on behalf of the people, P86771.
No, it's not. You have works. Yeah, you're on fire.
Are you up? Please sit at the desk representing yourself.
The judge needs to address you, sir. Is that a problem, sir?
Yeah, you're a defendant. Sit at the defendant's chair.
I'm not defendant. I'm sorry. Judge, if I may try to help explain.
Try.
I'll try. Mr. Michaud is a sovereign citizen and.
No, I object. I'm not a sovereign citizen.
All right, sir, don't speak.
I maybe am not phrasing that correctly.
Don't speak until I ask you to speak.
But there is a difference between Frank Michaud, or I think it is Mr. Michaud's assertion that there is a difference between the natural person, Mr. Frank Michaud, and the sort of legal entity.
I don't recognize that.
And that's what I've prepared Mr. Michaud for that.
Sir, you're a defendant in my courtroom. Either I issue a bench warrant because you haven't appeared, or you come up here and sit in the chair and we proceed.
All right, so you're threatening me to.
Absolutely, I'm threatening you. Either you're here today or you're not. If you're not here today, a bench warrant will issue. If you're here today, I need you in the chair so we can proceed with the proceeding that's scheduled, which is a preliminary exam.
And Judge, if I may, I have advised Mr. Michaud that the courts receive objections all the time, or rule objections that are preserved on the record. If he has,
He can appeal me. I'll let you build whatever record you want to build, Mr. Michaud.
Are we on the record?
Yes.
Are you on your oath to the Constitution?
Hold on, are you picking him up? That's one of the reasons I want you up here, is through the microphone here.
I'll speak loud.
Are you picking him up? Yes. Go ahead.
Are you honoring your oath to the Constitution today?
Pardon me?
Are you honoring your oath to the Constitution? You have an oath to the
I didn't swear an oath to the Constitution.
You haven't.
I took an oath that said I would follow the Constitution.
To not uphold the Constitution?
Yes, follow the Constitution.
So you are upholding an oath to the Constitution?
Yes.
Thank you. I accept your oath. Thank you. Okay. Now I have.
Sir, get your ass in the chair or leave and I'll issue a bench warrant. You're not running the courtroom. I am. If you want to have an exam today, get your ass in the chair. That's the way it works.
I reserve all my rights. As I come.
I would have nothing less.
I reserve all rights.
Now, are you representing yourself today?
I'm presenting myself.
That's not what I asked you. Are you representing yourself, or is this gentleman going to be your lawyer for today's proceeding?
I will be presenting myself today.
may
All right, so that's a no. You don't want him to represent you?
No, for the record, he's not my lawyer. I don't have an attorney. I present myself.
Okay.
Judge, what I recommended to Mr. Michaud is that he has a jurisdictional argument that he wants to make. And that, pending Your Honor's ruling on that jurisdictional issue, I have prepared to conduct a preliminary exam.
Okay.
And could be, available if he wanted to ask me to do that at the correct time.
So you want to represent yourself for that jurisdictional argument, and if I rule against you, then perhaps you want him to represent you? Is that what I'm hearing?
No, that's not what you're hearing.
All right, so you don't want him at all under any circumstance?
No, I don't need an attorney for the record. I'm fine.
Okay.
So with that being said.
Well, hold on. You can stick around if you want to, but I'm not going to obligate you to stay.
I understand, Judge. I'm definitely going to stay.
That's fine. All right.
So today.
You have a jurisdictional argument you want to make?
Well, I've served notice.
Sir, it's a yes or no. Do you have a jurisdictional argument you'd like to make today?
I have a
yes or no.
Why are you forcing me to say answer?
Because I'm running the courtroom and it's the way I want to do it. Do you have a jurisdictional argument you'd like to make today?
I do, yes.
Then make it. What's your jurisdictional argument?
I'm presenting myself. So I need to know, Article 6 of the Constitution grants me the right to know what jurisdiction is this court operating up under?
State of Michigan.
No, what jurisdiction?
State of Michigan.
Okay, what jurisdiction is the state of
District
Michigan?
courts are legislative courts. That means they're created by statute. The state of Michigan gives me my jurisdiction.
So, okay, is that
I work under the authority of the state of Michigan.
What is it? Under what jurisdiction? There's two different jurisdictions under the Constitution. You have admiralty and common law. So I'll need to know.
This is not admiralty.
What is
and
it?
It's not common law.
Which
it's
one?
Statutory.
Okay, so it's statutory. That is what, civil?
No.
So what is it?
My jurisdiction is both civil.
I can't defend myself unless I have it on the record. Is it?
My jurisdiction.
It's only two.
Sure. Shut up. If you ask me a question, I can't answer while you're talking.
Okay, cool.
My jurisdiction is both civil and criminal as provided by the statutes of the state of Michigan.
Okay, so today, under which one is?
This is a criminal case.
Okay, right. So is that common law or admiralty?
It's statute. It's neither common law or admiralty.
It's one or the other. It don't say statute.
All right, then you can appeal my ruling. My ruling is it's neither admiralty or common law.
So this is you say it's criminal for the record?
Yes.
Okay, and if it's criminal, in order for a crime to exist, there must be an injured party for the record, right?
There must be what?
An injured party.
Yeah, it's the people of the state of Michigan.
All right, so if the people of the state of Michigan, right? Where's this sworn statement
Where's what?
A sworn statement. I have a right to see a sworn statement saying I entered sworn.
There's a complaint in the file.
Sworn complaint, signed, all,
You want to see it?
affidavit, sworn affidavit?
No, it's not. I don't think it's an affidavit.
Well, okay, so
You said you wanted a sworn complaint.
from an injured party. Who have I injured for the record?
The state of Michigan
How can I
are
injure
bringing
the
the
state?
charges.
How can I injure the
Sir,
state?
sit down. Sit
I'm first saying,
down.
I'm not.
Sit down, or I will hold you in contempt.
Another threat, wow.
You're probably going to hear more than one.
I see.
All right. I am ruling that I have jurisdiction. You are free to appeal that to the circuit court. Proceed. Do the people have a witness they'd like to call in the exam?
Yes, Judge, the people are prepared to move forward. Just as a quick preliminary matter, we'd request a mutual order of sequestration with an exception for the
So-
OIC.
All right.
So again,
I'm not asking you to talk. Ma'am, are you a possible witness in this case? Okay. All right. And would you mind putting your name on the record, please? Counsel, I want to look at the lady. Would you mind putting your name on the record?
she's a witness. She is a witness.
Sir, you speak again when I haven't asked you to, and you're in contempt. And we'll deal with that first. The reason I need your name is because if you appear somewhere down the road and want to testify, we have to know that today you were in the courtroom. And I can't do that by taking a picture of you, so I'm asking you to state your name.
Your witness, yes.
Sir, you are in contempt of court. That's a $100 fine. Speak again when it's not your turn, and I'll continue to up the ante. Clear? You can speak now. I've asked you a question.
I object.
I don't give a shit if you object. Is it clear what I said? I'm waiting for an answer.
I said I object. What am I supposed to say?
I want to know if you understand you've just been fined $100 for contempt.
I don't understand.
Okay, well, you still owe me $100. Are you going to give me your name?
No, you still will.
That's fine. Thank you. Witness.
Your Honor, the people called Officer Steppen. Oh, I'm sorry. One last quick preliminary matter. Pursuant to 76611B, we'd like to introduce a certified registered of action in regard to this individual being a previously convicted felon.
I object.
Hold on. Have you showed that to him?
I object. I object.
What's your objection, Mr. Michaud?
My objection is that I am here under the guise of
Bless you.
probable cause conference. And I don't know how we're here at a preliminary exam when I did not waive any right to waive a probable cause.
This is a preliminary exam.
This is, okay, so right here.
This is the probable cause hearing.
It says.
All right, stop. Right now, the question on the table is, you've objected to admittance of that document. I want to know what your legal objection is.
I'm also objecting.
What is your legal objection?
To not waiving my probable cause hearing.
Denied. That's admitted.
Under what grounds am I denied not?
Because you didn't give me a valid objection.
I object.
You can't just object. You got to explain with the valid objections to the
I
evidence.
object that we are having a preliminary exam when I haven't had a probable cause hearing and that I did not.
They're the same thing, Mr.
It's
Michaud.
still, on this.
Mr. Michaud, they're the same thing.
But it's still, I have a right to a probable cause. Am I right or wrong?
Sure, try.
Am I right? Do I have a right to a probable cause?
That's what today is scheduled for.
But today it says preliminary exam. Right here it says probable cause conference. And today is a different date that says a preliminary.
Have you ever had a grilled cheese?
If it was different.
Have you ever had a grilled cheese?
If it was different, why would it have two?
Have you ever had a grilled cheese?
I object to any of that. Why would it have two separate columns?
Take him out.
Why would it have two separate columns?
I'm not playing this game with him today. If you think you can get him to shut up long enough so we can have our hearing, we'll do it. But I'm not going to let him try to run my courtroom.
Okay, I'll just be very brief in my one attempt here. I would like to try to explain what I understand Mr. Michaud's objection to be, and what I have also represented to him regarding that objection. Mr. Michaud, I think the court record will reflect, had a probable cause conference first on November 29th, and then again on December 20th. I have disclosed, I mean, I think I've been very transparent with Mr. Michaud that probable cause conference is a bit of a misleading name because probable cause conference under the court rules does not require that probable cause be established.
Right.
At the second probable cause conference, Mr. Michaud was caring for a sick relative, so he wasn't able to attend that probable cause conference scheduled December 20th.
Which didn't hurt him at all.
Right. I represented him on that day, and I asked the court to waive his appearance so that he could remain with his family.
Which we
I
did.
understood to be his wishes. I may now understand differently that I misrepresented him in some way, but my goal was just to be able to conduct a probable cause conference where we were going to find out if there was any offer, whether discovery.
You don't have to tell me what they are. I know what they are.
I know, but I'm just trying to.
And I'm trying to explain it to him too, but I'm not going to talk over him.
Right.
And I'm not going to play that crap today.
Right.
So if you want me to explain what's scheduled today versus what was scheduled last time, I'm happy to do that, but you got to be quiet while I'm talking. Clear?
Oh, dude, I hear you.
All right. The last court date that we call a probable cause conference is like a pretrial on a misdemeanor. It gives the parties a chance to discuss the case and see if there's any resolutions prior to the next step. Next step being preliminary exam. At the preliminary exam, the people have to prove to me that there's probable cause to believe that there was a crime and there's reason to believe you were involved. That's what's scheduled today. That is a probable cause hearing. Probable cause conference is just a name that we all came up with instead of saying it's a pretrial for a felony. Do you have any questions based on that?
At what point did I waive it? Because if it's a hearing. or
You
a conference,
didn't
right,
waive it.
so
There's nothing to hold.
Do I have a right to have a probable cause conference?
No.
What?
You can do that right now. Do you want to make a deal with the people?
I want to be able to prepare myself for the probable cause conference.
There's no preparing for a probable cause
It's-
conference.
it's-
It's a conversation.
It still takes preparation.
You want a PCC? Go out in the hallway, have a PCC with the unrepresented defendant.
Judge, just for the record, there will be no offer at this stage.
There's your PCC. Now, do you want to plead guilty? Do you want to have an exam? And at the exam, he's got to prove to me those two things I just said. Probable cause to believe a crime was committed on this date and reason to believe that you were involved. Do you want to have that hearing so he has to prove his case? Or do you want to waive? That's the other option. You can waive the preliminary exam and we'll take the case directly to circuit court level 2 weeks down the road for an arraignment on information, which I would describe as another pretrial on a felony, where you and the prosecutor can discuss the case, see if there are any offers. That's another option. Would you agree with that assessment, Mr. Sullivan?
I would agree, and I would also just add that Mr. Michaud has made his arguments today, he ruled on his arguments, and that he preserves his right to.
He can appeal them.
As you've already said, at circuit court. And so if he wants to sort of move forward on that defense alone, that, the waiver does not preclude him from
not at all
arguing jurisdiction at the circuit court level. But likewise, if he holds a preliminary exam today, holds the people to that burden, he also maintains the right to, continue his objections to jurisdiction, to appeal the court's orders regarding jurisdiction at that next level, at the circuit court level, assuming that the people are able to prove probable cause today.
Now, do you want to have an exam today?
Well, I wanted to address some, I served the court some notices.
I haven't read any of that because you were represented by counsel.
No, I wasn't. I don't have any contract.
As far as I knew, you were represented by counsel.
Okay, so now you know. And I served the court notices. And I would like to.
First notice, what would you like to put me on notice about?
Well, I served you notice that I requested the criminal bonding information. I requested
Criminal what?
bid bond.
Hold on.
I requested the bid bond, the performance bond. I have an affidavit.
There is no bond.
There are bonds. This is
Okay,
a
listen. You can't tell me something and then just disagree with me and think. Listen to me, sir. I am not going to let you interrupt me.
Oh, you just interrupt me.
I'm in charge. I get to do shit you don't get to do. It's part of the black robe. Okay, that's just the way it works. My courtroom, I get to decide how it's run. There are no bonds required for me to do what's scheduled today. I've been doing this 25 years. I've never had a bond.
You have a bond.
Okay, I have a bond.
Everyone
I
here
don't-
has a bond.
Not in any definition I know. So let's get to the point. Do you want an exam today?
No, I really want to address, okay, so.
I'm not addressing any of that crap you
Can
got in
you-
front of you.
Well, since you say you don't have a bond, can you express that in a via affidavit so I can have a?
It's on the record. Order a transcript. I'm not signing anything for you.
Okay. Also, I want to also address that. I sent a affidavit of fee schedule for violation of any of my rights.
There are no fee schedules.
Well, I gave you notice and.
Great, then you gave me notice. Doesn't change anything. We still scheduled for an exam today.
Yes, just put it on the record that I served you notice, okay? Also, I served you notice on my power of attorney.
Okay, you
Okay.
said that.
Right, and
Move on.
you haven't responded to that, as well as my indemnity bond, which separates me, and I have a private capacity. I am not the artificial person.
I don't
am not
recognize
a
any of that.
United States citizen. I am
Stop,
actually
hold on,
identified.
stop. You can put on notice what you sent the court if you want to make a record of that. But I'm telling you, I don't recognize any of that stuff you're talking about. I don't recognize that you're not really Frank Michaud. Okay, I understand that's what you're trying to argue, but I don't
Under
recognize that.
Under what law could you represent or you can use, tell me that, not just from what you say, because ignorance of the law is no excuse for you or nobody else. So what you're saying just don't mean nothing. I need to have facts.
Okay, well, it does
Can you
mean, hold
prove
on. It should mean something
Can you
because,
prove it? Please prove it.
can I prove
then.
what?
Prove that I am not that I am the artificial person.
I can prove you're Frank
I have
Michaud.
full faith and credit.
I can prove.
Okay, so.
Hold on, you've
Are
asked
you-
me. I can prove you're Frank Michaud. You know how I can prove that? Because when I called the case and said you either come up here and be Frank Michaud or you leave, you came up here.
And I
You
asked
proved
you
it for
threatened
me.
You threatened me.
But if you're not you, the threat means nothing.
It doesn't mean nothing.
Okay.
But you're still threatening me and you're using it under color of law.
Okay, listen,
And plus
listen
you
to
have,
me. Mr.
you
Michaud,
have, you have
I've
multiple
wasted
officers.
too much time with you. Yes or
Okay.
no?
So.
Sir, don't argue with me. Yes or no? Are we doing a preliminary exam today? Yes or no?
I object. I will address.
Answer the question.
I want to address other issues as well.
You're in contempt of court. Put him in jail.
For what?
For contempt of court.
I'm having.
You can appeal that too. Sentence is 30 days. See you in 30 days.
I object to that. That's
I'm happy to hear your objection.
Due process.
Appeal me. That's why circuit court judges have jobs.
Definitely.
Take him out of here.
Under color of law.
I can give you more than 30 days.
30 days.
I don't think we're gonna use you today.
Thank you.
Have a good day. Be safe.
Thank you.
Good to see you, John.
Property-wise, you want to give to your wife, sir?
Hey, Ryan, let me know what the next one is.
Is this okay that I give this to your wife?
Yeah.
John, ask the wife to come in so he can see his property go to his wife.
Thank you, Judge.
It should be the Jackson.
Ma'am, would you accept some personal property from your husband, please? Thank you, ma'am. Thanks for the attempt, Mr. Sullivan.
Judge, ready for Jackson then?
I'm ready if they are. You got anything else on the docket today? Sure.
That was an extreme amount of patience.
Good try.
I appreciate you, giving him as much latitude as you did.
I just can't let him run things. You know, I'll let him engage me and, you know, I don't mind that, but I just can't let him try to run things.
Yeah. no,
Especially when I got 3 or 4 more exams to do.
Right. Yeah.
The internet is the worst thing in the world for these guys.
It's like, there are, I'm sure, constitutional law scholars that appreciate this level of abstraction, but like, I tried to tell him.
It don't play here.
The court is going to deny your objection, let's allow this to move forward. You know,
And you know
I
what?
thought that maybe you'd allow me to just represent him in the limited capacity of like, I know.
I would have if he would
I've
have.
got a cross prepared. I think that he might have been able to like win this.
And that's the
case.
worst part about all these cases, right?
Yeah.
Because sometimes they've got a chance if they just,
We had a good
Ron White,
argument.
right?
Yeah.
Got a constitutional right to remain silent, just can't do it.
Yeah.
No, I appreciate you trying.
Yeah, thanks, Judge. If the court wants to keep me like, you know, on the, when things are scheduled.
Can we do that? I mean, it seems like he's not antagonistic to you.
Yeah, well, I will notify you.
Yeah. Yeah. You know, if he decides to hire me, I'll be here. Thank you.
Yeah, thank you, Mr. Sullivan. I appreciate it.
Afternoon, Judge.
Are we ready on this one?
Yeah.
Yeah, good. All right, gentlemen, your appearances for Stacy and Dwight Jackson.
You want the prosecutor first, Judge, or?
I don't care who starts, as long as I get all your names. If you guys need a minute,
No, we're ready, Judge.
just give me your names.
Mohammed on behalf of the people, PA 6771.
And good afternoon, Your Honor. Good afternoon to your staff. Edward Martel, P 85051, on behalf of White Jackson, sir, takes the full name of the murder. White Jackson.
Thank you, sir.
And good afternoon, Your Honor, and to your staff. May it please this most honorable court, Mohammed Nasser, P74485, appearing on behalf of this Stacey Jackson, who is standing behind me, ma'am. State your full name for the record.
Thank you, ma'am. What do we got?
Judge, I've had an opportunity to speak to the prosecutor and the officer in charge of this particular matter. Our desire at this point, at least I can speak for Ms. Stacey Jackson, is to waive. There has been, of course, there was no approval from the prosecutor or anything along those lines. The officer in charge has indicated that he has no objection to a dismissal of Ms. Jackson. However, that's nothing for the court here. We'll be waiving. I've spoken to Ms. Jackson. She understands she has a absolute right to a preliminary examination. At the preliminary exam, the burden would be on the prosecutor to show by probable cause standard that a crime was committed. She committed the crime. She knowingly, intelligently, and voluntarily wants to waive the right to a preliminary exam and have this matter bound over to the circuit court for further proceedings. Is that correct, Ms. Jackson? Speak up a little bit. Yes.
All right, so you understand what an exam is all about? Yes? You've gone over your rights and options with counsel, you understand those. And you know that if you waive, I'm gonna send you downtown for your next court date at the circuit court level. And you're doing all this freely and voluntarily?
Yes.
Satisfied, gentlemen?
Yes, Judge, but I would like to say something for the record.
Yeah.
In regards to Mr. Nasser waiving his client, there is no conditional offer in regards to the waiver. There's been no offer by me or anyone at this stage. This is a discussion that happened between Mr. Nasser and the OIC. But just wanted to state that for the record.
And Judge, I don't think I said.
No, you didn't.
No, he clarified, yeah, clarification. Yeah, that's fine. That's fine.
Judge, if I may?
Yeah, go ahead.
Thank you. Likewise, as it relates to my client, White Jackson, has been fully advised of his right to hold a preliminary examination. Certainly has been advised of the burden that the people have. And Judge, in light of the same, Judge is seeking to waive this examination as well today.
Okay, all the same questions. So you've gone over your rights and options?
Yes.
You understand those?
Yes.
You understand the purpose for the exam, the schedule?
Yes.
And you're doing this knowingly and voluntarily to send the case downtown?
Yes.
All right, we all satisfied?
We are.
Okay, all right, so both of you, February 14th, 9 a.m. is your next court date downtown.
So the 14th?
Yes.
14th, Valentine's Day. What a lovely way to spend it.
Absolutely.
All right, so I've got some writing to do in the files and I'm gonna hand them back so you guys can get signatures.
Perfect, Judge.
Yes, Judge.
All right,
Please.
I'm assuming bond is continued.
Yes, Judge. No problem.
No,
Thank you.
All right, give me just a second, folks.
Take your time, Judge. Thank you.
Stacy's file,
Yeah, Coach Judge.
please. No disrespect, man.
And Heather can get them when they're done selling them.
This is just really.
30 days in custody. So just schedule, I guess schedule a PCC after that. Hey, Ken, would you also tell Mr. Sullivan to stick his head in?
Okay.
Oh, yeah.
Yeah. Good luck downtown, people.
Thank you, Judge. Judge, I do have one other matter, the Sixth Street matter. We do have a resolution. I'm waiting on Ms. Sixth Street to come in.
I'm ready.
Thank you, Judge.
Hey, Joe. Never mind, Ken's got it. Just so you know, I just told Heather, let's just put this on a PCC calendar for at least 30 days down the road.
I was wondering if the court would even allow us to continue with the PCC. I mean, I understand that he's serving a 30-day sentence.
Right.
Could we continue the case while he's serving the sentence? So like, could we have a PCC next week or?
Oh, and Zooming?
Yeah. I mean, like treat it as though he's in custody.
On a bond or something.
Yeah.
Yeah, we could do that. We could do that. I think we got to do a PCC at this point.
I think the way that he's, perceiving the situation.
Well, and the other thing is if we do it in the next couple of weeks, you'll get to see another judge and maybe he can just start fresh. I'm not hopeful, but it's possible.
What week do you want? We have.
Any Wednesday, we can do a PCC.
Within the next 4 weeks.
Oh, all right. I'm good. You know, I have to buy me a US HDMI cord.
You need an HDMI code?
Oh, yeah, if you have one, great. Because the prosecution doesn't play.
Hopefully our cord will work.
I will play.
Well, you know what? You gave it to somebody today. Didn't you?
For that, private.
I thought you gave it to somebody today.
I got you.
No, I'm not rushing you. I'm not rushing you.
I can do a PCC next week if.
Next week?
Next week, 8:30?
That should be plenty of time for the jail to get us.
We can do a tutorial on what a PCC is.
Make a note in the file too, because like I said, I'm not hopeful, but it's possible.
We gotta change the name probable cause conference.
Just for these guys?
Well, not just for these guys, because I get the question a lot, you know?
Yeah. Make a suggestion.
Okay.
What do you want me to make note about just the?
I mean, I don't know why we couldn't call it an FPT. Felony pretrial.
Yeah, that's a great.
Why not?
description. Yeah, that's what.
Because it's really what it is.
Yeah.
I don't know how they ever came up with that. Because you're right, it is confusing.
Yeah.
I don't even know if that came from scale. Where'd that come from?
We used to call them in Washington. Okay.
FPTs?
No, PC.
PCCs? Yeah, I think it came out of scale.
Yeah, I think that's across the state.
Remind me, I'll warn her.
Anything else you need me for?
No, thank you very much, once again.
So it'll be on Judge Soon next week.
Okay.
8:30 because he'll be in custody.
Okay.
And the jail's pretty good about getting them quick.
I'll be there.
Good luck.
Maybe you can watch a few other PCCs before we have ours.
Good luck.
Thank you.
Yep, I'm trying to get it. final, Mr. We're gonna go through it. Joe,
don't.
can you ask Michelle or, Marianne if they have them in their course?
Oh, of course.
What do you want?
An HDMI cord from your courtroom.
Didn't somebody?
Where would that be?
In the
I
drawer
know
by
they
your,
use it Monday.
do you have a drawer by your desk?
Yeah, I don't think it's there. Let me go look.
Mullins.
Mullen, his guy had one.
Oh,
His guy told me, he's like, I'm in the HDMI.
oh, Mr. Giroux had one, didn't he? Yeah.
Yeah,
So maybe someone took it
that's who we used it yesterday, the Sona.
Monday.
Monday. Oh,
Try
yeah.
it. Yeah, call
Must
it.
be.
No, I remember
I
that,
can't
but I
think
thought
of
somebody used it
anything.
today.
No, I don't know when he used it.
And Mr. Martell said they had a resolution on Siegfried.
Okay.
Let's tell them I'd like to get that, because I'm assuming that'll be quick. I'd like to get that done before I start the exam on Mr. Eberline, or
All right.
Eberline, I think, Eberline. What?
And then over there and keep.
See if Mr. Riggins needs one, and you think someone took his Monday after the car, would you see if they got one in one? Oh.
No, I don't.
No, I gotta remember warning your boss and apologize. Well, and Mr. Sullivan still hopefully we can get talk to him. So. Thanks.
Yeah, she's just pulling up now, so he said we're going. Okay, she gets up the stairs.
I mean, I guess I can do a PCR with 30 days next week, but that shows that he's serving 3 days. I need something from him, he's serving 30 days. Yeah, he's going to. But his case was never found. Right.
Damn, she's an hour late.
Yeah.
Oh.
I was hoping to get him to see Danielle today.
I'm the same file.
So that's one, right?
It was such another question.
I don't know, Mr. Riggins is pretty tight.
Yeah.
Oh, I think I know.
Can you get me a case number?
Charlotte's no problem. They usually know. It's all out here, it's all here.
Frank Michelle is 20. I was very much
Yeah.
because the guys are reading you.
Well, and that's why I had to like that, because I didn't want to put Sullivan in a situation where he said he gave Sullivan X and the wife didn't get it.
Yeah. Did you guys find out?
She didn't have one. I asked her to see if Marianne did. No, seriously, I've had all kinds of trouble like this with those sockets, but I don't think I've ever had one get physical. I think it's all about the show. Oh, I think he does. I think he believes it. Yeah. No, but I think they convince themselves they've got a legitimate argument.
Wait, they do?
Well, and that's what I said. I'm gonna say, why do I have to buy into their delusion when you don't let me buy into his delusion? Because I could have said, no, you're right, this does.
What's the difference?
Yeah.
They're both delusional.
Thank
I
you.
got facts on
Thank you,
my
Mr. Rogers.
side of both. You know,
You're welcome. I guess they will. Oh, they will, yeah, so much of mine.
Yeah, you gotta send her an email.
Well, I know, we always kept it. You
Yeah.
guys just don't keep it.
And it's probably,
It's in mine, I just had it, she took it and she moved it.
someone probably had a very bottom of the trial
Yes.
case.
Sure.
It's a long day for her.
Oh, I can't imagine. I can't.
Did you tell Muhammad what a great job he did with both those? arguments? But he's gotta be quicker too.
I thought it was kind of funny when Oakley was answering my call. He like looked like,
It
like
doesn't-
they're like bringing him in, like, come on. I will.
It doesn't matter if you object, if it's after the answer's out.
I will. Actually.
Both talking right now.
They're really, really late.
Who's both?
I'm sorry?
Both. Who's the other one? Oh, the
Oh, no,
attorney.
This is her and her counselor.
With Adam Sophie.
For this kind of deal, she should have been here early.
I agree.
I would be. Diet Coke, bubbly
I
Diet
know
Coke.
I know your coworkers.
What?
I see, I don't see that you're on here, so that's.
I thought Sullivan was
He did very good.
really,
Yeah.
I mean, if I was him, I would have just got up and walked up.
Yeah,
Okay, you don't want me, I'm
explaining
going.
what he could.
Good afternoon.
Good
Your appearance for
afternoon,
Ms.
Judge.
Siegfried. Your appearance.
Thank you, Judge. Good afternoon again, Your Honor. Good afternoon to your staff. May it please this most honorable court, Edward Martell, P 85051, on behalf of Amber Siegfried. Ms. Siegfried, please state your full name for the record.
Amber Lynn Siegfried.
Thank you.
And Judge, first and foremost, let me apologize on behalf of my client. I know she's had some transportation issues. Certainly this matter was set for 1 o'clock. So again, we apologize to the court. On the good side, Judge, we do have a resolution.
I see that.
We've reached an agreement for my client to plead to disorderly conduct with an agreement for fines and costs. She is prepared to pay within 1 week. If Your Honor would set it for 2 weeks, that would be more than generous. She's been fully advised of her trial rights, which is the way of the day, and plead guilty to disorderly persons.
Thank you. You've discussed your rights and options with counsel?
Yes.
You understand those rights and options?
Yes, sir.
You understand the possible penalty for the charge? Disorderly conduct charge? Up to $500 plus court, up to $500 fines plus court costs, and up to 93 days in jail,
Yes, sir.
which includes 0 jail.
Okay.
Okay. Understanding all of that, are you pleading guilty freely and voluntarily?
Yes, sir.
Mr. Martell, the incident date was November 16, 22. Can you give me some facts?
On that day and time, you were in the city of Romulus, were you correct?
Yes, sir.
Okay, and on that day and time, you would agree that you exhibited conduct that was disorderly, correct?
Yes, sir.
Judge, we're satisfied.
You satisfied?
Yes, ma'am.
I'll accept that plea, dismiss the original charge. Fines and costs are $600. If you go downstairs at the front counter, you can set up a payment plan, weekly, bi-weekly, monthly payments, whatever
Okay.
works best for you.
Thank you so much.
You're
Judge.
welcome.
Judge, always a
Good to see
pleasure.
you.
Always
Good
a
to see you.
pleasure. Have a great day.
Stay safe.
Have a good day.
You as well,
Thank
man.
Mr. Martell, tell Adam we say hello.
We will.
We love Adam.
Adam is in, Adam Sober, Adam Clements.
So.
So we will.
We love him.
I will let him know. Thank you again.
See what the charge was.
Let me know whenever you push your button, I have to push a button to make it show on the screen.
Okay. Which one?
Defense, all podiums.
That's on the little screen?
Yeah.
Is there any way for me to test this out to see, because I've never done it here? So what do I have to do to get it to work?
Hit desktop on yours and what does my phone say, Judge?
Desktop and then display settings.
Display settings.
but hit all podiums. or
All displays.
Yep, in the middle.
So just so you know, we're gonna do a tutorial.
Yeah.
Show everybody how to use it, and he's gonna put it all out, like step 1, 2, 3, 4, 5.
I meant
To do this stuff, right? Just what you have to do, yeah, like you got a little cheat sheet, it's gonna be on a little piece of paper. Yeah.
Okay. I think it's working, yes. So,
Let me know if you want us to take it down.
oh,
That sounds good.
I
But no, that.
I don't know. I don't know. How would you write on it? Like a stylus or something?
Yeah.
That's news to me. It'd be handy.
When we first wanted, I swore that's what they said.
All right, are we ready on Everline?
Yep.
Appearances, please.
Mohammed on behalf of the people, P86771.
And good afternoon, Your Honor. Good afternoon to your staff, Neighborhood Defender Services by Tim Riggin, P82125, on behalf of Mr. Michael Uberline. Mr. Uberline, can you state your name for the record, please?
Thank you. You can have a seat.
Right.
Just briefly, as a preliminary matter, I provided notice to defense counsel. If the testimony reflects it, I will be moving to add the additional charge of felonious assault.
Okay.
Noted.
Okay. Ma'am, are you a possible witness?
It's my boyfriend's vehicle, and this is the ripple effect because it does affect my household.
No, but were you there at the time it happened?
No, I was not.
An objection if she stays?
No objection, but just for the record,
Yeah.
a mutual order of sequestration. And there is no officers present today that appeared. It's just Mr. Smolinski.
Okay.
And our first witness is Scott Smolinski.
Okay. If you would, Ken.
Yes.
I don't blame you. Been a good week. Sir, come on up front, please. Watch your step right here. It'll trip you up.
Okay.
Raise your right hand. Do you swear affirm tell the truth, the whole truth, nothing but the truth? Yes. Have a seat right there. Sir, if you would, settle in that chair, state your name and spell your last name.
Scott Smolinski, last name Smolinski.
Thank you, sir.
Good afternoon, Mr. Smolinski. Can you please restate your name for the record?
Scott Smolinski.
Mr. Smolinski, I'm going to take you back to the date of January 10, 2024. Were you at the location of 27416 Ecorse Road?
Yes.
Is that located in the city of Romulus, County of Wayne?
Yes.
And what's at that location?
Gas station.
What kind of gas station?
Truck stop.
Okay. And what occurred on that January 10, 2024 date that brings you into court today?
I parked my vehicle in front of the gas station. Went through my wallet, set my phone, my wallet, my money, all my keys on the console of the truck. Ignition keys also. Went inside to get cigarettes done for the night. As I'm in line, I see my dome light on. And a gentleman getting in the truck.
Okay, now this gentleman, what side of the truck was he getting into?
Driver's side,
Driver's side? And you said the keys were still in the vehicle, correct?
yes,
Were they, I'm sorry, and maybe you mentioned this, but where exactly were the keys?
on the council.
On the console.
On
So
the
they,
console.
they weren't in the ignition.
No, they weren't.
Okay, and then the reason that you went out was just because the headlights went on, so it drew your attention?
Objection,
It-
Your
it is-
The dome light.
I withdraw. When you went outside, what if anything did you observe?
When I ran outside, I observed a gentleman in my truck in the driver's seat.
Okay, this gentleman that you observed in the vehicle, do you see this individual in the courtroom today?
Yes,
Can you please point to that individual and point out an article of clothing that individual is wearing?
on a green shirt.
Your Honor, please let the record reflect. Witness
Noted.
head. Thank you. And upon observing this, what, if anything, did you do when you saw this individual in the driver's seat?
I knew that if I could get the door open before the truck was in gear, I was gonna pull him out of my truck.
Okay, and did you attempt to do this?
I attempted to do that. As I grabbed him around the neck to pull him out of the truck, as that happened, he put it in gear and floored it. I was hanging on to the door and to him. As he sped off, he turned right, as hard as he could, turned right and smashed into the gas pump and the pole that holds up the canopy. As that happened, I hit the driver's door, folded it around the truck, and I commenced to rolling across the ground. All I could
And
think
Your Honor,
was,
I think he's testifying in the narrative, but.
It is a little bit of a narrative.
Okay, I can. So after this vehicle hit the pump, what
Yes.
happened to you?
I was thrown across the ground.
Okay, did you sustain any injuries?
Both knees raw, elbow raw.
Okay. Now, this individual that you identified here, did you give him permission to drive this vehicle at any point?
No,
Do you know this individual?
no.
In this vehicle, you said it was a truck, correct?
Silverado.
Do you know how much that car's worth?
15,000 in my mind.
Your Honor, I think that's speculative. If he doesn't know, he doesn't know.
Any response?
Did you purchase that? When did you purchase
I've
it?
had the vehicle for 6 years.
And when you purchased it, how much was it?
It was 5,500 then.
55,000?
100. The truck has totally been gone over. Every body panel has been replaced, custom paint, custom wheels, stereo,
Approximately how much did you spend on that upgrades?
8 grand.
Okay. And when you attempted to get this individual out of the vehicle, did he say or do anything to you?
He tried to swing. His first instinct was, I guess, when I grabbed him, was to swing.
That's speculation.
It is.
Okay. Did he swing?
Yes,
Move on.
Did he make contact with you?
yes,
How many times did he say?
just once.
Did he say anything to you?
Not at that time, he didn't.
What do you mean by not at that time? Was there a different time?
When I drug him out of the truck and commenced trying to hold him there, he kept saying, "I'm cold. I'm cold."
So at some point you got him out of the vehicle?
Yes.
And did he attempt to get back in the vehicle?
No, attempted to walk off.
What did you do when that happened?
I tried to hold him down
Why?
so the cops could come and get him.
All right, no further questions.
Mr. Riggins, your witness?
Yes. Good afternoon, Mr. Walensky.
I do.
Good. I have some questions for you. Now, this is probably going to be a dumb question. You don't know my client, correct?
No.
Never met him before, correct?
Nope.
So you pulled into this. You pulled into the gas station, correct?
Yes.
And you went inside the store.
Yes.
Are you sure you didn't leave your keys in the ignition?
No.
You're not sure, or you
I'm
did not?
sure.
Okay. Yeah, at this point, I'm going to play a video. Yeah, I moved to admit defense exhibit
One.
one. This is going to be a video titled "Incident" from the night at the Marathon gas station. Mr. Walensky, does this look familiar to you?
Yes.
Okay. And what does this look like to you? What is this?
Looks like the gas station.
Okay, going to play the first few seconds. There's a car that comes into frame. Do you see the car?
Yes.
And can you identify this car?
That's my truck.
That's your truck, okay? Now, you just saw yourself get out the car, correct?
Yes.
And you just saw the wipers go up and down, correct?
Yes.
So you took the keys off, out, correct?
Correct.
And you just completely get out the car in one motion, correct?
Mm-hmm.
Just saw the wipers go off again, did you, right?
Yep.
Do your wipers go off and on without the keys being in the car?
No, not.
So it's possible that you did leave your keys in the ignition, correct?
Sure. Yes.
Okay. Oh, I'm sorry. And this is the gentleman you identified as my client getting in the car?
Already passed that up. Yes.
That is, okay. So you see the car pull off, correct?
Yes.
And it's your testimony that he swung at you at some point.
Sure.
Did
Yes.
you see him swing at you in that picture?
Not in that picture, no.
Okay. But you did try to pull him out of the car, correct?
Yes.
So at that point, you're trying to apprehend him, correct?
Yes,
And at that point, he's not swinging at you, correct?
not at that point, no.
At that point, he's telling you, I'm cold, correct?
Yes.
And I have no further questions.
When the individual pulled off when you were hanging on, how did it make you feel?
Scared. Scared. Didn't know what he was gonna do next.
What is it that you feared in that moment?
At that moment right there, before the camper top fell off in the picture, I thought he was gonna back up and run me over.
Nothing further.
But the fact of the matter is, he never did back up, correct?
No, he didn't.
He never did do anything to you, correct?
Sir, you can step down. Watch your step on the ramp. Anything else from the people?
Nothing further from the people.
Any defense witnesses?
No witness.
I'm ready for argument.
Judge, the people moved to bind over on the counts in the complaint, and that's all.
Yeah, no.
And I reserve argument.
Thank you.
As to the unlawful driving away, obviously that is going to be a question of fact. We see that somebody got into a car and attempted to drive away. But Your Honor, there is an added count of carjacking. Carjacking requires that my client forcefully take possession of Mr. Polinsky's car. Now, I think if the video showed, what we have is Mr. Polinsky leaving the keys in his car in the ignition. My client jumped into the car, and Mr. Polinsky, rightfully so, tried to take him out the car. But at that point, he never used any force to take the car. He simply put the car in gear because somebody grabbed him. He tried to drive away, but he didn't attempt to use force to take the car. In fact, at that point, he was already in the car. Your Honor, so I believe that a carjacking charge is at best a stretch. We object to the carjacking charge. I don't think he made any argument to add any other charge. So that's my argument, Your Honor.
Thank you. Mr. Muhammad.
Judge, in regards to count one carjacking, I understand that's the issue. The attorney's bringing up Mr. Riggins. I do think force, the use of force or use of violence, at the very least here is a question of fact. And that would be because, as you can see from the video, it's dark and we can't see inside of the vehicle. The testimony was that there was a punch or some kind of a push at some point by the defendant, which is a use of force or violence. Furthermore, the testimony by the witness was that the car was put into gear and the guy tried to drive off, and he struck the gas, the pump. So the use of violence was used. The testimony was that this individual sustained injuries as a result of the defendant's actions. So at the very least, we do believe a question of fact for the trier of fact exists in regards to the use of force or violence. And so we still move to bind over on the counts in the complaint. Thank you.
No added counts, understood.
Correct.
Anything else, Mr. Riggins?
No, yeah.
All right. I think it's a stretch as well, but I think with the testimony of the punch, that brings in force and violence. I think it's a trier of fact issue. I'm going to send it downtown. Sir, your next court date's going to be next Wednesday at 9 a.m. circuit court level. And I wish you luck. Bond continued?
Yep.
All right. Thank you, gentlemen.
Thank you.
Talk to you. Yeah. Want me to leave the cord here or bring it up?
Yeah, that's fine. We'll get it.
Okay,
Thank you, Mr. Riggins.
no problem.
Have a good evening.
You too.
We're done. What's going on, Jason?
What's on that case?
I saw your son in his uniform yesterday.
Are we having it here?
No, he was in, I went in to Wild Willie's for Taco Tuesday and he was in there for the same reason.
Gotcha.
How's he doing?
Good.
Good.
Not enjoying the report aspect of this job.
The what aspect?
The report, writing reports, but.
Yeah, he knew what he was getting into. He knew what he was getting into though.
Yeah, exactly. So I like the movies where you
All fun and games.
have all the fun and dump it off on somebody else. It's not the other guys? Right, yeah. Right, report.
Stay safe, Jason.
All right, thank you, Your Honor.
I'm shutting down now.